Good morning. My name is Nicholas Mignonelli, and I'm a research librarian at the Lillian Goldman Law Library and a lecturer in legal research at Yale Law School. Thank you so much for being here today for Yale's second Legal Information Symposium, the Legal Treatise, Past, Present, and Future. I'm going to turn it over to Professor Femi Cadmus, the director of the Lillian Goldman Law Library, to welcome us with some remarks.
Good morning.
Good morning.
How's everybody?
Well enough.
Sorry, we don't have sunny, warm weather, but this is typical for us in spring, and our hearts are warm even as we welcome you to this symposium. As Nicholas mentioned, my name is Femi Cadmus, and I'm the director of the Lillian Goldman Library. I'm so pleased on behalf of my colleagues at Yale Law School to welcome you to our second symposium. And what makes this one particularly wonderful is, you will remember we had our first symposium right slap dab in the pandemic. And it was 100% virtual. It was lively, it was fun, but there's something about having real people in the room. So thank you for making this trip to New Haven to join us. And I also want to acknowledge the people who are here with us virtually. So we do have virtual attendees all over the world, in fact. So welcome to a symposium. We wish you were here. So this year's symposium is focusing broadly on the treatise Past, Present, and Future, and we'll be hearing from the 15 authors of the 12 papers selected. Papers selected will appear in a special symposium issue of the Law Library Journal. And in this regard, I really want to thank the former editor of the Law Library Journal, Tom Gaylord, who collaborated with us on this project. The symposium could not have come to fruition without the dedication of the symposium special committee. And I'm going to mention the names of the people who are on that committee. Mike Chirazi, who unfortunately can't be with us in person, University of Miami, Anne Kleinfelter from UNC, Catherine James, Julie Krishnaswamy, and Fred Shapiro of Yale Law School. And I also just really want to give a round of applause to Nicholas Mignonelli. He has been dealing with most of the authors, doing all the arrangements, and he's just been spectacular, just a bundle of energy and vision and commitment. And that's hard to find these days. So I really want to acknowledge him especially. I also want to acknowledge the administrative office in the Lillian Goldman Law Library, Pam Rentz, Shanna Jackson, and our Director of Library Operations, Rachel Gordon. Again, this would not have come to fruition without their dedication. And I want to mention the accompanying exhibit to the symposium. It's on there too. So if you have not done a tour of the law library, if you've not gone around, you want to visit the rare book room, we have a special symposium curated by Catherine James, our rare book librarian, on being on authority and the legal treatise. This is going to be on view through April 12th. So if you're here the weekend, you can still catch it. Are we open this weekend? It's spring break, if you've noticed. So this feels like a ghost town. So having said all of that, I just want to welcome Heather Gerken, who's the Dean and so Lillian Goldman Professor of Law here at Yale Law School. Now, Dean Gerken is traveling, so she is really crushed that she can't be here in person. But what she did was she took time to record a special welcome and a greeting to everybody here. So we're just going to introduce that video. You ready? Yes.
Good morning, everyone. I am just heartbroken not to be with you in person on this wonderful day as you begin this fantastic conference. Alas, the day that you chose for the conference is also the day of the Princeton Board's retreat, which happens once every 5 years, so I'm not able to be with you. But given the importance of the topic and the chance to sing the praises of a beloved colleague, I hope you won't mind my decision just to kind of zoom in to make the introduction. As a legal academic myself, I would be remiss if I failed to start by expressing my gratitude to Yale Law School's dedicated librarians and the many people who do this work to support scholars at other schools. You have all spent your careers doing work that is too often overlooked by practicing lawyers, but never overlooked by scholars. Law librarians are this profession's guardians of quality, are custodians of accuracy, and are stewards of organization. Legal publications, I suspect, are especially taxing to maintain compared to other disciplines. The law is ever changing, and the seriality of legal print sources makes catalyzing legal texts an unending affair. And yet, as law librarians, you take the plethora of disorganized documents and order them into something comprehensible for practitioners and scholars, students and educators, and even the broader public. The entire legal profession, Yale Law School included, depends on your intelligence, your prescience, and your unwavering commitment to accessibility. You catalog for all of us the past, the present, and the future of the profession. And just as librarians bring order and structure to the information underpinning the profession as a whole, the professors and practitioners who pen legal treatises seek to bring a similar level of organization to substantive areas within the law, which is why I just adore the topic that you've chosen for this symposium. Now, to be sure, this work doesn't typically benefit from the glow of the flavor of the day political discourse, and I suspect its contents won't ever headline the Yale Law Journal or Harvard Law Review's newest volumes. But the legal treatise is the backbone of the legal profession. If one were to view the world of law as an unruly wilderness of rules, doctrines, procedures, and principles, the treatise is the legal scholar's effort to tame that wilderness. H.J. Stevenson noted in his preface to one of the very first texts on legal pleading that no previous attempt had ever been made, and I quote, to develop systematically the principles of this science and show their bearing as part of a general system or scheme. Despite this essential function, viewing the treatise as merely a mechanism of order would sell a treatise short. Treatises have served as catalysts in affirming and codifying reforms. Treatises are the maps we all require to set out on our journeys, be they scholarly or practice-based. You could not have chosen a better topic for your symposium, and you certainly could not have chosen a better speaker than John Langbein, Sterling Professor Emeritus of Law and Legal History here at Yale. John is one of our great ones. Treatise writers are, as I just noted, map makers and guides. But because John Langbein combines those skills with the highest level of integrity and an extraordinarily range of scholarly virtues, I think of him not as a map maker or guide, but as an academic's North Star. John Langbein's career is a shining example that any legal academic would be proud to emulate. He began his studies at Columbia University, where he studied economics. He went on to graduate from Harvard Law School and Cambridge University with a degree in English law. Eventually, he earned a PhD from Cambridge, where he won the York Prize for a brilliant thesis on criminal law, which has been cited on several occasions by the United States Supreme Court. Just imagine that. As soon as he finished pursuing degrees of his own, he put his passion for teaching and scholarship into practice and became an exemplary law professor who has always balanced teaching and mentoring with publishing groundbreaking work. John began his career as an instructor in 1971, joining the University of Chicago's faculty for almost 20 years, where he'd eventually serve as the Max Pam Professor of American and Foreign Law. And in 1989, lucky for us, John joined Yale Law School as a Chancellor Kent Professor of Law and Legal History. He would go on to earn a Sterling Professorship, the highest ranking appointment in the entire university. And prior to his retirement, John has held an enormous range of academic appointments, including those at Stanford, Oxford, NYU, and the Max Planck Institutes in Germany. Finally, in addition to serving as Professor Emeritus at Yale, John is an honorary fellow of Trinity College, Cambridge. Now, these impressive titles are, as you know, merely a stand-in for a body of scholarly work that is impossible to match. John is a scholar and a treatise writer. He has been a force in promulgating legal reforms across the country. His work has covered an enormous range of topics, from probate and trust law to pension and employment benefit law, from legal history to modern comparative law. All of it provides a touchstone for generations to come. John is also known for his own extraordinary integrity and his personal virtues. For all these reasons, I'm not just honored that I call him a colleague, I am in awe that I call him a colleague. So with that, I want to wish you the best of luck in this wonderful symposium, and again, to introduce the extraordinary John Langbein.
Well, thank you so much for your patience. This morning, it's my honor to introduce our keynote speaker, John H. Langbein. John H. Langbein is Sterling Professor Emeritus of Law and Legal History at Yale Law School. He's an eminent legal historian and a leading authority on trust, probate, pension, and investment law. He teaches and writes in the fields of Anglo-American and European legal history, modern comparative law, trust and estate law, and pension and employee benefit law, ERISA. In 1987, he was elected to the American Academy of Arts and Sciences. In 2000, the American Society for Legal History awarded him the Sutherland Prize for his pioneering work in legal history. In 2006, his book, The Origins of Adversary Criminal Trial, received the Coit Biennial Book Award as the Outstanding American Book on Law. In 2009, he published History of the Common Law, The Development of Anglo-American Legal Institutions with Renee Lerner and Bruce Smith, a textbook on the history of the legal system. He is an honorary fellow of Trinity Hall, Cambridge, and a corresponding fellow of the British Academy. He's admitted to the bar in Florida in the District of Columbia, and as a barrister of the Inner Temple in England. Thank you so much for being with us today, Professor Langbein.
Thank you. Welcome, everybody. Whenever I have a chance to speak in something that's been organized by the law library, I always try to express my gratitude for the great library that we have here. It is one of the great blessings for our students and for faculty is the enormous depth of this collection and the sophistication and devotion of the librarians who keep it up. Yeah, it's just a wonderful blessing. I'm going to address you on the topic that I have called the rise and fall of legal academic treatise writing in the United States. I want to discuss really two questions. One is why treatise writing became such a prominent activity in the leading American law schools in the 19th and early 20th centuries, and then why treatise writing has effectively disappeared from those institutions where it was concentrated over the last generation or so. Those of you who know anything about the scholarship on these questions will recognize that my lecture title is a play on the title of a great article about the subject published in the University of Chicago Law Review in 1981 by the late Brian Simpson. Brian was an Englishman, moved to the US well into his career, spent some time at the University of Chicago when I was there, and then settled down at the University of Michigan for quite some time. He was a dear friend of mine. In this lecture, I'm going to be voicing some differences from positions that Brian developed, but I want right at the outset to emphasize my admiration and gratitude for his enduringly important work on this subject. Let's start by asking what we mean by a treatise. Say that word to me, and the prototypes that come to my mind are the multi-volume mega treatises, they've been called, that emerged in the early decades of the 20th century. I'm thinking in particular of Wigmore on evidence, which for me, of all the great treatises of that period, has been the most valuable, but also Williston on contract, Scott on trusts, Powell on property, and so on. These works were comprehensive. The ambition was to state the rules of an entire field of law, and to do it in a level of detail that reflected the availability of the relevant sources. These treatise writers, all of them academics at major shops, systematized and often theorized the rules of these fields of law. Their books were reference works. These books would expose the reader to the nomenclature of the field and to the authorities, typically case law and then increasingly legislation. The rules were generalized from those sources. That was the work of the treatise writer, to generalize, organize, systematize, generalize. The treatises also served an updating function by means of pocket parts that were issued sometimes even quarterly, but often on an annual basis, and also by being revised fairly frequently. I should say that I do not much understand the difference between what we call a treatise and what is sometimes called a textbook, or in West Publishing Company terms, a horn book. I just don't quite have in mind a conceptual distinction that works. Other than size, Wigmore or try carrying all of Williston around, and it's a chore. But that can't be dispositive. A one-volume work such as Prosser on tort or Bitker on taxation, it functions the way the big mega treatises did. It's simply a thinner set of sources being canvassed. Let me return to Simpson's great article from 1981. His main theme is that the treatise was a prevailingly 19th century genre. It developed primarily on account of the emergence, says Simpson, of university legal education in the United States. Alone of all the central institutions of Anglo-American law, the legal profession, the courts, the adversary system, the jury system, all of that stuff, it all comes from England. There's only one central institution of our legal system, which is American to start with, and that's the university law school. In England, legal education, such as it was pursued at the Inns of Court for a time. They largely gave it up in the First Revolution in the 1640s, and didn't get back into the business until very late 19th century. And even then, when they got in it, they did it badly. The Americans establish university legal education, and they did it in a fascinating way. They started with proprietary law schools. The great Yale Law School began as a program launched by a guy named Staples, who was a practicing lawyer here in town, who had a substantial personal library of English works. There was no American legal publishing to speak of until basically the late 1780s, mostly coming out of Philadelphia and mostly just reprinting, sometimes with additional American supplementation, reproducing the English works. There simply was no indigenous legal literature, and legal literature was extraordinarily expensive because it had to come from England, and the whole process of producing it was expensive and was about to undergo huge changes and efficiencies as we get into the 19th century. So what you have is a world in which people who want to study law do it basically in one way, which is apprenticeship. You went and hired yourself out to a local lawyer. He was meant to give you some instruction. His instruction typically took the form of whatever was in his inbox, and that's not a good curricular design if you're trying to understand the basics, but that's what they did. And it took a while, but this pattern developed that you would apprentice yourself to a lawyer. The lawyers in that area would have a cartel in effect about whom they would recommend to the local court to become authorized as lawyers. And so there was something like what we have now, which is training, although lousy, and an accrediting process for what we would call today admission to the bar. One of the fascinating things about legal education is that it has a dual mirror image function. It opens the profession to newcomers. It also excludes, because it has at some point criteria, and if applicants don't make it, goodbye. So in any event, the important thing to understand is that the Americans enter the period of American independence with virtually no indigenous legal literature. They produce, they begin to produce volumes which were really directed to laypersons who would have responsibilities in the legal system, persons who would serve as justices of the peace or constables, or there's literature for jury persons, things of that sort. But that's not legal professional stuff, although it was, particularly the JP manuals were very, very important. So where are we? We're in the early 19th century, we're in a legal system which has set itself free from the English, but is completely dependent still on English sources. That ultimately affects the theory that comes through in the American treatises when they get going, Story and later. The theory of an English treatise is, Her Majesty's courts have said the following: these cases and these statutes are it. And what I'm going to do as a treatise writer is put them in a decent order for you and try also to abstract the main categories and principles. That's what I'm going to do. I'm going to tell you what the authorities allow me to say. Across the Atlantic, come deal with the Americans who, guess what, have just had a revolution in which they very much don't want to have to rely on English authority. and they will need a different explanation for what they're doing. And that explanation, Simpson, by the way, develops this wonderfully in the great paper at Chicago Review. That step that the Americans will take is to explain the rules of law that they are explaining, that they're developing. Explain those rules as a matter of legal theory. Much of it natural law type theory. The idea is, I'm not telling you, the treatise writer, you got to do this because Lord Mansfield says so, because Lord Mansfield's just passé. I'm telling you that you need to follow these rules because they're right. And they're right because I say so, but that's not good enough. They're right because I give you a theoretical account of why they're right. So what the Americans do when they get to treatise writing, and it starts with the people at Harvard, Story and Greenleaf. These treatise writers they speak in a different voice, and it's the voice of academics. The special thing about American treatise writing is that it came out of law schools, but the English don't have law schools. They teach Roman canon law, which is a sort of a dream law, which comes down from a couple of millennia of Roman scholars reworking the Roman sources. But it's not in effect in England, except in the church courts and a couple of other places that by the 19th century don't much matter. So we have we have what we call a common Anglo-American tradition in legal literature, but already in the treatise form, the treatise genre, you see a difference in tone, which is hugely important. What does the treatise writer think he's doing? And the answer for the Americans is, I'm theorizing. The answer, much less so in England, is I'm telling you what the authorities say. Oh, and by the way, I also have some thoughts about why that might be right. So the development of the treatise form in the United States takes the form initially of borrowing English treatises. Mostly they came out of Philadelphia and then later Boston. They were works like Gilbert on Evidence or Cruz on Real Property or whatever, these standard practitioner works. And the Americans took them over and adapted them to changes in the authorities arising from American practice. Simpson, in his article, took the position that, as I say, that the treatise was a prevailingly 19th century genre, and also that it developed in this country on account of the emergence of university legal education. Simpson focused on the treatises by Joseph Story, the Supreme Court Justice, who wrote, I think it's a total of 9 treatises in a 2-decade period in the 1830s and 1840s on topics that varied across private law, but also he did a treatise on American constitutional law. He wrote about bailments, he wrote about trusts, et cetera, et cetera. Simpson's emphasis on stories, treatises, is understandable as exemplifying the influence of the universities, the academics on treatise writing. Treatise writing became law professors' game, law professors' business in the course of the 19th century. Simpson emphasized that, but he was, I think, a little bit disingenuous in that he knew better. He knew that treatise writing in England had become quite substantial in the 18th century. And indeed that some treatise writing goes back into the 17th century, a little bit into the 16th century, actually. These systematic summaries of a field of law are found just basically right away as soon as the book is found, as soon as we get publishing. Folks, by the way, those of you who are here who don't know the Yale setup, the Rare Book Library is just across the next block, and there's a Gutenberg Bible on display. Simpson was very much an English common lawyer. His own work, he was a scholar of both property law and contract law. He was not, I think, particularly sensitive to the new fields of American law that arose really in consequence of the New Deal and produced a sort of final burst of treatise writing. I'm thinking of, for example, Louis Laws's treatise on securities regulation, Kenneth Culp Davis on administrative law, the treatises that arose to deal with the Federal Rules of Civil Procedure, which come along in 1938 and revolutionized our concept of what litigation is all about. There's a huge new body of treatise literature in that period, basically from the 40s on. And that's not part of Simpson's account. His account, Simpson's account, was focused on story and on the Harvard Law School, and for the very good reason that Simpson was so acutely aware of how meager the English tradition had been in treatise, in legal education. And what struck Simpson was that if you put the professors in charge of writing these things, you get a different kind of book. You get a more theoretical work. And in his view, that was the crucial development. It was the marriage of treatise, which is an older form in some respects, going back into the 15th, 16th century. It's the marriage of treatise and university legal education with this new type of character, the law professor, a new type of legal professional. That was the development which opened up the great golden age of the treatise writers, which is late 19th and especially into the early 20th century with the so-called mega treatises. In other words, put this as simply that what gave the Americans their primacy in treatise writing was that they had developed this subclass of legal professionals, law professors, who were both able to do this kind of work and inclined to do it. I would add to Simpson's account a couple of other dimensions that bear on the question of why the treatise tradition came to flourish in the 19th century. First, it's important to remember that the treatise was not the only form of legal literature that flourished in that period. The treatise came to prominence just in the period that the American law reporting system was stabilizing. The Americans were quite deficient in developing organized law reporting, case reports. They get 20 years or so into independence, into the 1804, 05, before they kind of figured out. Up until then, across all of the colonies, and then the new states, and both the original 13 and the newer ones, there was, as of 1804, there had been a total of 5 volumes of law reports published. The oldest was Kirby here in Connecticut, 1789. There was a volume in New York, a volume in Pennsylvania, a volume in Virginia. But they are esoteric, unsystematic, and not necessarily very reliable. So the Americans had, in the early phases of getting their legal system up and running, they had flopped on the basic core business of getting the sources to be made accessible. Finally, in 1804, 1805, the 2 American states, New York and Massachusetts, under old boy pressure from Chancellor Kent in New York and Story in Massachusetts, they finally get something organized. And what they get organized is subsidy. They get there are various forms of subsidy. One is in New York, they establish an office of law reporter, and the legislature provides a salary. In Massachusetts, they do it a little differently. They arrange for somebody to be designated as the reporter, but they deal with the problem that nobody particular wants to pay real money for these things. They arrange for subsidy on the purchase side. They order up a big batch of copies. They distribute them to all of the county law libraries, county libraries, basically, and government offices, and that gets you a unit cost, which is much lower and allows the thing to get going. So what happens here is the development of official state reports, and they begin to burgeon. So I said to you, there were only 5 volumes of reports for the whole country for the first couple of decades. Thereafter, that situation changes. Let me just read you some data on this. It's quite fascinating. By 1822, about 140 volumes of American reports, law reports, had been published. in striking contrast to that handful I was just describing. Concern began to arise. Instead of the old complaint about the fact Emeritus don't seem to be able to organize law reporting, you get a different complaint, which is people complaining that, for example, Story in giving a speech in 1821 into the Suffolk County Bar in Boston, he worries, I quote, that the mass of the law accumulating with an almost incredible rapidity, close quote, will submerge us. We won't be able to deal with it. He speaks of, again, I quote, the calamity of being buried alive under the, quote, groaning shelves, close quote, of the law reports. The story continues on. By 1839, there were more than 500 volumes of American reports. By 1882, the number stood at just under 3,000, and so forth. In 1929, the prominent New York lawyer Elihu Root complained that there were, by his count, 1.5 million reported decisions available in reported precedents, and that the increase for the previous year had been 170,000 printed pages. This profusion of law reports led to a concern which was widespread in the bar, that a legal system based on case law sources could become unsustainable. The likely solution, Justice Story and others thought, Story in 1821 said that the only adequate remedy that he could foresee is a gradual movement into statutory form. Codification is what we now call it. And that concern is what led to the creation of the American Law Institute and their restatements. The effort to try to generalize what that mass of case law had done. That it's not only the ALI, which is founded in the 1820s, I think they're celebrating what they call their 100th anniversary this year. The Uniform Law Commission is also a response to this sense of catastrophic conditions in the flow of material. So just why am I on the subject? Answer, because the 19th century is not only about the rise of law schools, it's about the rise of law reporting in an immense mass. If I were doing this right, I would talk about the West Publishing Company, a remarkable phenomenon. And it's John West's core principle, of which is you publish everything out there that walks. Don't use any kind of judgment. Don't. If somebody called a judge in an appellate court has said it, I publish it. And that, of course, produces more of this concern. So part of what the 19th century does is it produces an appellate tradition. We get the organized appellate courts. it produces a flood of appellate decisions, and it results in a law reporting system which makes available for treatise writers this abundance of authority. That is the interconnection between these two great movements is, I think, important to see as a kind of joint cause. Another development in the 19th century that facilitated the rise of the treatise and law reporting is the set of technological changes in the, might call it the publishing industry or the printing industry. It made it a lot cheaper to publish books and to distribute them. Rapid changes occurred in paper manufacturing, especially the shift away from rag-based paper content to papers that were entirely pulp. And in order to get pulp to hold together for printing, you need to treat it chemically. And so a whole industry of sub-industry of the chemical industry developed, focusing on different formulas, mostly of sulfuric acid. Those of you in the preservation end of your libraries know what that led to. Nobody thought about it at the time, but it turned out that if you put a lot of sulfur in your paper, it's not going to survive very long. And so we have all these 19th, early 20th century books that are falling apart. But nevertheless, at the time, people weren't thinking about that. They weren't worried about it. They were instead focusing on getting the price down and making it ever cheaper to produce books. So that is another branch of the story of why, as Simpson says, the treatise is a 19th century genre. If you focus on the technology, there are enormous changes that I don't want to bother you with because I don't understand them. I'm talking about changes in printing press technology, things of that sort. Also, the development of the rail network and the post office system greatly reduced the cost of shipping this stuff around the country. And therefore, you had a whole series of economic changes that supported the development of the treatise tradition. I've told you that I mean to tell a rise and fall story, so let me just get to the fall of the treatise. If you had walked the halls of the Yale Law School in the middle years of the 20th century, you would have found a flock of treatise writers in the offices up here. Notable for their number, particularly as a fraction of the much smaller total faculty size of the time. Think of them all: Borchardt on declaratory judgments, Gilmore on security interests in personal property, or Spitker on taxation, Gilmore and Black on admiralty, Moore on civil procedure, Moore on bankruptcy. This stuff is just being churned out of here. That's what law professors did. Walk up in those halls today and try to find a treatise writer. You can't do it. There's not a single person on the Yale Law faculty who's writing a treatise. There are a couple still left at Harvard who are keeping up older treatises, but it's basically a defunct tradition. Question is why? I have a few answers to suggest. The most important by far is one that Simpson pointed to. He said, remember, you're talking about law professors. And if you look closely, law professors began to suffer a funny disease in the 1930s called legal realism. They began to develop a hostility toward legal doctrine. They began to doubt the enterprise of collecting judicial decisions, generalizing about legal rules, and purporting to follow those rules. If your view of legal rules is that they are essentially smokescreens, that they are a pack of lies behind which judges can do whatever they want. If you take that approach to the theory of legal rules, of legal doctrine, it's not going to be a very attractive career to sit up there in one of those offices writing about these false justifications that we have to pretend we're following. In other words, if, as somebody said to Laura Kalman, she quotes it in her book on legal realism, we are all legal realists now. If that's true, meaning if that we all think that the rules are bull, then it's not all that interesting a career to spend your time as a curator of these excuses. Simpson has a wonderful passage at the end of his paper in Chicago, which he quotes Lawrence Friedman of Stanford, who's still going. Simpson has a scathing attack on the people who would be so foolish as to actually believe that legal rules matter. I can't get into the history of legal realism and its causes and flaws and so forth, but I think it is important just to make sure everybody understands what was so destructive about it. Legal realism was essentially a destructive movement in legal theory. It told you what was wrong, according to the realists, with the legal tradition, especially the rules of decision, but it had no answer, no positive account of what law was or ought to be, how it ought to work. There were ultimately in recent times, there were efforts to supply positive account of this sort. Good example is law and economics. There, the idea is microeconomics, the supply-demand equilibration, is really what's going on in most legal decision making. There's a kind of a Marxist version of that, which is the critical legal studies stuff, where it's all a big plot by the plutocrats to confuse the underlings. But these aren't serious long-term solution. Law and economics has been hugely successful in natural marketplace areas, antitrust, bankruptcy, contract, in a number of these areas. But as soon as the law and economics crowd starts to become colonialists and reach out to try to conquer new territory, they run into trouble, and you get nonsense like Posner's baby selling and the economics of rape and all that stuff. So what we wound up with was a vibrant legal system lacking a theory of what it was doing. That's where we are right now. And the result is one which it is very hard to write a treatise about. Simpson had some other things to say about the decline of the treatise tradition. I want to just point to two factors. One is the academicization of law. Once the Langdell theory of what law is, namely the perfect private law solutions that would emerge if you were smart enough, once that passed, the substitute, which was Ames at Harvard, was what we do in law school is teach tricks. We teach you how, quote, to think like a lawyer. As a result, you don't need to know anything to be a law professor. I was hired when I first started in the law teaching world. I was hired to teach criminal law. I have never taught criminal law. The reason is that some months after I was hired to teach criminal law, the dean of the Chicago Law School called me up and said, "Hey, Langbein, congratulations. You're our new trust and estates teacher." Langbein to dean. What's a trust? Dean to Langbein. You got several months. By the time you get here, you can work it out. You weren't expected to know anything. Teaching was mastering a bag of tricks. A lot of it centered on things like dictum and holding and the how can I put it, the relationship of substance to procedure. That's what law school was meant to be about. Well, in that sort of world, law professors didn't have much interest in theory because they regarded it all as kind of BS. That changed. My favorite example is if you take a look at the Yale Law Journal for 1967, you will find that there are in 3 separate issues of the journal, there's a 3-part article on the law of federal tax liens. If you wanted to publish an article in 3 parts on federal tax liens today, you would have to start your own law review and pay for it. Nobody cares anymore. Read the Yale Law Journal. I mean, I defy you to read the Law Journal, but it's illegible. But make a good faith effort at reading current issues of the Yale Law Journal, and you will find that it is no longer addressed to bench and bar. The audience to which these journals and to which the law professoriate is now oriented has changed. It used to be service to bench and bar. Help the judges get the right results. Help the lawyers make effective arguments. That's gone. Today, the audience is other people like us, academics. We're writing for the academy. There's been this vast, the Germans call it a Verwissenschaftlichung, a scientificization of the field, that there's ever more interest in what the scholars are interested in, but it's moved away from the effort to guide people about the law. So, yes, who wants to write a treatise about legal doctrine in a world in which everybody's a realist and nobody cares about doctrine? And that's where we are. And that is by far the most important reason for the decline of treatise writing. I think there was one other thing that I would say, which is that over this last generation, there has been a huge shift in the content of law school curricula away from private law subjects and toward public law. The enormous emphasis on constitutional law, administrative law, and related fields that you find now is quite recent, and it also is taking people away from the field of treatise writing. If you are not interested in the core fields of private law, you're not likely to be doing treatise writing. So there we are. We have a decadent treatise writing tradition. It is completely gone from the elite end of the law school world. It's pretty far gone everywhere in the law school world. Practitioners are now back to writing treatises the way they did in the 18th century. But the great cycle has run its course, and we no longer have that culture of treatise writing that was so central to the development of American law and American legal education. Thank you. Please.
We have about 10 minutes for questions, so I'll start with you, Professor Stern.
So thanks for a wonderful talk. I wonder, though you focused on the US, I wonder whether the explanation that you give has some explanatory force with respect to, say, England and Canada as well, where I believe it would be correct to say that the treatise writing tradition has also diminished very significantly. So one might think that many of the things that you've said are particularly American. For example, where I teach in Canada, they sort of laugh and claim that the realism never happened. So one might therefore think that at least some of the things that you said wouldn't apply there. So let me offer a speculation and see if you agree with it. Namely that although the realism never happened there in Canada and England, possibly many of the things that you've said, well, let me just offer one other difference, namely that there's an extraordinary worship of the private law as real subjects in Canada and I believe England as well. So those are two reasons why you might think that the treatise writing tradition would remain strong. I wonder whether, nevertheless, the extraordinary power of the developments that you describe have made Canadians and English law professors somewhat embarrassed about the project of treatise writing in ways that can't be fully acknowledged, but that are effects of precisely the attitudes and perceptions that you've described and detailed with such great force. So in other words, perhaps by some sort of indirect effect, it's made law professors in those other countries more shamefaced about the project of writing a treatise along the lines of the early 20th century.
Far be it from me to speculate about the Canadians. I do think that it is important to understand that these classical common law fields are already the subject of important and serviceable treatises. So that another factor, if I was going to make a longer list of the factors that bear on the decline of the treatise, certainly another of importance is simply that the early treatises were transitory. They were first on the block, and they did the job. And you can argue, therefore, that by the time there's been a Williston to get the rules down like this, and a Corbett to say, hold off, a lot of that is nonsense. Once you have those two schools who produced their treatises, who's going to do what? Well, it turns out both those guys and everybody in that world neglected restitution, unjust enrichment. And so we had to have that done in the much later period. But so there's still some private law treatise writing that needs to be done. But it was basically a transitional form from nothing to something. And I'm not particularly surprised that they don't keep doing it again. What that leaves me to explain, and I can't, is why it is that in the world's most sophisticated legal system, Germany, they're still writing away with these treatises. They keep them up, they revise them. New youngsters come on, spend their career updating them. There's part of that is that legal realism never hit there. These people have the sense that legal doctrine really matters. You can learn from all those people who went before, and a little bit of humility and some knowledge will help you deal with problems that arise recurrently. It feels like contract and property and so on. I have never seen a satisfactory account of why legal realism was so much more destructive in the United States than anywhere else. Everybody else's legal system has dabbles of this. The French have this guy, Genet. The Germans have the Interesse in jurisprudence. I mean, you get a little of it. But the system doesn't pay these guys any attention. They know better. They understand the simple core insight, which is that you really can learn from what people have done before. And that's really all that a legal doctrinal system is. Now, the English make a huge blunder, which is that they get the idea that if you're going to have a system of precedent, guess what? You have to have strict stare decisis, and once you make a mistake, you live with it forever. They don't get rid of that until, I think it's 1960, 5 is when the Court of Appeals issues its practice statement saying basically, we give up. But I've never seen a comparative work on legal realism.
Yes, my name is Paul. Thank you for honoring.
My name is Paul. Thank you for honoring us with speaking to what I've learned is a noble profession in my years of service with it. One of the factors mentioned by Simpson was technology. That in addition to realism, the changes in ability to search cases online would be a factor. You also mentioned technology, the ability to distribute treatises because of the railway and collect the materials and the resources and the cost of printing going down. And printing also contributed to having stabilized editions that could be corrected and compared and pinpoint citation, all kinds of things. What do you think today, as we're not only in a digital era of searching, but we're in an era where we are using artificial intelligence, and we have just now the release of Case Text Co-author, which is a version of GPT, which you may have heard of, similar to, but for the legal field. And it's a use of AI to develop texts in the legal field. Complicated, sorry.
I certainly didn't mean to neglect the rise of the electronic services in law reporting and otherwise. They certainly are part of the story of why it's unlikely that the mega treatises are going to come roaring back. It's just too easy to update, to find your way to new authority using the electronic media. I agree completely that it's correct. As you get into things like artificial intelligence and so forth, you're looking at a completely obsolete person, and I'm just delighted that there are people who care about it and are doing stuff about it. There's a wonderful paper by Bob Baring about 10 years ago about the way in which the electronic word search ability changes the theory of what you're looking for, and that you no longer have to have West type categories. Instead, you do word searching and other techniques. And if you want to know what Judge Smith had, if he's ever written about Coca-Cola, it's really easy to find it. And so these changes are occurring in ways that, again, strike at the concept of legal doctrine as bodies of thoughtful, theorized experience.
And then just one last question.
Do you think the treatise tradition will be reborn again?
Would you say that one more time?
Do you think the academic treatise tradition will ever be reborn?
Will
ever be reborn? Will it come back?
I claim no skills as a prognosticator. I didn't think Donald Trump was going to be president of the United States. I'm just bad at foreseeing the future. I am not optimistic about the future of the treatise tradition for many of the reasons that we've talked about today. I think it's a goner from the places that used to cultivate it. And for the reasons that we've been looking at today, I don't think it's coming back. But I'd be happy. I'd be happy about anything that would help restore interest in the integrity of legal doctrine and legal rules. I think the free realist mindset of American lawyers was correct. I think the derision that we've heaped on people who tried to take legal rules seriously has been a big, big mistake. And it means that the legal system that we have is ever less principled.
Let's have one more round of applause for Professor Langbein. Thank you so much. And we're about to start the first panel, and I'm going to hand it over to Professor Femi Cadmus.
Okay, hello everyone, we're back and we're here with panel number 1, historical and comparative perspectives, and this is going to run from 10:45 to 12:15. And the way we're going to do this is that each panelist has 20 minutes to present their paper and discuss it. So we're not going to take questions in between. We're going to save the questions to the end. I'll be keeping the queue. Nicholas will be keeping time so that we don't go over. And for our virtual attendees, you're only able to view and listen. We're sorry, we're not opening the chat room and we can't take questions from you, but we hope you're still engaged with us nonetheless. So I'm going to get started by introducing our panelists. There are 3 of them. I'm going to start with a panelist who's virtual, and that's Michael H. Hoeflich. And the reason that he's given us permission to say this, the reason that he's virtual and not in the room is that he's preparing for knee surgery. So our thoughts are with you as you prepare for this, because we have all our panelists in person and we haven't made exceptions except for a medical condition. So I'm going to go and introduce him first. Michael H. Hoeflich is the John H. and John M. Kane Distinguished Professor of Law at the University of Kansas School of Law. And the title of his paper is Reprinting English Treatises in Antebellum America. And we're keeping the introductions short because you can always read people's bios these days. So if you want to read the full bio, feel free to venture to the University of Kansas Law School websites. But I'll introduce him, and I'm going to introduce, should I introduce other speakers or do it other? You know what, I'll introduce the other speakers before they speak. So I'll just give Professor Hoeflich the floor to present his paper. Thank you so much for joining us. You look very comfortable.
Thank you. I seem to make my movements between my hospital bed and my easy chair. And I appreciate being here, and I very much appreciate hearing John Langbein, my old friend, give a wonderful, wonderful talk. Today, I want to give a very brief discussion of reprinting English legal treatise in Antebellum America. It is part of a larger book that I hope to finish next year. And it is a follow-up to my 2010 or 11 book on legal publishing in America. On the 6th of February, in 1819, John Hall, who was the editor and publisher of the American Law Journal, wrote to Justice Story to seek his aid in getting the Supreme Court's imprimatur on a new publishing project Hall wished to undertake. In the course of his plea to Justice Story, he mentioned how hard it was to convince American publishers to print original legal works by American authors. He said, "Our booksellers will not give copy money while they can invest their money in English works of established reputation." Until the mid-1830s, at the very earliest, reprints of English treatises dominated the American legal market. The state of affairs carried with it significant economic, intellectual, and professional benefits, although it did for a time perhaps make it more difficult to publish American authored text. A number of factors explain why the period from the 1770s until the 1840s was what I'd call the golden age of American reprinting of English legal texts, especially treatises. The first factor, of course, was the Copyright Act of 1790, which granted copyright protection only to American citizens. I need to add also that American tariffs on books were quite heavy, and they made English and other imported books quite expensive. Another factor was the strength and growth of the American printing industry and ancillary activities like paper making, bookmaking, and other book arts. The thousands of print shops spread across the US in the period were always looking for new profitable ventures. Again, the American legal profession was growing in numbers and lawyers needed books. Fourth, a growing number of American lawyers were willing to take on the duty of editing and annotating English legal texts to make them more useful for American lawyers, as well as make them eligible for copyright protection in the US. This process of Americanizing legal texts also served an important jurisprudential function. American lawyers were common lawyers and as such felt a continuity with their British brethren and their legal productions. Reprinted English legal texts with American annotations were in effect a bridge between the legal professions and the legal systems of the two countries. Jessica de Spain has commented that reprinting of English texts in the Antebellum United States helped to create a communion between the two countries. Thus, a law professor at Transylvania Law School, Daniel Mays, could speak of preparing his students both for the courts of America and those at Westminster. An anonymous author in the US Literary Gazette wrote in favor of annotated reprints of English treatises. He said, American editions of English law books, which are greatly increased in value by the additions of notes and references. The extent of the market induces booksellers to republish a commendable desire of improving the jurisprudence of the country and affordable facilities of investigations of the profession has incited its members to a gratuitous contribution to their labors. We hope every future edition of foreign publication contain references to our decisions. Another important factor in the reprinting trade was the overwhelming number of Irish and Scots printers and booksellers who emigrated to the United States in the late 18th century and the beginning of the 19th century. Men like Isaac Riley and Robert Bell were familiar with the success of Irish piracy, and I use that phrase advisedly, of English texts, and saw that with the permission of the 1790 Copyright Act, they could reprint without being legal pirates. If one combines all of these factors, it becomes clear there was a market demand for American reprints of English texts, an industry ripe for this additional source of revenues, particularly as technologies made publishing more efficient. And there were skilled artisans who could produce the product. There are also a number of other aspects of the early 19th century reprinting, legal reprinting business worth mentioning. The two most important factors in determining the success of a reprinted text was the reputation of the author, and to a lesser extent, the editor, and second, the subject of the reprinted text. Both of these factors were market factors. For a bookseller or printer to undertake to publish a legal text, imported or homegrown, was a financially risky endeavor. The costs of printing, marketing, distribution were high. For instance, the cost books of Carrington Lee indicate that to reprint Chitty's pleadings in 1825, in a press run of 1,500, the firm estimated it would cost $4,578, enormous expense, including $200 for an American editor, which is quite a nice little stipend. When one compares this to other books published by the firm, you quickly see that such an investment in a title was quite high. It seems obvious the firm thought there would be a sufficient market for the book. But interestingly, of the 3 volumes planned, they only published the first 2, suggesting perhaps that the third, which was Forms, would not be as profitable. One method adopted to lower the financial risk in publishing these books was to create a syndicate of other publishers to spread the risk, as was done in England. Oftentimes, books were published simultaneously by booksellers in New York, Philadelphia, Boston, and even occasionally Charleston. But of course, to do this also reduced profit potential to the individual publisher. Carrington Lee, for instance, chose to assume the entire financial risk of publishing itself. Why? Because they focused on potential market. Joseph Chitty was one of the most prominent and prolific English text writers of the period. He had a strong transatlantic reputation and few rivals in the field. Further, the text was on pleading, a subject important to all common lawyers. In 1825, the rules of pleading in England and in the US had yet to deviate greatly from each other. So Carey and Lee thought it was worthwhile doing it. And indeed, they also published Chitty's Bills of Exchange, another subject of interest to American lawyers, although in this one, they have the press run to 750. Again, a clear indication of their beliefs about what would sell and how much would sell. The inability of foreign authors to obtain copyright protection in the US was very much a double-edged sword. The last thing an American reprinter of an English legal text wanted was to compete with another American publisher to sell the underlying text in a limited market. We see such competition, for instance, in Joseph Chitty's works. Not only did Carey and Lee reprint Chitty, but also G&C Merriam and some other American publishers. To cope with this potential problem of American domestic competition, American reprint publishers would add sufficient additional material that could be copyrighted as well as add significant value for the reader. Thus, the reputation of the American editor could be nearly as important as that of the English text author. There was also the fact that without the ability to send books by post, advertising and distribution networks became critical to the success of these ventures. Merriam, based in Springfield, Massachusetts, was incredibly aggressive in sending out flyers to lawyers and booksellers across the nation. Carey and Lee constructed a network of booksellers who would sell their books throughout the Northeast and throughout the South. Indeed, some publishers voluntarily paid royalties to English publishers for new text in exchange for early access in sheets sent across the Atlantic on the fastest packet boats available. Indeed, there was a prize given every year for the typographer, the typesetter who could do the fastest typesetting on the ocean. All of these concerns determined whether a publisher decided to reprint, in particular, English text in the US. The result of these market considerations was that publishing any text, including reprinted text, was a risky proposition for an antebellum printer, particularly for those who are not well capitalized. Only one failure could lead to bankruptcy. When one compares the American printing of three important English texts in antebellum America, Blackstone's Commentaries, Edward Cook's Institutes, and William Jones's Treatise on Bailments, one sees the risks that printers took. It's well known, Robert Bell published the first American reprint of Blackstone's Commentaries, although he was not the first to contemplate that, but sold subscriptions prior to going to press from fear there were not going to be enough potential purchasers to make the venture profitable. Much to his surprise and delight, he sold far more copies than he'd hoped. I'd suggest that a large reason for this is that he sold copies not only to lawyers, but also to a wide variety of professionals, soldiers, farmers, and to booksellers in multiple copies in other cities and in other places, including Jamaica, for resale. Bell's success led to other American Blackstone editions. While Blackstone's commentaries were printed frequently in the antebellum United States, some, but not all, of the full works of Edward Cook, another standard English legal author, were not. American publishers reprinted various parts of Cook's institutes in the antebellum period. Isaac Riley in New York and R.H. Small in Philadelphia, among others, undertook American abridged reprints of the first part of the institutes, or the abridged ones thereof. The first volume of Cook's Institutes, of course, was a commentary on Littleton's works on property law, and it was a seminal work on the subject and had relevance in the United States. The further volumes of the Institutes and the multi-volume reports, apparently, were not of much interest to American antebellum publishers. Why? The reports and the full text of other volumes of the Institutes would have been of less interest to the American bar, both because of subject and because of the cost of the multi-volume sets, including heavy tariffs, which were imposed, by the way, by pounds of books, not by any other factor. Sir William Jones's short treatise on bailments, on the other hand, was frequently reprinted in the antebellum United States. It was reprinted multiple times from the 1790s in Boston in 1796, again in Albany in 1806, in Philadelphia in 1804, in Brattleboro, Vermont in 1807, in New York in 1828. Now, these were naked reprints, no American annotations. But again, interestingly, they were not the full works of William Jones, then in 7 volumes, were not reprinted in the United States. And according to an article in Arcturus in 1842, the reason was, one, the tariff was too high, and second, there was a surplus of the books already available in England, and they could be cheaply dumped in the US. But in the case of all 3 books, there are certain common aspects. The authors were well known, and they enjoyed a high reputation in the Americas. Second, the books appealed to more than just lawyers. Printers could expect sales to merchants, politicians, students, at the very least. Third, the subjects of the books were particularly appealing to an American audience. All these characteristics helped to convince American printers and booksellers to invest in their reprinting. For instance, we don't see a lot of reprints of English works on Admiralty. And the reason was Americans were just going, dead out writing books on Admiralty law. We didn't need English Admiralty law. And in fact, the substance of English Admiralty law was not very comfortable for Americans. What about the buyers of these reprinted English books? Why would American lawyers purchase these books? Price was certainly a major factor. Publishers didn't have to pay royalties, they didn't have to pay tariffs, they didn't have to undergo the long, perilous, and expensive transportation across the Atlantic. And in fact, Americans generally didn't like to spend money. They were cheap. An article in Arcturus, an early American publication, 1842, on duties on foreign books, stated, in England, the ordinary price of a popular novel is $7.87. Here, the cost of the same work rarely exceeds $1 or $1.50. Turner's Anglo-Saxons cost abroad $13, with us not to exceed $5. Ronca's Pope's $12. Our reprint, $5.50. Campbell's Petrock, $7. Here republished for $2.50. And those London prices are exclusive of duties. Furthermore, the American reprints were more useful because almost always they were published with annotations to American cases. And this made an enormous difference, particularly as Professor Langbein pointed out, since these treatises were in fact compilations and explanations of authorities. Americans wanted American authority. Beyond the pragmatic professional reasons for preferring the transatlantic reprints, there was another reason for American lawyers to buy American printed books. The act of buying an American printed text was an act of ideological and economic patriotism. By purchasing an American printed text, an American lawyer was supporting all the printing-related industries in the new nation, as well as the lawyers who earn money by doing the editorial work. Why support the English export trade when one could support one's countrymen, oftentimes friends of or clients? Why export wealth to a recent enemy? Now, there were some downsides to the American buyer who purchased a reprinted rather than imported text. First of all, they were cheaper, which was good, but they were also more cheaply produced. Let me give you one example. Samuel Warren was an English barrister and an author of works which were extremely popular in both the US and England during the 19th century. He was best known for his triple-decker novel, 10,000 a Year. But 2 of his works, designed for law students, A Popular and Practical Introduction to Law Studies, and his moral, social, and professional duties of attorneys and solicitors, gained a wide readership in both England and the US. The physical differences between the English export and the American reprint that I own are telling. Both are octavo, both are bound in green, embossed publisher's cloth. The import, published by William Blackwood and Sons at London in 1848, is 448 pages. The American reprint, published by Harper and Brothers in 1855, is 306 pages. The text of each is identical. The size of each is identical. How they do this? The answer, of course, is in the type and page layout. The English original has a larger type font and 23 lines per page. The New York reprint has a significantly smaller type and is printed 33 lines per page. Since paper was one of the most expensive aspects of antebellum printing, the use of the smaller font, more complex, and the more compact page layout would have saved Harper an enormous amount of money on paper. Not good for old eyes, I can tell you that. But for an impecunious American law student, that alone would have made the Harper's volume a preferable purchase. Perhaps the most interesting fact about these antebellum American reprints is that based on bookseller, institutional, and personal library catalogs and lists, one American reprints of English texts became available. They tended to dominate the market at the expense of the imported texts. But by the late 1840s, American bookseller catalogs feature current American legal treatises and English legal treatises reprinted in America with annotations, and a few printed in England. These would appear to have been books that had been left in stock, because in point of fact, the American books and the American reprints were clearly taking over the market. I won't go through the list, but if you look, for instance, at the listings of volumes by Joseph Chitty in a Little Brown catalog of 1856, you have 1, 2, 3, 4, 5, 6 issues, and only 2 are English at all. And one had been published 32 years before the catalog, and the other 42 years before the catalog. All the recent titles were American publications. So what I've discussed in this very brief summary may be summed up easily. A combination of market forces, nationalism, and pragmatism led to a thriving business of reprinting and selling English legal treatises in the antebellum US. By the second quarter of the 19th century, annotated American reprints of English treatises and original American treatises were coming to supplant English printed treatises and literally consigning them to the secondhand shelves. I've only briefly touched on the jurisprudential and professional significance of the legal reprint trade in the US. The need for American annotators led to the rise of an American cadre of legates able to master both English and American law. These men, such as Edward Ingraham and Thomas Sargent, were a group of true, but today unrecognized comparative lawyers. To understand the rise of comparative law in the antebellum United States, scholars must study the annotations and annotators in these reprints. Second, the continuing reprinting of English legal treatises in the United States guaranteed that American lawyers would continue to study English as well as American law, leading to the fact that American lawyers were equally competent to practice in the courts of the United States and Westminster, something stated by Daniel Mays in his Transylvania introductory lecture, and exemplified by the fact that Judah Benjamin, fleeing the Confederacy, became an enormous success at the English bar. Of course, the continuing publication of English cases meant that they continue to have great influence amongst both legal scholars and judges and lawyers. It's no accident that Langdell's casebook on contracts depends not upon American, but rather English case law. And so I will end by saying, I hope that those of you who are listening today will recognize there are great historical and bibliographical treasures to be found in studying the printing, publishing, distribution, textual, and technical aspects of antebellum law books. And those of you who might be willing to do this, I am more than happy to be a resource and make my librarian notes available to you gratis and with any and all help I can give. Again, I thank you for letting me be here today visually, and I hope the conference goes well. And I hope it stayed close to 20 minutes.
Thank you very much. That was perfect. You were right on time, Professor Hoeflich. So we're going to hold questions. So if you have questions, we will have those questions at the end. I'm going to move on to the next paper that's going to be discussed. And this is paper presented by Professor Carlton F.W. Larson, who's the Martin Luther King Jr. Professor of Law at UC Davis School of Law. And again, in the interest of brevity, I am not recounting his very impressive background and biography. The title of his paper is Treason and Treatise, English Legal Treatises in the American Revolution and the Early National Period. Over to you.
Right, thank you. Very happy to be here. Huge thanks to the Yale Law Library for sponsoring the picnic and Nicholas for all of his hard work in putting this together. And it was a real treat to hear Professor Langbein have brought back many memories of taking trust in estates from you in this room and history of the common law next door. I'll be talking about the role of English legal treatises in American treason trials during the Revolution and the early national periods. And I'd like to start with one of my favorite stories from the American Revolution, and it involves a man named David Redding, who'd been convicted of treason by a jury of 6 men for aiding the British in the nascent state of Vermont, and his execution date of June 6, 1778 was rapidly approaching. As a 19th century historian recalled the tale, John Burnham, an attorney at law who had recently arrived from Connecticut, with Blackstone's commentaries in his saddlebags, appeared before the Council of Safety and showed them that Redding's conviction had been irregular, inasmuch as no man could be convicted of a capital crime but by the verdict of 12 jurymen. The council was convinced and set aside Redding's conviction and granted him a new trial. There's perhaps no more vivid depiction of the once awesome power of legal treatises than this incident. The Vermonters who accused David Redding of treason for aiding the British could not have been more hostile to the authority of the British king, but they showed no hesitation about accepting the authority of an English legal treatise. To an unlettered observer of this bizarre scene, Burnham might well have been a prophet bearing holy writ. What the book could give, however, it could also take away. And unfortunately for Redding, his reprieve proved short-lived. He was tried and convicted again for treason, this time by a properly constituted jury, and executed. But the execution was now by the book, and the executioners could rest comfortably, knowing that they had fully complied with the rules laid down by Judge Blackstone. The halted execution of David Redding opens a valuable window into the powerful role that legal treatises played in cases of treason during the American Revolution and early national period. In all of these cases, substantive arguments about the law of treason were advanced and debated within a legal framework that was defined and delimited almost entirely by English legal treatises. So let me explain briefly what are the major treatises that were in play. So the first was the third part of the Institutes of the Law of England by Sir Edward Coke, published posthumously in 1644, devoted to criminal law with an emphasis on high treason. Cook's analysis was the first published systematic discussion of the subject, and it proved enormously influential. The next treatise didn't emerge till the early 18th century, and that was William Hawkins's A Treatise of the Pleas of the Crown, published in 1716, and he devoted 13 pages to the subject of high treason. A few years later, in 1736, the great posthumous treatise of Matthew Hale, The History of the Pleas of the Crown, was published, and it quickly became the main authority on English criminal law. Hale devoted over 300 pages of his treatise to the offense of high treason. Hale's mantle would be picked up in 1762 by Sir Michael Foster, who published a volume that included reported cases that he had decided as a judge, as well as 230 pages discussing high treason and homicide. It is by far the most influential treatise on treason ever written. The last significant writer was Sir William Blackstone, whose 4-volume commentaries on the laws of England was deeply influential in the American colonies. Although Blackstone did not break significant ground with respect to the law of treason, his widespread availability made him effectively the last word in many more remote areas, such as the Vermont of the Redding episode, where few extensive law libraries could be found. Okay, so let me just talk briefly about some treason trials during the American Revolution. This was, of course, a great act of treason against the British king, but there were no prosecutions of Americans by British authorities. In a handful of state cases, however, Americans prosecuted other Americans for remaining loyal to George III. And we have some reported cases from Pennsylvania, as well as some manuscripts from judges. And we can look at the citation patterns there, and we see occasional citations to particular cases in English case reports, but the overwhelming number of citations are to English treatises. That is, when interpreting American treason statutes, the overarching legal framework was that of the English treatises. Whatever doubts the revolutionaries had about English government, they did not extend, at least, to the basic framework of English law, which they continued to apply as their own. Now, when we get to the US Constitution, we have the Treason Clause of the Constitution, Article 3, Section 3, which is written using specific English terms of art. So under Article 3, treason is limited to levying war against the United States or adhering to their enemies, giving them aid and comfort. And these are phrases rooted in the 1351 English Statute of Treasons that have been debated by courts and commentators for over 4 centuries. And so when the delegates drafted the Treason Clause, they worked with a baseline of familiarity with English treason law. But that familiarity almost certainly did not come from the discordant mass of English case law. Rather, it was mediated through the great legal treatises. As historian Thomas Slaughter has argued, the commentators most often read by Americans, Hale, Cook, Foster, and Blackstone, were brilliant analysts and quite up to the task of sifting and sculpting past statutes and court decisions into an orderly system that Americans apparently accepted, at least for treason, as an accurate portrayal of English law as it existed at the times the respective treatises were written. The delegates thus wrote the Treason Clause against the backdrop of an understanding of English law that was largely shaped by the treatise writers themselves. Now, several years after the Constitutional Convention, Delegate James Wilson of Pennsylvania, now serving on the United States Supreme Court, delivered a series of law lectures at the College of Philadelphia. Although the lectures were delivered orally, Wilson intended for them to be published, and his written notes contained citations to legal authorities. In his discussion of treason, he relied almost entirely on English legal treatises. For example, when distinguishing levying war from rioting, Wilson cited to Hale's treatise. For a point about the crime of adhering to the enemy, Wilson cited Foster, Hawkins, and Blackstone. All told, Wilson's discussion of the Treason Clause of the Constitution included 8 citations to Foster, 4 each to Hale and Blackstone, 2 to Hawkins, and 1 to Cook. When discussing the US Constitution, it was thus, for Wilson, entirely appropriate to cite, as authorities determinative of its meaning, treatises written 3,000 miles away, and in some cases many decades or even a century earlier. Foster's treatise might not have been explicitly incorporated by reference into the US Constitution, but Wilson's law lectures suggest that it effectively had been. Now, the hopes that the new Constitution would help ensure domestic tranquility proved overly optimistic. Pennsylvanians rising in arms in opposition to federal taxes would soon require federal courts to examine the meaning of the Treason Clause. The Whiskey Rebellion, which erupted in Western Pennsylvania in 1794, led to 10 trials for high treason in Philadelphia in 1795. And the most extensive legal arguments, turning on the phrase levying war, arose in the trial of William Mitchell, where both prosecution and defense attorneys relied on English legal treatises. The court's brief decision, siding with the prosecution, cited only one authority, the treatise of Michael Foster. And Foster's significance had been vividly demonstrated at the earlier trial of Phil Weigel. The jury requested a copy of the Acts of Congress and a copy of Foster's treatise, which the court provided to the jury. And so one imagines the jury pondering the words of the federal treason statute and then turning to Foster, written nearly 30 years earlier in England, to understand the American treason statute. In 1798, violence erupted again in Pennsylvania over federal taxes. A group of over 400 armed men led by John Fries forced the release of tax protesters from federal custody. Fries was brought to trial in Philadelphia on the charge of levying war against the United States. Attorneys for the United States and the defense vigorously debated whether Fries's conduct was legally cognizable as treason. Prosecutor William Rawle argued that it clearly was, stating that an armed rising to prevent the execution of a law of the United States from motives not of a special, but of a general nature, is treason. Now, significantly, Rawle rooted this doctrine not so much in particular adjudications, but on, quote, the particular authority of all the writers on English law, that is, on treatises. And he proceeded to cite the works of Hale, Hawkins, Foster, and Blackstone. The presiding judges agreed. Supreme Court Justice James Iredell, for example, argued that the use of English terms in the Treason Clause indicated that its learned framers certainly at least meant that the English authorities and definition of those terms should be much respected. But the only authority he directly cited was Foster. With respect to a defense argument that treasonous intention must be formed in the same county as the overt act, Iredell responded that he considered Foster's Crown Law as settling that point. That leads to the Aaron Burr trial, where legal treatises probably played their most prominent role. As in the Whiskey Rebellion and the Fries Rebellion cases, the primary issue turned on the meaning of the phrase levying war. Now, since those earlier cases, a new treatise on criminal law had appeared in England. In 1803, Edward Hyde East published a treatise on the pleas of the crown, divided into 2 volumes. And his discussion of high treason would span over 100 pages. Would American judges and lawyers be quite so eager to cite a treatise that was now decidedly foreign law, published 20 years after the conclusion of the Treaty of Paris? The Aaron Burr trials would provide a decisive affirmative answer to that question, with East's treatise joining its older predecessors in shaping the legal debate. The issue first arose on a petition for a writ of habeas corpus filed by 2 of Burr's associates, who argued that their commitment on charges of treason was unlawful. In the only treason matter to reach the United States Supreme Court in the 19th century, the High Court agreed. And the first treatise cited in the oral argument was none other than East's Crown Law. And it was cited for the defendants by none other than Francis Scott Key, a figure not generally remembered for his enthusiastic embrace of British authority. The government, too, would rely on East, as well as on Blackstone, St. George Tucker's edition of Blackstone, and James Wilson's law lectures. Chief Justice Marshall's opinion for the court did not explicitly cite any treatises by name, although he did refer to, quote, some modern treatises on criminal law. Now, it was in the actual trial of Aaron Burr himself where English treatises would be most vividly deployed. The attorneys and Chief Justice Marshall presiding over the case all relied on these treatises to answer the puzzling question of whether Aaron Burr had committed treason. Formally, the question turned on the meaning of levying war against the United States. Could Burr be constitutionally convicted for allegedly organizing men who assembled on Blennerhassett Island in the Ohio River with the intention of ultimately overthrowing the established government in New Orleans? Burr himself was not present on Blennerhassett Island, and so the case raised difficult questions about principal and agent liability and when conspiracies can be said to have ripened into treason. In his opening statement, United States Attorney George Hay referred to English authorities, specifically Foster and East, to argue that the crime may be committed without arms. He claimed that his position on this point was consistent with the English adjudications, again citing Foster and East and adding a citation to Hale. After various prosecution witnesses testified, the defense moved to arrest the evidence until the court issued a definitive ruling on levying of war. Arguments on the motion lasted for several days, and the court's opinion by Chief Justice Marshall was the longest judicial opinion he ever wrote. In support of the motion for the defense, John Wickham noted that Sir Edward Coke and other writers had maintained that in treason there are no accessories, all are principles. But the treatises were wrong, Wickham contended, as no adjudications bear them out on it. Wickham then read from Judge Tucker's treatise on the subject to show how the erroneous doctrine laid down by the elementary writers that in treason all are principles had originated. Responding for the government, Attorney William Wirt contended that the argument that in treason all are principles was fully supported by Coke, Hale, Hawkins, and Foster. It was true, Wickham noted, that Judge Tucker disagreed. But Wirt continued, however sincerely I revere Judge Tucker, when the question is, what is the law of England, it cannot be considered as disrespectful to our learned and virtuous countrymen to prefer the authority of such men as Coke, Hale, Hawkins, and Foster to his. Wirt continued to rely on these authorities for the rest of his argument, including lengthy quotations from Hale and Foster, and an encomium to such a mind as Hale's. The rebuttal argument for the defense was delivered by Luther Martin, who emphasized that English decisions, however entitled to respect, are not binding authority in this country. But he fully embraced English legal treatises, at least when they supported his position. At one point, Martin noted that there is a direct reason stated in Foster, Hale, and Hawkins why the advisor of treason should be specially charged. Shortly thereafter, he noted that Hawkins, Hale, and Foster all declare the reason why an overt act must be stated. Martin then went into a lengthy examination of Hale's treatise, stating, let us see whether anything in Hale justify it. After a long discussion of page 214 of Hale, Martin said, let us now turn to page 238, and provided a similarly extensive analysis of that page. Later in the argument, he read lengthy passages from East and Hawkins. Now, for his part, Chief Justice Marshall, in his opinion, forcefully rejected Wickham's contention that English law was irrelevant. Living war was a term of art and must be understood in English terms. Marshall then proceeded to deliver a full-throated defense of the English legal treatises. Although he agreed that the superior authority of those celebrated, that the superior authority of adjudged cases will never be controverted, those celebrated elementary writers who have stated the principles of the law, whose statements have received the common approbation of legal men, are not to be disregarded. Principles laid down by such writers as Coke, Hale, Foster, and Blackstone are not lightly to be rejected. Those books, Marshall argued, are in the hands of every student. Legal opinions are formed upon them, and those opinions are afterwards carried to the bar, the bench, and the legislature. Unfortunately, however, Marshall found that the treatises did not shed as much light on the matter before the court as is to be wished. The implication nonetheless seems clear. If the treatises had resolved this issue, Marshall would not have hesitated to follow them. He was thus forced to consider the issue as one of first impression, but in doing so, he continued to draw on the treatises for support. With respect to the argument that Judge Tucker should be preferred to the English treatises, Marshall noted that Tucker's volumes are meritorious, but if a spurious doctrine has been introduced into the common law and have for centuries been admitted as genuine, it would require great hardihood in a judge to reject it. He repeatedly praised the treatises, referring at one point to the most approved authorities of that nation from which we have borrowed the term. At another point, he referred to the opinions of the best elementary writers. He praised Foster's valuable treatise on treason. On another point, he said it was sufficient to refer to Hawkins. In an especially telling phrase, he referred to the doctrine of the books. And perhaps most strikingly, he argued, if from reason we pass to authority, we find it laid down by Hale, Foster, and East in the most explicit terms that the conviction of someone who has committed the treason must precede the trial of him who has advised or procured it. So for Chief Justice Marshall, authority in this context was not the decisions of American courts or even the decisions of English courts, but the opinions of the authors of English legal treatises. Now, Marshall ultimately issued an opinion very favorable to Aaron Burr, and the jury effectively entered in a directed verdict of not guilty. Burr's critics faulted Marshall greatly for his ruling, but we should not overlook the role of English legal treatises in this most famous treason case in American history. A former vice president was on trial for his life, prosecuted by the very administration in which he used to serve. The interpretation of the United States Constitution was directly at issue, and the legal framework was provided almost entirely by English legal treatises. Burr may have been aided by Chief Justice Marshall, but he also received substantial assistance from those long-dead writers across the seas, Cook, Hawkins, Hale, Foster, and Blackstone, whose ghostly presence loomed over every step of the trial, their pens continuing to prove as mighty as the sharpest swords. Thank you.
Thank you, Professor Larson. We are going to third and final panelists for panel one, and I'm going to introduce, I don't know if you have a professorial appointment, but I'm going to appoint you one right now. Professor Shawn G. Nevers, who is a senior law librarian and the deputy director at the Howard W. Hunter Library, Brigham Young University, Chair Reuben Clark Law School. And the title of his paper is The Treatise and the Code.
Thank you, Femi. And just want to thank everyone here at Yale Law School, Yale Law Library, especially Nicholas, for organizing this, bringing us all together. I'm excited to learn from so many of you. I'm also really grateful to be here with one of my former co-authors, Julie Graves Krishnaswamy. She's a librarian here, and grateful to be here with her. You know, it was really her, the research that she and I did on an article that we wrote about statutory notes in the United States Code that got me interested in the history of codification and its connection with the history of legal treatises in America. And in this particular paper, I attempt to identify the attributes of 19th century legal treatises that address concerns in the legal system sought to be remedied by the codification movement of the 19th century. Now, in 2023, it's very difficult to imagine the United States being anything but a common law country, but there was a real concerted effort throughout the 19th century to reduce the common law into a code and follow after civil law countries like France. Now, two influences from abroad really kicked off the debate on codification in the United States. First, the French Civil Code was adopted in France in 1804 and shortly thereafter translated into English. And Americans, as well as others abroad, were fascinated by its simplicity and systematic treatment of the law, especially as compared to the messy common law. Often printed in only one volume, the French Civil Code was widely regarded as the first modern code and a model for many nations, including the United States. Second, the English codification advocate, Jeremy Bentham, turned his sights to the United States after failing to gain much traction for codification in his home country. And in 1811, he wrote a letter to President James Madison offering to create a complete body of proposed law in the form of statute law. And over the next few years, Bentham wrote letters to governors of each of the states and 8 letters to the citizens of the United States advocating for codification and offering to produce a code. And while no states accepted his offer, Bentham's ideas of codification began circulating among the states and received widespread attention. Now, while some Americans were discussing codification earlier, the debate became widespread in 1823, exactly 200 years ago, with a speech by William Sampson to the New York Historical Society. Sampson railed against the common law as a mysterious essence and proposed codification as a solution. Now, this address was published in a pamphlet form, and unlike earlier speeches on codification, circulated widely, becoming the source of much discussion in the legal profession. And by the mid-1820s, the debate over codified law was common throughout the United States. Now, throughout the codification debates, there were 2 main views that were prominent. The radical view of codification stemmed from the work of Bentham. He advocated the complete abolition of the common law, which he considered counterfeit law. And he felt like law should not be determined by the whims of judges. And he also detested the common law's legal fictions and technical procedural rules that made it impossible for laymen to understand the law. The moderate view, on the other hand, typified by a speech by Joseph Story in 1821, he was a limited supporter of codification, where some settled points of the common law would be codified. The moderate codifiers saw virtue in the common law's ability to decide cases that were unlikely to be foreseen by codification, and to do so in small steps. Moderate codifiers also allowed for the codification of the law in certain specific areas where the common law was well settled, rather than pushing for codification of the entire law of the United States. Now, while there was much debate about the need for codification during this first wave of codification in the 1820s, 30s, and 40s, there were relatively few concrete codification proposals during this time. Edward Livingston, a follower of Bentham's, had some success with codes in Louisiana in the early 1800s. In 1828, the Revised Statutes of New York was passed, and this revision was considered a codification, although a limited one. The Revised Statutes had codified selected rules of the common law, but the common law could still be consulted for understanding and elaboration. And then in 1836, the governor of Massachusetts appointed commissioners, including Joseph Story, to evaluate the practicality of codifying the common law. But while the commission was in favor of codification in some areas, its support was limited, and the Massachusetts legislature did not attempt codification at the time. Now, many scholars agree that the widespread fervor toward codification had cooled considerably by the early 1840s. And while this first movement toward codification occupied the minds of many lawyers at the time, the codification movement lacked a leader that could focus its efforts. And while it had some successes, they were limited and much more in line with the moderate codification position. Now, not long after the first wave of codification faltered, a second wave began, and this wave had what the first did not, an established leader. And no figure is more tied to the American codification movement than David Dudley Field, who almost single-handedly resuscitated the codification movement and kept it going throughout the second half of the 19th century. In 1846, Field advocated for a general code of the state of New York at New York's Constitutional Convention, which resulted in the Constitution providing for the appointment of commissioners to reform procedure and codify the law. While Field advocated for a general code and the codification of all law, his approach was practical, and he began drafting codes by topic. His first code, the Code of Civil Procedure, would have the most long-lasting impact. Popular because it did away with many of the archaic English technicalities, the completed code was adopted in the state of New York in 1850. Field continued drafting codes from 1847 to 1865 and completed a penal code, a political code, a code of criminal procedure, and a civil code. The civil code included a provision that the common law did not exist where the other 4 or 5 codes were in place. But despite this provision, Field's advocacy in New York steered clear of the radical notion of abandoning the common law altogether. A more moderate approach was necessary during the second wave of codification, and in the end, even that fell short. While many supported Field's codes, they were ultimately rejected in New York after being vetoed by the governor, both in 1879 and 1882. Now, despite the enactment of several of Field's codes in these in other states, Field, did find success in his native. It did not find success in his native New York, but his codes did find success in states that were relatively new to the Union. North and South Dakota, Montana, Idaho, and California all adopted at least some of Field's substantive codes. And with fledgling legal systems, these states were ripe for the adoption of Field's codes. But despite the enactment of several of these codes in these states, the common law did not lose its power, and the code did not become the dominant source of law in any state. In fact, the California and Montana civil codes omitted the provision from Field's civil code abolishing the common law, and the California courts soon adopted the view of John Norton Pomeroy, the first dean of the Hastings College of Law and a treatise writer himself, that the code was a declaration of common law rules and that it should be interpreted using common law precedents. And by the close of the 19th century, very few, if any, radical codifiers remained. Moderate codifiers still had some supporters who hoped for a systematic statement of certain clear areas of the law, which ultimately led to some of the uniform law and restatement movements of the 20th century. But the debate over a complete codification of American law had ended. Now, as we heard some this morning, at roughly the same time that the codification debates began in the United States, the first great era of American legal treatise writing began. And while many American legal treatises existed earlier, most authors point to Kent's Commentaries on American Law, published between 1826 and 1830, as ushering in the treatise tradition in America. The earlier post-revolutionary treatises were written primarily to the non-practicing gentleman lawyer, while treatises beginning with Kent's commentaries were written for practicing lawyers and focused on the scientific or theoretical nature of the law. These post-1820s treatises were also distinguished from earlier American treatises by their high quality, and many were exported to England because of their superiority. Kent's commentaries was soon followed by a number of topic-specific treatises, including 9 separate treatises by Joseph Story in the 1830s and 40s, as well as treatises by Greenleaf and others. And special note must be made of the treatises of Joseph Story, not merely because of their number, but for his influence on the American treatise tradition. Story was appointed to the Dane professorship at Harvard University in 1829, which required him to deliver and then publish a course of lectures on various branches of American law. And in this capacity, he wrote an astounding 9 legal treatises over 16 years, despite also being a U.S. Supreme Court justice and teaching at Harvard. Story's approach was to identify major legal principles in the common law and arrange them in a systematic order. Where principles were difficult to identify, Story often turned to the civil law to fill in gaps, but while civil law was consulted and decided, it was not the primary focus. It did, however, help situate the common law into this legal science and prevent his treatises from becoming merely an index to case law. The main focus of Story's treatises were these principles and the common law that came after them. And this blending of the scientific, systematic treatise of the continent and the practical case-based treatise of England was unique and powerful in a country whose legal system sought both. Now, as the second wave of codification began in this mid to late 1840s, the treatise tradition continued with vigor until the Civil War. While Story had passed away, despite having plans for additional treatises, additional authors such as Rawle, Bishop, and Sedgwick continued the genre. Now, there's some disagreement as to the level of treatise writing that followed the Civil War, but most scholars agree that the treatises of the post-Civil War era of the 19th century were much less influential than those earlier in the century. And one of the reasons for the decline was that lawyers at the end of the 19th century became more and more interested in seeking precedents rather than principles, which was reflected in the types of treatises published and the continued rise of digests. Now, some authors have suggested that legal treatises helped end the codification movement in the 19th century. And while it is difficult to assess exactly which factors led to the downfall of the codification movement in the 19th century, several attributes of 19th century legal treatises addressed problems in the early American legal system that codification was trying to solve. First, legal treatises distilled legal principles from the growing mass of case law. Second, legal treatises provided order through a scientific, systematic organization of legal principles. Third, legal treatises provided some legal unity across the country. And fourth, legal treatises of the early 19th century, particularly those of Kent and Story, helped provide a foundation for an American common law. So first, legal treatises distilled legal principles from the growing mass of case law. At the most basic level, codification proponents hoped that moving from common law to codification would reduce the amount of legal material attorneys had to sift through to determine the law applicable to their situation. The common law, as it was said, was scattered in little bits and pieces among hundreds of case reports and had to be painfully extracted from a jungle of words. Prior to 1804, there had been only 5 volumes of American case reports. As we heard this morning, by 1824, there were close to 200. And by 1839, there would be more than 500. Additionally, judges and attorneys understood that the number of reports was only destined to grow. Of this, Joseph Story said, and we heard this morning as well, the danger indeed seems to be not that we shall hereafter want able reports, but that we shall be overwhelmed with their number and variety. It is impossible not to look without some discouragement upon the ponderous volumes which the next half century will add to the groaning shelves of our jurists. The promise of codification was that it would reduce the law into only a few volumes as the French Code had, diminishing the time spent searching for legal precedents. Thus, a single page of a code, the codifiers argued, would contain in a clear and explicit statement all that the researches of a week or even a month would scarcely justify them in affirming with an unfaltering confidence. Now, legal treatises were well suited to perform this distillation process. Legal treatise authors reduced the mass of cases to rules and principles that simplified the research process for lawyers and judges. It was said of Story, for example, that first and most directly, he wrote in response to the pressing practical needs of working lawyers who had to bring vast quantities of unorganized case and statute law to bear on the novel problems of the age. One author in 1886 wrote that it was quite impossible at this time to ascertain readily what the law is without the aid of elaborate legal treatises which collect the decisions and classify them. And another more recent author noted that most American attorneys embrace the genre of law book with hearty rapture. Now, what law treatises could not do was to eliminate the volume of reports completely, as a true codification would have, since the underlying cases would remain the primary authority. But legal treatises were a positive step in dealing with the mass of case law that continued to be produced in the United States. Now, second, legal treatises provided order through a scientific, systematic organization of legal principles. The common law was known as, at the time, and even maybe now, as a loose, messy, complex system. Field criticized it as full of tumult and disorder and offered codification as the solution. One of the main reasons the American codification movement began was a desire to apply the order and structure of the French Civil Code to American law. Similarly, legal thought at the time was focused on bringing a scientific focus to the law. The codification movement tapped into the law, into the idea that law was to be systematized and categorized in a manner similar to that used by Blackstone to bring it into the realm of a pragmatic science. Thomas Grimke, arguing for codification in South Carolina in 1827, stated that the character of the law would be elevated and dignified with a code, because the law will then exhibit the elements, forms, and arrangements of science. Legal treatises of the early 19th century were ideally suited for the role of providing the scientific systematic structure. A legal treatise, according to a popular definition by Plucknick, begins with a definition of the subject matter and proceeds by logical and systematic stages to cover the whole field. The result is to present the law in a strictly deductive framework, with the implication that in the beginning there were principles, that in the end those principles were found to cover a large multitude of cases deducible from them. Horwitz notes that the rise of the treatise reflected the deep and mystical devotion of 19th century jurists to the proposition that law was a science, and that most of its basic problems could be solved through the intensive application of reason. Blackstone, of course, had attempted to present law as a rational science, and his commentaries had provided organization and structure to the English common law. Kent, Story, and others followed Blackstone's model, Kent in his own American commentaries, and the other authors as they brought rational order to more specific areas of the law. The century's most prolific treatise author, Joseph Story, was an exemplar in the scientific pursuit of the law, and his treatises provided applied legal science akin to that of a code. Treatises and codes were actually known to share similar purposes of setting out general legal principles. And in fact, in several countries, legal treatises similar to Stories were precursors to codes because of their systematic organization of legal principles. Codes were seen as the next logical step in the process of the systematization beyond the discursive treatise. The French Code, for example, was preceded by the treatise work of Pothier, while legal treatises ultimately did not precede codification in the United States. The form of legal treatises was often seen as sufficiently scientific and organized as a code. This may be why code opponents, who were not blind to the common law's faults regarding order and structure, pointed to legal treatises as an adequate substitute for codes. Now, third, legal treatises provided some legal unity across the country. Codification in other countries was often preceded by diversity in local laws. Many codification advocates in the United States hoped that codes would provide a more unified set of laws that would facilitate economic growth. While he worked to bring a code to his home state of New York, David Dudley Field dreamt of a code for the entire country. And while that dream was never achieved, a state-by-state enactment of model codes, such as Field's Code of Civil Procedure, which was adopted in 24 states within the first 25 years of being adopted by New York, or his Civil Code, which was not adopted in New York, but was adapted for use in Western states, showed the potential of codification to unify laws across states. While not mandatory law as a code would be, legal treatises did provide unity in legal thought to the various subjects they treated. Simpson considered the many different jurisdictions of the United States as a potential obstacle to treatise writers because each state would have its own unique law on a particular subject, making it difficult to present a unified common law. But that did not deter treatise writers, however, who attempted to identify the legal principles that would be applicable to all. Because legal treatises of the 19th century were very influential in the legal profession, they helped keep state law developments within similar confines. And while not a perfect substitute for a code, this unifying feature was an important attribute of legal treatises and one sought after by codification. And fourth and finally, legal treatises of the early 19th century, particularly those of Kent and Story, helped provide a foundation for an American common law. At the time they began to write, little had been written about American law, and there were many who were opposed to the United States remaining a common law country. Many did not want to adopt the common law as it came from England, finding that many of the legal fictions of the unwritten law were not fit for the United States. The early treatise writers, particularly Kent and Story, helped develop an American common law that was settled enough to withstand the second, stronger push toward codification after the Civil War. Simpson notes that these early treatise writers wrote in a nationalistic spirit and inevitably stressed the American character of the law they were expounding and the degree to which English common law had been rejected or modified in America. This foundation of American common law allowed the common law time to mature and take root in America. Now, these four attributes of legal treatises addressed many of the problems with the 19th century legal system that codification proponents hoped to remedy. And by providing a somewhat acceptable substitute, among other things, especially during the first wave of codification in the early 1800s, legal treatises played an important role in overcoming the need for codification in the 19th century.
Thank you. So we have a couple of minutes to take questions for the panelists.
For Carlton, were any of your cases state treason cases?
Yes, so the ones in the American Revolution are all state level treason cases. So each state after the Revolution essentially adopted its own treason statute that made loyalty to Great Britain a state crime. The post-revolution ones, Aaron Burr, Whiskey Rebellion, Freeze are all federal. But the possibility of a state treason as an offense is still out there. And so you do see state treason trials arising from the Door Rebellion in the 1840s and John Brown in 1859. And in theory, it's still on the books in many states.
It is mine, I think.
Now, this is kind of for all the panelists. I was wondering if there are any political dimensions as to who would use treatises and who would not, who would more likely rely on English law and who would not. For example, we heard a lot, and you will hear a lot about people relying on Blackstone, but Thomas Jefferson and people like him, Democratic Republicans, were hostile to Blackstone. And I was wondering if there's perhaps any difference between how Democratic Republicans and Federalists would approach treatises in English law, or Whigs or any political parties that came afterwards would approach treatises or English law.
Well, I guess I could say a little bit. So Jefferson was famously hostile to Blackstone, but he at least later in life, after he no longer had to grapple with Cook as a law student, was very enthusiastic about Cook. You do see, I did see sort of a decline in citations to Cook, in the sense that the Federalist judges seem to be less excited in citing him. Now, that may just be that his work is the oldest and sort of there's more stuff that's more relevant. But I did sort of notice a fade away from him. In the sort of, to the extent that the, say, Whiskey Rebellion trials had a little bit of a political valence, it was interesting to me that both sides sort of fully embraced the English legal treatises as the frame of argument. And so they're each saying, we're right based on this passage in this book, and the other side, no, we're right based on this package. And then it's not really till the Freeze's Rebellion case where you see people actually asserting that English authority simply should not be relevant at all. Right, that this is an American treason statute passed by an American Congress implementing an American treason clause, and therefore we shouldn't look to these at all. But you seriously don't see those arguments, in the Revolution itself.
I just wanted to find out if another panelist wanted to respond to that at all. No, we'll go to the next question. Okay.
Thanks. So that observation about Cook and Blackstone prompts a question that maybe touches on all three papers in a way. So Professor Hoeflich, you observed that Cook is much less reprinted in the US than Blackstone. And it's certainly true when the commentaries were first being published in the later 1760s, that you can hear an almost audible sigh of relief among the reviewers who praise it as a perspicuous work. Hint, hint, we no longer have to read Cook. And it's certainly true that anyone who's tried to read Cook in the way that you could imagine people at that time reading Blackstone to learn about the law, the Cook would be something of a headache. So I think on the one hand, that may explain why Cook is so much less reprinted in the US, that indeed editions of the commentaries in England displace reprints of Cook in the later 18th century. So it wouldn't be surprising that you see a similar effect in the early 19th century. So I guess one question that prompts is about the third paper. Do we see among those who are opponents of codification observations about treatises as solving problems? So we don't need to codify because we have them, or a slightly different variant on that. Among those who are writing treatises, maybe a generally anti-codification attitude from which we can infer that at least they believed that the work that they were doing, in a similar way solved the problem. We don't need treatises because I'm sorry, we don't need codification because we have this. And yeah, so as to what you say, Carlton, I wonder if this might also the same phenomenon that Blackstone seems more modern, more legible, etc., might also account for the very observation that you just made about the waning of citations to Cook.
Maybe I'll just jump in. I mean, and talking about Cook, I mean, I remember reading about Story. He has this great passage about talking about Cook on Littleton, reading that and sitting down and weeping for how difficult it was to get through and how that was a formative experience for him. But as far as the codification goes, I mean, those that were against codification certainly pointed to treatises as kind of the less evil of the alternatives, and really were they saw it as a way to get most of what the codifiers wanted without putting it in the hands of the legislatures, which that was one of their big fears, was putting it in the hands of the legislatures. Why do we need to do this? We have treatises that can systematize, can give us what we need, but we don't have to make it law in this way, and we can keep the common law. So that certainly appeared. As for the treatise writers, I mean, it's interesting because and you get some different authors that have different opinions on this. Story certainly early on was in favor of kind of modified codification, this moderate view. Some authors say that really the codification, some of the treatise writing came to stave off kind of this the radical view that so maybe in Story's mind it was, I should write this, or some of the other authors, so that we can kind of get the moderate idea of codification, or we get something there so that the radical codifiers don't get everything of what they want, and at least we have something there. Even if we get some codification, that's okay if we have a legal treatise to kind of keep the common law with us. So you do see that some in Story, but as I've read Story as well, I mean, his motivation does not seem to be, at least from the things that he wrote, that I'm doing this to kind of go directly against codification, but some of those things kind of creep in there over time.
Could you please introduce yourself too, so that a virtual.
Hi.
I think Mike has a response.
Yeah, if I could just add, we also have to recognize that the treatise writers, like Story in particular, are writing treatises which are not state-oriented. They are writing treatises about the common law, which would apparently have been intended, I think were intended, to shape the law in all states. And that's very consistent with Morty Horowitz's notions about the teleological purposes of the treatises. When you go to codification, you're going to the state level. And so there is an inherent conflict between codification, which is going to occur state by state, which might well emphasize differences between states, and treatise writing, which as it shaped itself, was very much national in origin. And one of I think the interesting things to look at is the way that Southerners looked at stories, constitutional and other treatises, where they said, look, hey, that's not us. This the Northern Massachusetts viewpoint. And so they rejected a good deal of story precisely because they saw it as provincial to the North. And so I think we haven't done enough about the sort of national bias of treatise writing in the 1820s through 1850s, and the state orientation of codification. As was said, codification begins to succeed at the state level. It's not a national codification. And to just go back to John Langbein's brilliant talk, ALI, uniform commissioners, are looking to national activity. That's not what David W. Field was doing. Maybe he wanted New York to be a model, but he was focusing on New York. And so I think there is this state versus national common law issue, which is underlying a lot of this. Thanks.
Hi, Professor. I'm Wes Oliver from Duquesne Law School in Pittsburgh, and my question is for Professor Larson. Great presentation, by the way. One of the most striking things you said was that the interpretation of the treatise would be, if it was contrary to what the courts were saying, the treatise won out. How long was that kind of a thing? Like, at what point does the notion of treatise writer superior to judge, can you, any sense of the year when that starts to fade?
Yeah, that's a good question. And I honestly I have no idea. And it really is quite an extraordinary thing, because it seems like in that case, the defense attorney said, hey, there's no cases that support this. And the judge said, well, it doesn't matter, right? Because it's in the treatise. And I suppose the justification for that would be along the lines that to the extent that we're interpreting an act of Congress or the treason clause of the Constitution, all they knew were the treatises at the time it was adopted. They didn't know that it wasn't supported by the actual case law. And therefore, to the extent that that informed how the statute was drafted, I suppose it's plausible to say that should be the interpretation. Now, that's not quite the way Marshall frames it. He doesn't frame it as sort of getting at the intent of the drafters or the legislature. But I think that's at least defensible. If the extent that we're trying to understand a term of art and we assume that the people who wrote it only were familiar with treatises and not with cases. It's such an odd, but it's such an odd argument in many ways. It may be singular to the Burke case. I'm not aware of other instances where it's stated quite so aggressively as that. So I honestly do not have an idea when that might have changed. It's certainly something I can't, it's inconceivable a court now, right, would say anything like that.
Can I add one thing? I honestly think that most of the courts, including the Supreme Court, didn't have all the reports. In fact, they only had a fraction of them. I mean, the 1821 lecture that Story gave, underlying that, I think, is more than simply the notion that, I mean, he actually says no law student can read all of these things. There's also the issue of no lawyer is going to own these and no court is going to own these. I mean, I've read, probably gone through 200 plus catalogs of law libraries, private and institutional. And nobody has the number of reports that were being published, even into the 1820s and 1830s, because they were too hard to get because of transportation and too expensive to get. And until you get a point where they are in fact distributed in a more efficient way, which means after 1851, you can't expect courts to have every single case report that's been published. And they also knew they were unreliable. So it's not surprising that judges would depend upon treatises as opposed to possibly serendipitous collection of reports that they might be able to get access to. I mean, it's just, even the major law libraries don't have all the reporters. They will have the reports from their own state. They will have reports from contiguous states. They might have reports, from New York, and that's about it. I mean, you're not going to find a lot of courts that will have reports that have been published in the South, for instance. They just weren't available. And so I think that's also a factor as to why judges depend upon treatises, where the supposition is the treatise writers actually looked at, all of the sources or more than they have.
Paul Collister focused on Michael and Shawn, or Professor Hoeflich. I think we need to think more systemically about the problem. The problem in the beginning was access to the cases that were there, but rapidly became too many cases. There's just too many published cases. And okay, some of the solutions are the restatements. Some solutions are treatise writers who specialize in digesting all these cases. But the other is the word I just used, the digest. And the relationship to the digest, Shawn, in this period of the late 19th century and early 20th century, to treatises, I think, has to be explored more fully. It's a project I'm working on with a separate group of authors, and more than that, I can't say, but the bar was very interested in what was happening with West and the development of a classification system. And the choice was presented whether to codify or to classify. And so that's part of the story. Treatises are part of the story, but also there was this other dynamic of classification of cases that came from the Abbott brothers, who in the late 1800s spent 2 years reading the best treatises they can find. Well, there must have been something good published in that time, because they spent 2 years reading them, and then came up with their own system for New York, which became then a national system, which was then purchased by West. So I think there's a parallel story, and we've been so focused on treatises that we're not seeing the systemic nature of the solution and the dimensions of the problem that we need to. That's my comment.
Yeah. Let me just talk about that with codification. I think it's very true that the digest played a role. I think especially in the late 1800s. One of the things that as I explored this, and I do have some on the digest in the paper that didn't make it into the presentation, but the digest at the late 1800s, it's interesting when I kind of categorize this in these two waves of codification. The first wave of codification, I think, was the major wave that treatises had an impact on, that they created this alternative, And at the time, the codification movement didn't have a kind of central leader like David Dudley Field. And while digests were kind of coming into their own, they weren't quite what they became in the late 1800s. So in my mind, when we look at the beginning of the codification movement, I think by the time the second codification movement came and the digest kind of picked up that end to kind of create the end of the codification movement, the digest kind of finished it off, whereas the treatise kind of started with that first wave of codification that really helped give 20, 30 years of that common law a chance to take shape, so that when David Dudley Field came along, there was already something there as a good alternative to codification, and then digest, I think, finished that off. So,
Paul, it's really good to hear from you. It's been a long time. I think you're absolutely right. And the only thing I would add is there are some published digests in the antebellum period. But more importantly, I don't think we can forget the manuscript tradition. I've written about, probably ad nauseam, the importance of commonplace books, which are really, the manuscript versions of digests. And every single writer on legal education and every single writer on law practice says that every lawyer should create a commonplace book. And a commonplace book is a digest. And indeed, by the 1830s, we get published, printed blank commonplace books with the front pages are lists of typical topics, and I think that is very, very closely tied to the development of digests later, where in fact a lawyer starting out as an apprentice or as a law student will buy one of these pre-printed commonplace books, and they will just fill in the categories with the cases that they've read. Now, I will also say, relating to my earlier comment, that you mostly find, I'm in the middle of writing a piece about commonplace entries to follow up on other things I've written, that they tend to be place specific. So Massachusetts commonplace books all have stuff on oyster law. But that's what you'd expect. But I think that lawyers are actually creating digests from the treatises and from the reports, going back to the late 18th century. And I think that's an enormously important aspect of legal research, that, for the lawyer who couldn't afford to buy or couldn't get 400 reporters, let alone expensive treatises, what they could do is go to the local law library if they had one, and fill in their commonplace book. Indeed, I have a strong suspicion, John Langbein mentioned, bless him, that, part of the apprenticeship system was you'd find a lawyer with a good library. And one of the reasons why you found a lawyer with a good library is not simply to read the books, but to commonplace them, to use your commonplace notebook to basically get out of that library the references you thought you would need later when you wouldn't have as good a library. So I think you're absolutely right. The digest tradition has been, unfortunately, not focused upon by legal historians in this country.
I think this is it. We're at 12:15. Could we give a round of applause to our panelists?
This is our second panel. Before I turn it over to my colleague, Fred Shapiro, I just want to remind everyone that there is a rare books exhibit on L2, and there is an international legal treatise exhibit on L1. So during the breaks, we invite you to head down and take a look at these wonderful exhibits. And I'm going to turn it over now to my colleague, Fred.
I just want to make a little acknowledgement here. I want to thank Ann Kleinfelter, who is kind of the initiator of what led to this symposium and the symposium that we had 2 years ago. Anne and Mike Chiarazzi of the University of Miami and myself had a talk at an AAL conference about how AAL was not very supportive of scholarship in law librarianship. And this led to our thinking of ways to promote law librarian scholarship and to this symposium. And Teresa Miguel Stearns, our former director, was instrumental in our hosting the first symposium, and Femi Cadmus, our current director, has been instrumental in supporting this symposium. So this panel, the first, I'll introduce the first speaker is John Cannon. He's the faculty scholarship librarian and a legal research instructor at Villanova Law Library. And the title of his paper is Joel Bishop's Reign as King of the Treatise Writers and What It Means for Persuasive Authority.
Thanks, and hopefully everyone can hear me. And thanks for inviting me. It's great to be amongst so many great minds, in the profession, Fred Shapiro and Nick and Kleinfelter and everybody. It's just great to be here and also to read such great papers. Just fantastic stuff. And I'm going to start my talk with an apology because, like most of my writing nowadays, it stems from a rant. So much that one of my students says I basically engage in spite research these days, which, I actually kind of like. But really what I want to talk about is persuasive authority as sort of a vehicle for my research here. And persuasive authority, as we know it, it's basically sources which are not binding, those sources which legal decision makers choose to put in their sources, their material, their opinions, and what have you. And traditionally, we've looked at persuasive authority as just a big mass. And when we try to bring order to that mass, we tend to organize it in the way we would with binding authority, that we try to put it into hierarchies. And for example, we put out of jurisdiction case law at the top. We probably put law reviews somewhere in the middle. And legal encyclopedias, we probably put at the end. And I think Bob Baring said that only a fool cites to a legal encyclopedia, and take that for what it is. And that's kind of how we've dealt with persuasive authority, up to the present day. Well, there have been people that have disturbed this traditional order, or this traditional, I would say benign neglect of persuasive authority. And one of the first people really to launch a disturbance of it was Professor Frederick Schauer down at the University of Virginia. And what he said is, well, we have this phrase, persuasive authority, but it's really an oxymoron, because when we choose sources, even persuasive sources, we're not choosing it for the material, we're choosing it for the source, where it came from. And he preferred a more, what he thought was a better term, optional authority. And that really is the stem of my rant, because I hated that concept of optional authority. And I also knew intuitively that sources like treatises have to have more than just the name on the label, something to them which draws people to them. But at least he disturbed the order such as it exists now. Someone who picked it up and moved with it was Professor Amy Griffin down at Georgetown right now. And she has suggested that persuasive authority is really something more dynamic. We can't put it in hierarchies. We have to put it on a spectrum. And authorities like treatises, if we choose them, are going to be defined by points on that spectrum, not where it sits in terms of a hierarchy. And to better draw out that idea of authority, of how that might work, I turned to one of librarianship's great thinkers, a gentleman by the name of Patrick Wilson, who wrote Secondhand Authority back in 1984. It's a fantastic book about why people choose what he called cognitive authorities and what we would call persuasive authorities. And he provided a wide range of reasons why people might do this. Factors like professional peer esteem, special accomplishments, charismatic appeal, and intrinsic plausibility. Now, intuitively, that seems right to me, but I wanted to prove that this concept of persuasive authority could actually work. And to do that, I chose to create an authoritative biography of Joel Bishop, who was one of the greatest treatise writers of the 19th century, certainly the late 19th century. Not an authoritative biography in the sense that to tell his story, because essentially that's already been done by Professor Siegel, who wrote about him in 1998, but more in a biography of him as an authority, about him as he was embraced by the legal profession, ultimately discarded by the legal profession, and then ultimately picked up again by the legal profession just recently. So that's really what my paper is, a story about how somebody acquires authority, loses it, and then somehow gets it back again, even when he's not alive. So who was Joel Bishop? Joel Bishop was born in 1814. My geography of New York is actually quite bad. I'd like to say it's around the Mohawk Valley, but he kind of moved around there. He was the son of a poor farmer. But he decided that farming life wasn't for him and he wanted to get into education. So for many years, he tried to pursue a career in education. About 21 years of age, he decided he had to give it up for poor health, at least he said. And then he worked for a while on an abolitionist paper before he decided that he wanted to move to Boston. So he moves to Boston. He takes a job as a clerk in a law firm by some abolitionist partners, and he decides the law is for him. He really likes the law, and about a year and a half after becoming a clerk and going through that apprentice experience that we've talked about before, he becomes an actual lawyer, and he becomes quite successful. He starts his own practice, but he doesn't like doing small jobs, so he figures a great way to sort of get himself out of this tedious small jobs is to write a treatise. So not even 10 years out of starting practice, he writes a treatise on marriage and divorce law, and it becomes wildly successful. So incredibly successful that he said, I retired from the world, or retired from law to become a treatise writer. And over the next 50 years, he writes an amazing set of treatises. His next big project after marriage and divorce law is a set covering all of criminal law. He writes books on criminal law, criminal procedure, statutory crimes, and directions and forms. And he also writes other books: contract law, law of married women, statutory of interpretation and torts, and a book on torts with the odd name of Commentaries on Non-Contract Law. And these are updated over those decades, continually with many infrequent new editions. Now, it's not enough. Let me go back. He essentially went to all these fields and he declared himself an expert. And one of the great things about Patrick Wilson, he's in his discussion about authority, it's not enough to be an expert to become an authority. People have to recognize you as an authority. And people recognized that Joel Bishop was an authority in practically every area of endeavor that he took on. This is what one reviewer said about his treatise on marriage and divorce. He brought order out of confusion, brought the principles announced in a mass of discordant and heterogeneous decisions into a harmonious treatise, which is today found in every well-regulated office in America and consulted by every judge upon the bench who has to deal with questions of law relating to marriage and divorce. Now, that's not bad for somebody that's not even practiced for about 10 years. And his other treatises are referred to in much the same way. His criminal law series was called the most comprehensive analysis on criminal law ever attempted. His contracts treatise was called Masterly. His non-contracts book Tort's book was called A Very Good Book with a Very Absurd Title. I kind of like that one. And one critic said, "We venture to say that all of Mr. Bishop's works deserve to be read." Now, the reasons for his popularity, I think we've heard a lot about why they would be popular today. I mean, when he's writing in the 1852 to 1901, the problem isn't, as we've already discussed, not enough cases. We need to rely on something else. It's too many cases. We have a vast amount of cases that have to be dealt with. And what he did was he sort of laboriously went through reporter after reporter after reporter after reporter, gathering all these cases together, reading them, and then distilling them down to scientific principles. And we were just talking about this. I thought this was something new, but actually other people had done it before, is that he believed sort of platonically that there were all these legal principles out there that had to be discovered. And he would discover them by, by basically looking through all the case reports, putting all the information together and distilling it down to these individual principles. It's also interesting to hear him talk about it because he declares the treatise writer and as almost equal, if not better than a judge in deciding what the law is. Because from his view, a judge is only somebody that just looks at the law as it applies to certain facts. He's not seeing or he or she is not seeing the broad perspective that a treatise writer sees. A treatise writer looks at everything in a certain area of law, doesn't have the narrow view that a judge does. And so, I mean, he doesn't come out and say, I'm just as good of a judge or I'm better than a judge, but he does say, I'm pretty darn close. And most treatise writers like me are pretty much the same. He also has other aspects of his work that impresses the profession that enable him to become an authority for them. He's pretty successful at distilling this vast amount of material into small points. It's almost TARDIS-like if you've watched Doctor Who. I mean, he can really compress a lot of material into a small amount of space. And it's kind of hard to believe when you read his writings. People would criticize him for his succinct style back in the 1800s. And this was his response. Our profession, they were certainly certain, his critics, were gaseous bipeds who could only be attracted by a diet in large part of wind and who had not grown out of the pap-eating period to crave solid food. Different time. And also what's important to his work, he cites a lot. He provided an enormous amount of citations. One of his books had an oddly specific 16,129 citations, which is more than any other book produced in the United States or America, or England, or at least so he claimed. And as we talked today about the digest function, and he disclaimed that his books would ever be used like a digest, but certainly people were using it. Using his books as digests. And I don't think it bothered that much as long as it was good for sales. And it's not to say that people didn't like Joel Bishop. He did have his critics, people that didn't believe that he was an authority or attacked him to take away his authority. They thought he overgeneralized. They thought the cases he cited didn't support the principles that he said existed. And he also, when he went into writing about criminal law, he encroached on the authoritative domain of the other big writer on criminal law at the time, a man by the name of Francis Wharton. And Wharton's friends, at least he thought, attacked his first edition of Bishop's first edition on criminal law. And he was so taken aback by this, he was about to publish in his second edition of criminal law a scathing attack on his critics. I mean, it's almost embarrassing when you read it about how his rant against who he thought were trying to attack his authority. His publisher wisely discouraged him from publishing it, but later, when his authority was more secured, he then took the opportunity to go after the people that he thought had wronged him. And it actually bothered people that actually liked Bishop a lot, which was a lot of people. This was this is what one critic wrote about his attacks on Francis Wharton in his later books. It sounds too much like praising oneself by running down one's neighbors, and is quite out of place in a grave philosophical and elaborate treatise like commentaries on criminal law. But what would be assumption in a new and less able writer will not be so regarded in Mr. Bishop. And what would be regarded as unpardonable in an author of less authority and reputation will be pardonable in the author of the best work on criminal law ever published. Perhaps the greatest light was from the famous law school in his adopted city. He was never granted an honorary Doctor of Laws from Harvard, to which brought this rebuke from one of the periodicals of the time. The university has scattered around the degree of Doctor of Laws in a manner which ought to create nausea in the Republic of Learning, but we believe it has never yet fallen upon this great industrious writer. He will probably die without this honor, if it be an honor. I figure I could get away with saying that slating as Harvard at Yale. But even despite these attacks, his name, the name of Bishop, appeared on all the best lists of what books that lawyers and law students should have. He was called the Carlyle of the treatise writers for the United States, and another author said, no law writer, not even Kent, has done as much for the jurisprudence of this country. But his true authoritative status really was in his judicial citations. He is cited a lot by judges. And I went through and pulled his citations and combed through them. A lot of them are string cites, but a lot of them are, also commending him for his work and relying on his principles. His name appears alongside the names of people that we've heard already today: Lords Coke and Hale, William Blackstone, James Kent, Joseph Story, and Thomas Cooley, and even state and Supreme Court opinions. When his work is specifically named, he is given accolades like eminent, able, learned, and his work is called admirable, accurate, celebrated, learnedly, and earnestly discussed. Courts will often rely on him for his definitions, and they'll often rely on him to express a point that they couldn't better express themselves. Perhaps his ultimate triumph, though, was that he redefined the definition of marriage in this country in a way that even overruled the United States Supreme Court. The United States Supreme Court, with people such as John Marshall and Joseph Story, defined marriage as contractual relationship. Bishop, when he came along and wrote his marriage treatise, again, not even 10 years of being a lawyer, redefines marriage as initially a contractual relationship, but once it is executed, is merged into a higher nature of a status. And this was explosive because at the time, if marriage was a contractual status, then would run afoul of the Constitution and restrictions on states intruding on contracts. But once he changed it, that sort of got rid of that problem. And then one law professor wrote in the 1930s, and I think this expresses what happened. In 1852, a prophet arose in Israel, or to speak more exactly, a bishop appeared among the law book writers preaching a new gospel of marriage. One of the more interesting things too is in 1888, when the Supreme Court discusses marriage again, they're not quoting Marshall, they're not quoting Story, but they are quoting Joel Bishop. And that's a pretty amazing accomplishment. Bishop, and I think when I read the papers, you could see that he suffered a demise after authoritative as well as physical demise when he died in 1901. His books pass out of memory. And why is that? Well, no one comes along and takes on his works. For whatever reason, his publishers only publish maybe a few posthumous volumes. But for the large part, entirely, they are just left alone, while other books, like, for example, Francis Wharton's works on criminal law, were picked up, and you can still get them from West. Of course, was his authority gone, new authorities arose in contracts and torts, giants in the field obviously. He's not around to revise his writings to deal with new views, and his 19th century outlook on scholarship and society didn't apply to obviously the modern century. They certainly don't apply that the way now. And their use as finding aids, almost as digest, is supplemented, I think, by the digest system as well. We don't need to rely on his books for citations as much. We actually have the West Digest system, Reporter and Digest system, and I'm sure a lot of lawyers felt, well, let's use this. This is more modern. And I think also as well, the treatise tradition in a way sort of took a hit with Langsdale's case method. Cases were more important than treatise writers when that view came along. So his reputation dims, and his actual biographer, Professor Siegel, says in 1998, by his time, Joel Bishop is entirely forgotten. And I think when you look at the other papers, he is forgotten. I mean, he was the best treatise writer of his time, but I think as we've heard today, that time was like the nadir of treatise writing. So he was the best treatise writer of the worst period for treatise writing ever. And I don't think that's really enough to sort of, bring you into the modern age. But he's back. He's now quoted fairly frequently in support Supreme Court decisions. Justice Scalia quoted him in his classic Matter of Interpretation. Justin Thomas quoted him in Apprendi versus New Jersey and called him one of the greatest commentators on criminal procedure and criminal law of his era. And then other people have quoted him as well. He appears in Dobbs. He appears in Heller as well. And I don't think that the reasons for that are unfathomable. We heard before about codification versus the common law. Joel Bishop had a rather rapturous affection for the common law, and he was definitely a foot soldier against codification. He called common law the triumph of reason, whereas codification was the triumph of authority. And we have people on the Supreme Court now who obviously have certain interpretations of common law or love the common law in a lot of the same way. So it's no wonder that they would go back and bring him from his authoritative demise. And I think what that history tells us is that authority really is something dynamic. It really is changing. And authority is not static. It cannot exist in a hierarchy. You cannot look at that life and that life of authority and say that this is something that I can put in a hierarchy. And it creates a great opportunity, I think, for us as well to sort of go back to the resources that we use as persuasive authority and see how their authoritative lives work as well. And I think I'm finished.
Thank you. Our next paper is by Wesley Oliver and Nicole Singleton. Wesley Oliver is a professor of law at Duquesne Law School, and Nicole Singleton is a law student at Duquesne Law School. The title of their paper is 19th Century Treatise Writers and Legal Codifiers Created a Fossil Record of Framing Era Miranda Warnings.
Thank you. And thank you, John, for kind of setting this up. I feel like I'm a little loud. Yep, there we go. Thanks. John kind of wrapped up his presentation mentioning that the current U.S. Supreme Court, many of its members have a real love of the common law, the law, and when you say that, it's interesting because they haven't really figured out exactly what they mean by that. Is it the judge-made law? Is it also the statutes? And so even their own definition of that is interesting. But one of the things that a lot of the modern conservative originalists seem to agree upon is that whatever the law was at the time we adopted the Bill of Rights constitutes the protections that we have under various provisions of it now. That the Bill of Rights at least codified the protections that existed at that time, making our trip back into the past incredibly important. Dean Gerken in her introduction said that that perhaps what we do doesn't always arrive on the cover of the Harvard or Yale law journals. But I think increasingly it will come to as the Supreme Court even more thoroughly delves into these questions of history. We've got to figure out how and what are our methods that determine what happened prior to 1791. So last term, I was asked to write a brief of legal historians of criminal procedure on a Miranda issue, because as you know, a lot of precedent's kind of up for grabs right now. And one of the things that a lot of criminal procedure folks believe may be up for grabs is Miranda. There was a case that Vega versus Teco versus Vega that was believed to, if not end Miranda, at least to put the first dent in the court's ultimate demise of Miranda. And I've done a little bit of work on this. I had shown in some work I'd previously done that beginning in the late 1790s, that magistrates who were doing interrogations of suspects at that point were in fact warning them. Were saying, you shouldn't answer this. I'm cautioning you not to answer this. Anything you say will be used against you. I began to find that language in the 1790s. So I was asked if I would write a brief of legal historians talking about that maybe the 1796, late 1790s opinions or decisions or examples of magistrates warning suspects cast some light on the fact that perhaps there were warnings prior to this. Well, I started delving into it, and my co-author, Nicole Singleton, my research assistant at the time, just did some remarkable work, and with some help of some folks at British universities, began to delve through the Old Bailey session papers, which were, for those who are unfamiliar, these were newspaper reports of transcripts of portions of trials in the Central Court of London, the criminal trials in the Central Court of London. And they contain not everything in the trial. They'll contain various portions of it. But Nicole was able to unearth about 4 cases prior to 1791 in which suspects were warned that they shouldn't answer, and anything they said could then be used against them in a criminal trial. Well, this is absolutely fabulous. This is absolutely wonderful. But as Professor Larson mentioned earlier, a lot of American authorities are not going to be relying on even judicial cases, much less, you can't imagine John Adams getting a supply of the Old Bailey session papers in bulk and combing through them. Aha, warnings. That's what we need to do. So how in the world can we go about showing that this was practice? How do you show that to the extent that we are claiming that perhaps something like a Miranda warning was part of the contemplation of the framers? How do you go about showing that there might have been a culture of giving these warnings that's sort of pervasive, that these stories in the Old Bailey session papers aren't one-offs? Well, we began by looking at the language in the warnings themselves. One of the opinions, actually in 1796, 5 years after the Bill of Rights was adopted in the U.S., one of those opinions said, sorry, sorry, the folks at home. One of the opinions said, "Did you give the suspect the customary warnings?" All right, so now we're starting to get some good language that suggests these things are pretty regular. But why are we at a treatise conference? Of course, we're at a treatise conference because we're now going to start to rely on treatises. Now, the treatises come along later. We don't get our first reference in a treatise until 1816. Not terribly surprising. I mean, you can imagine these things take root a little bit later, that the treatise writers aren't hanging out in the criminal courts of London, recording the procedures that are not making their way into sort of the reported decisions or the actual decisions of courts later. But there are these cases that have been popping up and been decided that have been discussed in the criminal courts of London. And the reason the warnings are popping up is because of something that's actually been very well documented. the rule governing confessions in Britain, beginning in the 1740s, becomes much more rigorous. There's a real concern about people falsely confessing because they are expecting some kind of leniency. And so there's a rule that develops that says if a suspect has been given any kind of leniency or promise of any sort, then the statement that they're going to be offering, that they'll offer, is now going to be involuntary and inadmissible. So what do these magistrates who are interrogating these suspects do in light of this strong concern? They start to give these warnings. And we start to see that occur. But in 1816, we start to see in the treatises, the manuals for the justices of the peace, the magistrates, we start to see in those books various statements like it is the duty of the magistrate. It's the duty of the magistrate to give these warnings. And earlier speakers have talked about sort of how these treatise writers had themselves a sense of authority. Well, at no point can we find any record that says somehow Parliament enacted a rule, or the chief judge or the chief magistrate declared some sort of procedure that required these warnings. But it was first William Dickinson, who was himself a magistrate and a fellow at Cambridge University, who writes in his treatise, it's the duty of the magistrate to give these warnings. Later treatise writers won't be quite so bold. They'll say it's the custom to give these warnings, but from what are they even deriving that? So the treatise writers had extraordinary power. They didn't really have to cite to where they were arriving at this practice that they were describing. And then that kind of promulgates on out. The other interesting thing that was happening is we were looking for records that suggest kind of a fossil record, those things that come along that we find occurring after the pre-framing era that we're trying to document. What are the shadows that pre-framing era cast later in history? We get, of course, the treatises that I've described, but at the same time, as Shawn Nevers was talking about in his wonderful presentation, in this period of time, you've got a real competition for authority. You've got the claim of treatise writers to correctly summarize the law, but you've also got this codification movement that's coming along. And the codification movement is a competing effort to summarize the existing law. And we see in a proposed code for Louisiana by Edward Livingston, which was referenced earlier, an effort to codify the right to the warnings. It was by Edward Livingston. He was probably the most Jacksonian of all the great reformers. Of course, the Jacksonian era wants to make law more accessible. That's the codification movement in a nutshell. Edward Livingston would have gone on to be Secretary of State for Andrew Jackson. So Livingston proposes in his code that these warnings should be given, that you got the right to remain silent, and that you can say can and should be used against you. So this is great. This is another piece of evidence. If this is part of the codification movement, then it also suggests there's this pre-existing right to, or pre-existing practice of giving the warnings that is just simply being codified. But much like we can't trust fully the treatise writers to not sort of extrapolate in their own opinions, the codifiers have a different goal. The codifiers aren't claiming necessarily to merely reflect existing practice because this is going to a legislature. The codifiers can also be reformers. And we actually see this in Livingston. So Livingston writes in his proposed treatise for Louisiana that a person should have the right to be warned about the right to silence and the effect of offering incriminating evidence against oneself, but also should have the right to counsel at the interrogation. That's the first time George Thomas at Rutgers has described that that's the first time anyone has ever actually proposed the right to counsel at the interrogation. And so Livingston's proposed treatise for Louisiana, perhaps not surprisingly, doesn't go anywhere in Louisiana, but one of our speakers this morning talked about how the codification movements were largely meant merely for the states. And I think that's largely true, certainly with David Dudley Field in New York. But Edward Livingston was sending these copies of his proposed Code of Criminal Procedure everywhere. He was sending them to governors in every state. He was sending them to members of the legislature. He was very connected. Obviously, politically, he'd go on to be Secretary of State for Andrew Jackson. He was sending these things everywhere, hoping that, in fact, he was creating the model law for the entire country. It does become the law by statute in 4 states: New York, Massachusetts, Arkansas, and Missouri. So these states then have that. So back to our story, we tell a story of fragments, right? We tell a story of, I can show you these fragments from the Old Bailey session papers that themselves seem to reflect that this is an ongoing thing. In fact, the fact that any of the procedures show up in these newspaper transcripts of proceedings is kind of itself remarkable, and probably suggests a lot more often this is occurring because these newspapers were created for public consumption, and they tended to omit procedure because no one wanted to read about procedure. They wanted to read about the murder weapon. So the fact that it appears 5 times prior to the framing era is itself pretty good evidence, and then it's bolstered by these other 2 non-conclusive types of things. And that's the story of the competition between the treatise and the codification movement. And fortunately, we've got both movement on both ends. We've got both the treatise writers collecting or claiming to describe existing practice in 1816, and then we've got the codifiers putting this in with the caveat that they're now adding something more. So that their effort is not purely one of codification. They are also reforming, which kind of casts some question, I suppose, as to how thoroughly we can trust that their efforts are merely extrapolating from the existing practice. But a couple of interesting bunny trails that we end up pursuing as we went down this line. Why was it? Why was it that Livingston's criminal code added the right to counsel? Now, I'm offering this. This is not part of the paper. Some friends of mine who work in social sciences and hard sciences have suggested for a long time that there ought to be a journal of non-results, of things that people have experimented on and found nothing. So no one tries to do these experiments again in vain. I offer this in that similar sort of spirit. This is not a journal of non-results. This is a journal of things, or an articulation of things that we thought about but haven't been able to figure out whether are true or not yet. So Edward Livingston produces this code for Louisiana, the Code of Criminal Procedure, and his efforts are largely based on the Napoleonic Code. The structure is largely based on the Napoleonic Code. But French law doesn't include the right to counsel at an interrogation for several decades after this. So is there anything in the French tradition that might have suggested there was a right to counsel? We haven't found the link to this yet, but it's a tantalizing thought. I was in Paris this last fall with my wife. We were walking by a statue of Joan of Arc, and she says to me, "Who was Joan of Arc?" And I have to confess, and they'll forgive me, they might want their degree back from here, but I didn't know. And so I said, well, let's do what you always do. Let's Google it. And so we found out that, of course, she'd seen these visions. She'd led people into battle on the basis of these visions she'd had as a 19-year-old girl. And the first 2 times she was right, they won. The 3rd time she was wrong, they lost. So they decided that her visions must be heresy. So they burned her at the stake. Well, about 20, 30 years later, they go back and revisit her trial, and they determine that her trial was in error. And they exonerate her, 30 years after they burned her, on the basis of procedural errors in the trial, one of which was they didn't give her counsel in the interrogation. I don't know if there's a link between Edward Livingston's flashback to the Napoleonic Code and something about the French tradition. I don't know if there's a link there, but it's tantalizing. And if I'd had more time prior to this paper, and I spoke French, I probably would have tried to trace that down. The other really tantalizing thing that might be a future paper is, and Simon Stern, who's speaking later today, has traced down references to Miranda in literature. Well, one of the places that references to Miranda-style warnings appear well before Miranda is the Brothers Karamazov, the Dostoevsky novel, which was 1879. And in the trial in the Brothers Karamazov, the prosecutor actually gives the defendant what looked like Miranda warnings. Who knows whether that was part of Russian criminal procedure at that time? Don't speak Russian, didn't have a lot of time before this conference to look that up and find a translator. But that would be an amazing question to ask, because we know that Jeremy Bentham was part of the Russian court or visited the Russian court and it gave them interesting legal advice. And the question is, if in fact it did become part of Russian tradition, did it come from England or from France? Just great little tidbits I didn't have a chance to follow up on, but I thought were just fascinating, so I thought I would share. So to take us back to Shawn Never's question, who owned the legal authority of the early to mid 19th century? Was it the treatise writer, or was it the legislature and the statutory reformers? Well, as we can see in our case, there's clear evidence that both were at play, but we don't know who won that battle in our case, because it wasn't that the treatise writers went out of existence or the legislative reformers went out of existence. In our case, it is that the magistrates sort of went out of existence, because prior to the creation of professional police forces, magistrates were the one doing the interrogation. With the creation of professional police forces in the 1850s, police officers started doing it. And all of the treatises and all of the statutes describe the duty of the magistrate to give what we now know as the Miranda warning. When the police came along, they said, hey, we're not magistrates. We don't have to do that. And courts agreed with them. So our story ends there. But what we do see is the grand themes we've seen in this conference, the battle between what is legitimate authority. We see the fossil record of a pre-framing era Miranda doctrine that is evident in both strains of efforts to summarize the law in the early 1800s, both the treatises and the statutory reforms. Thank you very much.
Paper is by John, she's the head of reference services. Anne Rajat is the head of reference services at University of Connecticut Law School. And the title of her paper is Zephaniah Swift and Swift's System of Laws.
Thank you. As Fred said, my paper is on Zephaniah Swift, who was a Connecticut judge and legislator in the 18th and 19th century. And he authored the first treatise on American law. Other than this fact, which may be known to those in this room who are interested in the history of legal information, his work has not really been given a lot of attention. He was an extremely important person in the history of Connecticut, so his life has been examined somewhat through that lens, but much less so his early work, of his written works. So in this paper, what I hope to do is demonstrate that Swift's treatise actually was influential in his day and in the century since then. He certainly did have a tremendous influence on Connecticut law, but his work has been cited outside of Connecticut, including in the US Supreme Court, in cases involving some of our most important rights. So Swift was born in the mid 18th century. He came here to Yale, where he was in a class with some other well-known men, including Noah Webster of the dictionary and Joel Barlow, the poet. He maintained a legal practice after he graduated and eventually got into politics, serving in the Connecticut House of Representatives and the US House of Representatives. And he was ultimately the Chief Justice of the Supreme Court as well. His political career and his involvement in Connecticut's changing government at the time could be a whole other article or book. So my paper focuses really on his first work, which was called A System of Laws of the State of Connecticut. He did write several additional treatises, including one called Swift's Digest, which was an expanded and updated version of Swift's system. It's important to understand just a little bit about Connecticut history and the view of religion in Connecticut in Swift's time, as well as his personal beliefs, because they diverged quite a bit from the mainstream religious beliefs. Connecticut at that time had an established religion, Congregationalism, which was derived from Puritanism. The colonists were Puritans. And one of the tenets of that religion at the time was that humans were inherently corrupt and needed the law in order to engage in moral acts. Swift was not a Puritan. He did not view the law in a moralistic way, and he was very much in favor of disestablishment, as he placed the law as the highest power of government and not God. The status of English law in Connecticut was pretty uncertain at this time. Swift's life spanned the Revolution and its aftermath, and he was practicing law in the early 1780s as America was transitioning from a colony to an independent country. Connecticut, of course, was an English colony, but colonialists in Connecticut were not direct immigrants from England. They actually settled in Massachusetts first and then later traveled to the Connecticut River Valley in search of more farmland, actually. They created a form of government at the time. This was in the mid-1600s that actually was in place until 1818 in Connecticut. And they also created Connecticut's first statutory code. Connecticut never formally accepted or received English common law, as some other colonies did. And for a long time, the statutory code was really the primary source of law in Connecticut. So perhaps colored by the Revolution, Swift really downplays the relationship between Connecticut and England. He notes that it was settled without a charter from England, which is true, although there was a charter granted later. He notes that the Acts of Parliament had no power here, and that England had no role or a say in acts passed by the Connecticut legislature. After the Revolution, there were some schools of thought over the place of English law in America. Some, including Swift, believed that America should have its own common law, while others believed that English common law was fine unless it needed to be changed to respond to local conditions. But no matter what your beliefs were, as we've heard so far today, there was no denying that English law was already infused into American law. Professor Langbein described this time period much better than I can, but as he said, there were very few law books overall, and certainly no American law books. So in that vacuum, English works were the only things that could be relied on by courts and by lawyers. And one of those works that was the most influential was Blackstone's Commentaries, as we've discussed today. The structure and the accessibility of that work made it very popular with lawyers, and Swift was extremely influenced by its structure, the way it was laid out and accessible to lawyers, and the fact that it systemized the common law, and it made him want to systemize the law of Connecticut. So a couple of events took place that allowed Swift to start his systemization. The first was that the Connecticut legislature enacted a law in 1784 that required judges to give written opinions. Prior to this, there were no written opinions in Connecticut, and certainly no published opinions in the entire country. So this law is what led to Kirby's reports, which we've discussed already today, which was the first case reporter in the United States. Having access to these materials, these written materials, was the material that Swift needed in order to begin to systematize the law. The second thing that happened was Swift began to recognize that Connecticut did have a common law, but that it was completely inaccessible to courts and to lawyers. He was very critical of the court at this point in their method of solving disputes. He felt that they took each case as it came and didn't adhere to any overall principles or structure. At that time, he wrote in a letter that he was writing Swift's system because of this frustration, and that he wished Connecticut had a court with judges who would, quote, "instead of being anxious to do business fast, shall be anxious to do it right." So he wrote Swift's system, like Blackstone, not only for lawyers, but for all educated men. He thought particularly of legislators who were typically not lawyers, but needed information about the law and had very little way to get that. Swift, like Bishop, as I learned today, viewed common law as a set of principles that already existed and was revealed slowly over time, moving toward a state of perfection. Because he had this view that common law was revealed over time, he felt free to criticize English law and to point out when and why Connecticut law was different. And it also allowed him to not only systematize the law as it was in Connecticut at that time, but advocate for his view of what the law should be, discard precedent that he thought was in error, and advocate for his view that the law was the highest power of government and not God. So Swift's system was published in 2 volumes, a year apart, the first in 1795 and the second in 1796. It covered all of Connecticut law as well as its system of government, and its structure mirrored that of Blackstone's Commentaries. It was offered as a subscription in order to raise the cost for printing, and it was advertised widely in Connecticut newspapers at the cost of $4. It was characterized as a solution to the problem of being required to be familiar with court practice, English law, Connecticut common law, and Connecticut statutory law in order to know the law of Connecticut. It was also advertised in other parts of the country, where the benefits in those ads were generalized a little bit. It was described as like English commentaries and institutes in terms of convenience, but focused on American law. Volume 2 of the work contains a list of the subscribers. There are nearly 500 of them, and they came from, if not all, nearly all of the states that existed at that time. And there's some very recognizable names on this list, including President George Washington, Vice President John Adams, Aaron Burr, as well as some other prominent people of the time. The 2 volumes are about 900 pages in total, and they range from discussions of legal philosophy to very technical details about practice in Connecticut courts. It's actually very readable text once you get used to the style of typeface. The concepts are familiar really to any lawyer, and it's a very detailed source of contemporaneous history about Connecticut's form of government, court, and court practice. Swift's religious beliefs are evident in the work, as well as values that he personally believed in, such as the value of personal security, liberty, and property. He saw those as what the law should protect without unnecessarily restraining people's actions. Throughout Swift's system, he is clearly considering what the role of English law should be in Connecticut. He frequently refers to what the law of England is, usually to declare it inferior to Connecticut law. He did recognize, though, that some aspects of English law had already been imported into Connecticut because of the heritage of the colonists. Swift did recognize 2 instances where English law was superior, and both of them had to do with situations where a woman becomes pregnant without being married. So the first one in England, as he describes it, a woman could be forced to name the father of a baby when she wasn't married. And also the father of the woman could bring an action against a putative father for support. Neither of these remedies were available in Connecticut. And this is the one instance where Swift prefers the harsher regime that England has. So there are a number of legal concepts that Swift takes time to describe the difference between England and Connecticut. I'm just going to discuss a couple of them because they represent the most significant changes, as well as exemplify what Swift viewed as an improvement to the law and some concepts that continue to influence the law. The first is right to counsel. Swift described English law as providing counsel to criminal defendants only to plead points of law, not to investigate facts or call witnesses or provide a full defense. He was quite appalled by this. He called English law odious. And he noted that although it did persist a little bit in Connecticut early in its history, the legislature had abolished this and allowed for criminal defendants to have a full defense. Swift's writing on this is one of the issues where it's been referenced throughout time, notably in the Supreme Court case of Powell versus Alabama. Swift was also very critical of the English view of criminal punishment, believing it much too harsh. He believed the purpose of criminal punishment was to prevent crime, and his perception was that countries with harsher criminal punishment regimes, such as England, actually had more crime. At that time, England had over 200 capital crimes, and Swift believed that capital punishment should be limited only to societally destructive crimes such as treason and murder. When he was writing his treatise, Connecticut only had about 7 capital crimes, so they had significantly reduced the number of capital crimes. Forfeiture was another criminal punishment that Swift criticized pretty severely. It was very common in England. It could be a punishment for many different offenses, but was extremely limited in Connecticut. He saw forfeiture as punishing a criminal's family who were likely innocent, and he attributed the change in the law between England and Connecticut to the enlightened minds of Connecticut. So you're all enlightened minds today here in Connecticut. So just turning to Swift's ongoing influence, his name is certainly not as well known as some of the other early treatise authors. If you've heard of him at all, it might be the piece of trivia that he wrote the first American treatise, which is certainly how I first heard of him. His works that have examined the development of the law at this stage in history, he's sometimes mentioned and sometimes not. But when he is, he's typically characterized as a forerunner to Kent. But Swift actually was influential both in his time and continues to be today. Swift systems reached throughout the country, which is evidenced by citations in court cases in the first half of the 19th century from nearly all the states that existed at the time. He was cited on a variety of legal topics, from criminal procedure to wills to equity. Of course, he's had the most relevance in Connecticut. So he's been a consistent source of information about common law, about historically protected rights, and about interpretation of the Connecticut Constitution. Just one example of this, in 2010, the Connecticut Supreme Court considered the common law born alive rule, which determines whether a fetus who is injured in the womb is a person for purposes of the murder statute. The Supreme Court characterized this in 2010 as an issue of first impression, and so looked to the law at the founding of Connecticut, specifically at Swift's system, to determine that at that time, a fetus that's injured in the womb and then born alive and later dies was in fact a person under the murder statute, and ruled the same way in 2010. So this is just one example of numerous times that the Supreme Court, Connecticut Supreme Court, has looked to Swift's system for evidence of what the common law of Connecticut is. Another area where Swift was very influential in recent times is capital punishment in Connecticut. The Connecticut Supreme Court considered capital punishment in the early 1990s and considered whether it violated the state constitution's prohibition on excessive and disproportionate punishment. At that time, it found it did not. But in the dissent to that decision, those justices quoted Swift's system as evidence that Connecticut was ever moving toward a more decent society, had an evolving standard of decency away from harsh punishment and away from capital punishment. They noted Swift's criticism of capital punishment, and that, again, the number of capital crimes had been reduced from England to Connecticut. Connecticut did end up abolishing the death penalty legislatively in 2012, but that law applied only prospectively. So anyone who had been sentenced to death prior to that was still subject to capital punishment. When the court considered the constitutionality of that several years later, again, relying on Swift as providing evidence that Connecticut was moving toward a less harsh punishment regime, the Supreme Court finally completely abolished capital punishment. So Swift is not as commonly cited outside of Connecticut in modern times, although he is still sometimes. Very recently, he was cited in a New York case, and you may have heard of this one. It was a case that an advocacy group brought on behalf of an elephant in the Bronx Zoo. It was a writ of habeas corpus, and they wanted the court to recognize the elephant as a legal person. The court did not do that. But in the dissent, that judge wrote a really long and interesting history of the writ of habeas corpus, noting that the writ was allowed to be used in the past by people who were not entitled to full rights, such as enslaved people, women, and children. And he looked to Swift's system to demonstrate that women whose rights were severely limited in early Connecticut could use that writ against their husbands if they unfairly imprisoned or denied her liberty. So the US Supreme Court has cited to Swift system several times. Citations are not numerous, but they have been in cases where courts are considering important fundamental rights. For example, they looked to Swift system when they upheld a ban on assisted suicide in Washington state. They noted that although America didn't criminalize suicide as England did, it was still an unacceptable practice, and assisting someone with suicide was a crime. Right to counsel is the major legal right where Swift's work has been important. The most well-known case where the Supreme Court consulted Swift was Powell versus Alabama, which was a landmark case where the court had the opportunity to consider whether defendants in a capital case were entitled to counsel. To do this, they examined the right as it would have existed at the founding of the country, and they generally surveyed the constitutions of the states at that time to determine whether they had that right or not. Connecticut had no constitution until 1818, so the authority that they turned to was Swift. They quoted a long passage from Swift describing what the law was then. And they characterized the book as an ancient work long out of print, and noted that a copy of it is preserved in the locked files of the Library of Congress, which makes it sound quite obscure and very difficult to access. Why it would be locked, I don't know. So the Supreme Court cited to Swift's system in another well-known right to counsel case, Betts versus Brady, as well as two other right to counsel cases, Ferretta versus California and Herring versus New York. In each of these cases, the court used Swift's system as evidence of the law related to criminal right to counsel at the time of the colonies in early America, and to show that it was an important right at that time. So I hope I provided some evidence that Swift system's legacy is not only a bit of trivia on the first treatise of American law. And while I was writing this paper, I thought a lot about why Swift's work remains fairly obscure. It's certainly been recognized by legal historians as a source of information about the law of that time, but histories of legal information and treatise writing do not give it much attention. There are probably a number of reasons for this. First is that the name of the state is in the title. During his time, it was cited all over the country, but as other treatises started to be produced, a Connecticut-specific treatise was most likely overshadowed. Connecticut's a small state, and though I love Connecticut, it does not have the national influence of a state like New York. And so as treatises from more influential states and more national treatises were produced, it seems likely that the influence of Swift's system waned. Second, the court's remark about the work in Powell versus Alabama, that it was locked in the Library of Congress, may indicate something about its availability prior to digitization. I was unable to determine exactly how many copies were produced other than for the approximately 500 subscribers, but I would guess it was not many more than that. Swift later updated the work and expanded the jurisdictional scope, which would supersede any need to reprint Swift's system. With a low number of copies in existence, especially outside of Connecticut, its reach would be limited. And also fairly soon after Swift's system, other treatises began to be published, which placed Swift's system as sort of an early prototype, which then faded from prominence. Whatever the reason or combinations of reasons, Swift's work should be accorded more recognition. His role in Connecticut history alone is influential, and other authors have suggested that he's deserving of a more significant biography than what currently exists. His role in the development of law is an area that I hope I've highlighted somewhat, as his work has provided foundational information for courts to understand our legal history and the origins of our legal rights. Thank you.
Thank you, Anne, for that wonderful paper, and thanks also to John and Wesley and Nicole for their wonderful papers. I do want to just insert myself in something. Earlier, John Langbein said that Kirby was the first American law reporter, and Anne also mentioned that, and that has been the standard story. But if you search the America's Historical Newspapers database, you'll see that if you look at Philadelphia newspapers had advertisements for these two books, and it's absolutely clear that two books, and the other one is Francis Hopkinson's book of Admiralty decisions from Pennsylvania. And if you look at the ads, it's absolutely clear that Hopkinson was slightly before Kirby. So I mean, I love my adopted state of Connecticut, and I hate to take that distinction away from it, but actually Kirby was the second reporter, but it was very, very close, just a matter of a few weeks, I think, between the two of them. But thank you for your great paper, and thanks to the other speakers.
I'm going to take organizer's privilege to ask the first question on this panel, if that's all right. But, you know, I was going to say the day that Fred discovered that Kirby was not the first reporter was one of the worst days of my life. But actually, Fred did not discover it because Hicks, in his second edition of his legal research textbook published in 1932, actually has a footnote where he and one of his colleagues had discovered, right, that Swift had been the earlier reporter.
Right. It was actually a reference librarian here at the Yale Law Library, Elizabeth Forgius, discovered the same thing, remarkably, because she was in an era before online newspaper databases, and she found the exact same advertisement in the Philadelphia newspaper. I don't know how she did it. Right, so I'm not the one that discovered that. It was actually done many years ago by a reference librarian here, and Hicks repeats her discovery in his book on legal research.
And this is all relevant because my question is Kirby related, and my question is for Anne. So we've talked a lot about the relationship between the treatise and other legal genres. What's interesting is Kirby's Reports is published in 1789, Swift's System 1795. And what's fascinating is if you look at Swift's System has citations to Kirby's Reports. And I was wondering if you could comment to what extent Kirby, who is trying to create American legal literature, influenced or motivated Swift to create the first American legal treatise or legal commentary.
I don't know, or I haven't seen any evidence that Swift was necessarily motivated by being the first. Swift had a very strong views on the common law. He very much wanted the principles of law to be illuminated, and he was frustrated really that he felt that in legal practice that wasn't happening. I mean, certainly Kirby's reports allowed his systemization, is that he finally had that that material that he needed in order to study and to systematize. But I don't see that he wanted to be the first necessarily. He did a lot of things that were the first. He was the first compiler of the acts of Congress. He was quite did a lot of things first. So I think it was just an accident of history that happened.
Thank you. Simon Stern, University of Toronto. So Wes, I do have some questions about your paper, but with your permission, I might defer them until later and ask you when we have some more time. So I had a question about the other two that's perhaps related. John Cannon, you give a really fascinating account of Bishop, and one of the things I appreciated is that we rarely think of of treatise authors as promoting a particular, well, maybe I should put that differently. We often recognize that they're promoting a particular vision of the law, but I thought you did a very helpful job of elaborating what Bishop's view of the law was. And I want to speculate that one reason why it was so successful is that he seems to have been, if I understand your account accurately, a pre-Langdellian version of Langdell, and going with that thought that so on the one hand, that might help to account for how extraordinarily successful he was through the period when Langdell's method at Harvard was catching on, and it might also help to account for the diminution in his interest in his work in the 20th century for reasons that John Langbein gave. So I guess I just sort of wanted to invite you to speculate a bit more about the formalistic aspect of his work and its relation to the formalism of the age, which people sometimes associate strongly with Langdell as if it's somewhat unusual in that way. And then to ask with respect to Swift, so what's fascinating is that he calls it a system, and one's thereby invited to imagine that he actually is offering a vision and a method that's, if not similar in concept to Bishop's, at least his own vision and method. And I was wondering if you might say more about to what extent you see that in his work. So you sort of offered us examples of his views with respect to particular doctrines, but I wonder if something similar to what's been said about Bishop might be said about Swift with respect to his ideas about legal principles, their immanent or Platonic nature, relation to natural law, that sort of thing.
Yeah, I think Professor Siegel, who studied Bishop first, points out that difference. And the big difference with Bishop and Langdell is that Bishop is very much into religion and sees law as coming from God, and that he is, bringing forth what law has given. And he has these great discourses on, just once the truth, illuminated by the Almighty comes forth, you can't disagree with it. It's interesting, though, you note the comparison with Langdell is he very much felt threatened by the casebook method. He did see it as sort of almost a personal attack. And there's a great sort of back and forth between Bishop and his supporters and John Chipman Gray from Harvard about who should be delivering the law. Should it be treatise writers or is it judges? And it's rather interesting back and forth.
Yeah, it does sound like Swift and Bishop did have similar ideas about the common law. The beginning of Swift's system has quite a long chapter just on the philosophy of law and the history of law, sort of tracing the path of the common law. And Swift did seem very much to see the common law as something it existed out there in perfection, and it was up to humans to uncover it as they were deciding disputes. So it was ever moving toward a more perfect system of law. And he actually very much praised Connecticut's statutory code. He liked statutory codes because they reflected the will of the people. They provided consistent principles. And he saw the common law as sort of fitting within that, giving judges both using statutory law and presidential common law in order to be able to decide all disputes within certain, not unchangeable, but set legal principles.
This is a question for John mostly. You have a graph in your paper of Bishop's resurgence in recent years, from the lull and then up again. And part of that I know is due to Justice Scalia, who's, a time traveler in his own way. But I wondered how much of that is the digitization of 19th century materials, making of modern law on Google Books, that, I wonder if that same curve would exist generally for 19th century treatises.
That's a good point. However, I don't think but Paul it will prove, I think, what sort of I proved is this interest by the current Supreme Court in older sources. I mean, true, his material is digitized and you can find it online, but I can't think that somebody who's essentially forgotten would be of interest unless somebody had mentioned his name. And once it is mentioned by Scalia and Thomas and even Sotomayor has mentioned him, then I think we see that uptick. And I think it matches what Paul, I think what he'll talk about, sort of sources being mentioned, historical sources being mentioned, and an uptick in those as well. So I mean, it's possible. I think it makes it more available, but I really think that it's the Supreme Court that's moving it.
Please turn on your microphones when you speak, because it's really hard to hear. If they're on, maybe it's me and I need to go to an audiologist. But all the presentations, thank you. I again have a question for John. I'm fascinated with your suggestions that relate to cognitive authority, and that we have a scale of, or more of a scale than a hierarchy of persuasive authority. In fact, sometimes I hate the term persuasive authority even. But I was wondering if you had any ideas how we might use such a scale or develop a way of teaching our students, for instance, to distinguish what persuasive authority is really worth noting. Like I teach copyright, and 4 out of 5 cases that we cover cite Nimmer on copyright, even the edited down versions. And you'll see in our paper that if you read our paper that 80% of Supreme Court cases on copyright, they cite Nimmer on copyright. I've called him the lead treatise. Call it the lead treatise. So how do we distinguish and help our students? Because you can't just say, well, treatises are up here and encyclopedias are down here, because frankly, Amjur is cited all the time by the Supreme Court. So, so anyway, that's my question. If you have ideas on what factors, what criteria will we use in a spectrum to judge authority, and how does that become part of our cognitive authority, which I think is really the centerpiece of what we do as librarians, as a science, is cognitive authority. Thank you.
Yeah, I think what we have to do is really think about that, and we really have to think about it now. I mean, we had the luxury of not worrying about it, but with ChatGPT, we don't know what the authorities are that generate those responses. So we have to sort of deal with that now before that becomes a problem. I mean, there are certain works which we know are accepted by the profession. There are certain works that we as librarians can judge by currency. For example, is going to be a big factor. With Swift and with Bishop, obviously they're not going to be current, but then they're going to also be current in other ways. And I think we also have to think back to the materials that we're taught, that the older materials that are sort of coming forth, and that sort of gives us an indication as well. I mean, how how well do they speak, for their interpretations of the common law? The Supreme Court will often say, "Oh, this, this speaks for a certain era," like Bishop speaks for an era, Swift speaks for a certain era, or any other material does. And we really have to think about that. Does it actually do that? So it's going to be it's really going to take a lot of work, I think, by librarians, well, mostly by librarians, because this is the kind of stuff we think about to find out what those points are.
My question is for Wes. As I recall, reading a little bit about Livingston's criminal code, and one of the things that I remember, even though it didn't get passed in Louisiana, was that it seemed to be very well admired internationally by foreign countries. And I wonder if is there anything, I haven't read those reviews of that from those sources, but is there anything from those countries that talk about kind of Livingston, what he might have added, or the kind of this reform, or the things on Miranda that you're looking at that might give some
in like, were the Miranda style things referenced like in other countries, or were people talking about this?
Yeah, or even just do the people that kind of say that they admired the Livingston's criminal code, do they make mention of anything like that?
So not that I've found. And what's interesting, yes, not that I have found, and I think that is itself interesting. Now, I, can't claim to have exhausted every possible place where something like this might pop up. But what is fascinating is how little notice that provision that he created attracted. So, 4 states adopted. When the U.S. Supreme Court decides Miranda, of course, it's not a legislature, and so will the people, et cetera, et cetera. But when the U.S. Supreme Court adopts Miranda, this is one of the things that gets Richard Nixon elected president. So, I mean, it changed. Miranda was one of the things that really fundamentally changed the world, at least the United States, and I guess therefore the world. When Livingston puts it in a code that's not adopted in Louisiana, but then does get adopted by 4 states, as best I can tell, at least in those 4 states where it was adopted, it's like, oh yeah, sure, this makes a lot of sense, put it in the code. We're just codifying. And what's really interesting about this is, and this is why I offer the kind of like, obviously I wrote this in the context of a legal historian's brief suggesting Miranda has a pedigree. But the Livingston evidence for the long-term existence of Miranda is flawed in some way, because he drops in there the right to counsel and nobody notices. Now, it could just be that unless you were Aaron Burr, you couldn't afford a lawyer because there weren't a lot of rich people being accused of crimes. That's entirely possible, so no one really worried about it. But it was a fundamental overhaul, and I have found nothing about that. But to me, that suggests this really was, with the exception of the counsel, just something folks had long come to recognize, oh yeah, that's just what magistrates do. Then come the police, and the world then fundamentally changes, and they go, oh yeah, we as police, we don't have to do that, and we're going to stop. So I think your question is really interesting. I wish I had a better answer for it, because I wish I had found somebody referencing it somewhere, but I do think the absence of that is telling.
So yeah, question for Wes. It's really fascinating in this early period. What did you find, if anything, on what the remedies would have been if magistrates
Great question.
did not give the warning?
Yeah, great question. Absolutely nothing. Now here's right. So what does that mean? The warnings were exactly what the U.S. Supreme Court described them as in Miranda versus Arizona. They were prophylactic. They were meant to prevent something. They were meant to prevent exactly what the U.S. Supreme Court describes, which is they were meant to prevent a voluntariness issue. So you have, and I didn't get far enough into this in my presentation, but there were a lot of decisions that describe that even if you had minorly tripped over the voluntariness problem, the confession rule, by suggesting the person might be better off if they confess. This was a basis for throwing the thing out. But if you then also said, when you got to the interrogation, by the way, anything you say can and will be used against you, that could purge the taint of something that would suggest that you would get more lenient treatment. So the failure to give the warning itself didn't do anything. So the extent to which we're saying you've got to give this you need to give this because it will overcome this hyper-technical rule about voluntariness. So take us back to how the modern relevance. If you look at the sum total and package of confessions law at the time we wrote the Bill of Rights, we had a very rigorous voluntariness rule that would kick out virtually anything if you said boo to the witness before he started to be interrogated. But then with the warning, you could overcome the boo. And by boo, I mean, I can give you a great example. It would be better for you if you confessed. That's enough. That's enough to kick it out. And the warning is enough to overcome that. So there was this really strict voluntariness rule, much stricter than we have now, overcome by warning. When I wrote the brief of legal historians, I really, Oren Kerr actually approached me about writing it. And Oren is enough of a fan of Miranda to want to keep it. And so he didn't particularly like this idea, but I said, well, he was ambivalent as to whether this is a good idea or not. I really wanted to file an amicus brief in support of neither party, because I think this history could be read both ways, but the Supreme Court doesn't really know about it. Justice Gorsuch did ask 2 questions about the brief, so this is going to be part of the conversation, hopefully eventually as this thing goes down the road. But I honestly am not sure whether this history supports the continued existence of Miranda or not. I think an argument could clearly be made both ways.
Welcome back. This is our 3rd panel of the day. Again, my name is Nicholas Mignonelli, and the focus of this panel is identity. And I'm going to introduce the 3 sets of authors as they speak. And then after, I'm going to I'm going to have them speak, and then I'm going to ask some questions. I'm also going to take questions from attendees here in the room. So our first set of authors are Jane Bonson, and Jane is the Assistant Director for Research and Instruction Services at the J. Michael Goodson Law Library and a Senior Lecturing Fellow at Duke Law School. And also, Wycliffe Shreve is the Head of Scholarly Services at the J. Michael Goodson Law Library and a Senior Lecturing Fellow at Duke Law School as well. The title of their paper is Legal Treatises and the Evolution of Civil Rights Case Law, and I'm going to turn it over to you.
All right. Thank you so much. I'm going to do a rather short introduction, and then my partner is going to take over to talk about some of the methodological and substantive elements of what our paper is at this point. First of all, I'd also like to thank Nicholas again for, like others have, arranging this. Having recently taken over a little bit more of an administrative role, I recognize how difficult it is to get events like this together, especially when you have people who respond late to certain aspects of it. So I'm sorry. But moving on to the actual substance again of what we're talking about. So our original plan was to look at cases in which civil rights were expanded or contracted and see if there was a pattern in citation to treatises within those opinions. Specifically, we were looking at the US Supreme Court opinions because it gave us a controllable universe of opinions to look at and see how they turn to historical treatises to argue how civil rights or specific civil rights have been grounded in tradition. This was meant to include an examination of how treatises may have been used to argue for or against the inclusion of formerly excluded populations in the exercise of certain rights. So, e.g., women in suffrage, the LGBT community in civil marriage, as well as the recognition of so-called penumbral rights not explicitly enumerated in the Constitution. So, for example, privacy. We planned on beginning by describing the universe of cases and the method of selection, and then continue to identify the major historical treatises that were used therein. So things like Littleton, Coke, Story, Kent, Bracton, Hale, the names that we've been hearing over and over again during this panel discussions, and discuss how they were selected and used to expand or contract civil rights. And bring to surface any patterns in usage across time. Considering how the tradition of precedent seems to be coming to loggerheads at this point, with the use of historical treatises, we thought it was a timely and important conversation to be had. So when we started the project, one of the first things that we ended up in many ways sort of dropping was a discussion of the expansion or contraction of civil rights, because we looked at it and thought that this is not necessarily easy to characterize. I think the masterpiece cake maker case is probably a good example of how these things can be conflated in many ways. So as much as you can argue that it was, if you looked at, like, if you approached it more substantively, it said it's like, you know, a limitation of the rights of the LGBTQ community to interact with the public. It's also arguably a defense of people's First Amendment rights in terms of religion. So in many ways, it's more like looking at the hierarchy of competing civil rights interests. The expansion contraction question became less clear. We also wanted to see if there were other things that we should look at. So Jane did a literature review in which she discovered some of the things that, A, to make sure that, again, our conversation had not already been had, but B, to see if there were holes that we wanted to fill in terms of other issues that came up along the way. And one of the things that we thought about was looking at citations from briefs of parties and amicus briefs, and that had been done. So we decided that it was not something that we needed to necessarily delve into. The paper that had done it is 20 years old, but again, it was fairly thorough. So citations to Supreme Court opinions and briefs, a comparative study in 2002 in the Law Library Journal. The study compared the authority in SCOTUS during the October 1996 term with the authority used in briefs submitted to the court. The article included appendix listing the court citation studies. The study also counted the citations of numerous other secondary sources and included practice books within the treatise category. So it was a little bit more expansive, but it covered the treatise question at that point. We also wanted to see if there were citations. We wondered about including citations to other scholarly writings, and we realized that since the focus is on the treatise, that was pretty much beyond the scope of what we should be looking at. We wanted to see if there were more citations when a decision was controversial potentially, and this may be something that we look at as a future direction. So identifying those specific cases that were in the news, that were talked about, that ended up, like, you know, overturning a significant precedent. But at this point, it was difficult to come up with solid criteria in terms of like what was controversial. And we wanted to tentatively think about tying in the idea of what lawyers rely on has potentially come full circle. So there was, as has been mentioned before on previous panels, there was a reliance on treatises, and then there was a move towards reliance on case law once it became more regularly available. And in that case, we would look to our former director, Dick Danner, and he's written a specific paper on this in 2016 on case and case lawyers. So if we do continue on like that, that will be something that we expand on this future project at some point in the future twice. So at this point, I will turn over to my colleague who will discuss the methodological and substantive elements of our project.
Thank you. Can everyone hear me? Is this clear? Great. Thank you so much for taking our paper, our proposal. This really got stimulated when we saw what seemed to be more attention being paid to treatises in the news with current jurisprudence, and wondering, is this new? Is this some new phenomenon? Are they invoking these older writings now in a way that hadn't been done in the past? And can we see any pattern in what's been done in the past? So with any, I almost hate to use the word empirical because it really just means something you have observed, but there's always ways you can quibble with methodology, especially when you are trying to quantify things. So we specifically tried not to quantify things, but just to organize cases in a way that was meaningful to us, explain to you what we've done, tell you what we observed, and just get your feedback. Our paper really is very preliminary at this point. We found the readings fascinating. But what I'd like to do now first is talk to you a little bit about the methodology, just so that you can see how we approached it. We came about it a different way from some of our colleagues, in that we started looking at Supreme Court opinions first. We wanted those opinions where precedent had been changed. And fortunately, there's that excellent SPAIT database that is still hosted by the University of Michigan that did that hard part for us, in that they have a whole separate category for precedent altered Supreme Court cases. Now, they don't break them down by topic. We had to do that manually, but they listed in there 191 modern cases and 80 historical cases. And we looked at those, divided those up, and just read through them and pulled out those cases in which civil rights seemed to be impacted one way or another. It was a total of 455 cases. This was a very manual review, started back as soon as our proposal was accepted, probably during the summer. Took a long time to go through them. The total number of cases that we found were 316. I'm sorry, I've jumped ahead a bit here. We also looked at the Constitution Annotated, which has cases in which statutes involving civil rights at the state level were overturned. And we looked at those as well. So what we had again were those cases from the state database marked precedent altered that we had filtered for civil rights issues, and cases from the Constitution Annotated that they had flagged involved civil rights issues. So that was our corpus of Supreme Court cases. Reviewed a total of 455 of them, of which about 316 seemed to address changes in civil rights. Looking at this, again, the tough part about this was trying to put together a corpus to talk about in a meaningful way. But we looked at them and categorized them roughly into 13 different rights, some of which Wick has mentioned: freedom of speech by individuals, equal protection, due process, habeas corpus, sovereign immunity, those sort of issues, right to an attorney, right to bear arms, freedom of the press, the right to jury trial, reproductive and family rights, religious freedom, cruel and unusual punishment, search and seizure, racial segregation, and voting rights. These were all of the different civil rights areas we looked at, looking at those opinions, seeing how treatises were used. Were they used to support the opinion? Were they used by the dissent? Were they used by the concurrence? Hoping to find something basically to talk about. Due to the restrictions in the length of the paper, we chose the 5 categories in which treatises were invoked most often, just to see how it was that they were actually being used by the justices. It involved a lot of manual sort of color coding. Again, we were trying so hard not to make this empirical because there is so many layers of subjectivity at every step of this process. Picking the cases, what is a treatise? All of the things that we went through trying to figure out what is it that we can talk about in a meaningful way. To mention briefly, again, the treatise, we have a section in our paper that I won't read for you now that talks about how we decided what a treatise is. We did a literature search on it. I was hoping we could find some standard use of the term treatise so that we could simply implement what other authors have done to make it comparable across the literature, which is always, of course, something we tried to do. We were unsuccessful. So we came up with our own criteria, which are in the paper. Quibble with it as you will, but keep in mind that this was our interpretation and our observations are based on our curation of cases and our discussion of those particular authors. And I can say we did recognize Bishop. We recognized about everything everyone talked about today. So I think we got a pretty good compilation within there. And again, moving on to the analysis, one thing we did that made things helpful is as we recorded them, we entered the cases into a spreadsheet, just a big fan of Excel, even for organizing my legal research, and marked by color those cases in which treatises were cited by either the majority opinion, the concurrence, or by the dissent. And that way we could sort them by particular civil right, we could sort them by time and see if there was any kind of visual pattern. And we were really hoping to find something meaningful to talk about. And as I say, this is still very preliminary. Our paper is probably the one that is in the most draft form of everyone's, and we apologize for that. I think the data collection part turned out to be a much bigger beast than we thought it would be. But we were hoping to see trends over time, trends by justice, trends by political affiliation, and trends in the majority or the dissent. And from here, I just want to talk with you about some of the observations that we had. First, on the right to trial by jury, just to quote to you from the paper, this is where Blackstone reigned. Blackstone was in every case in which a treatise was cited. There were parameters of the right to a jury trial have long been considered to be determined by reference to the practices contemporaneous with the adoption of the 7th Amendment in 1791. the roots of which lie in the common law of England. So it comes as no surprise that this set of opinions, Blackstone was the favorite, appearing in all 9 opinions in which treatises were cited. The specific issues taken up by the court included circumstances under which the defendant had a right to a jury's trial, the number of jurors that were required to come up with a meaningful representation, and the composition of the jury pool. It didn't mean that Blackstone's missives were always followed in determining the outcome. Indeed, the court was entirely willing to dismiss Blackstone's teaching when they seemed to contradict the Constitution or to conflict with modern values. For example, Blackstone, I don't think, contemplated other races or women as being on a jury. So when that came up, those were quickly dispensed with. In the right to jury trial cases, just as a last kind of observation, those justices with traditionally conservative political ideological leanings cited treatises more often than those with traditional liberal leanings. Now, how did we come up with which justice had which kind of leanings? That fortunately has also been done by other authors. There is a wonderful chart that is also linked through the University of Michigan's Space database. A lot of justices changed their reflection over time. Some started out much more conservative and moved liberal, some stayed the same. So we tried to match up the date of the opinion, which with the ideology of the justice at the time the decision was handed down. The next civil right to talk about that we observed, the Eighth Amendment rights, the struggle to evolve with the times was kind of the subject there. It was interesting in this section in that the court held the Eighth Amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. You would think that in Eighth Amendment jurisprudence, if it's universally accepted and adhered to, would theoretically constrict the use of older treatises. This was not, in fact, the case. Within these cases, there were frequent citations to Blackstone, Eliot, and even to the Bible. Although more conservative approaches did not tend to carry the day. Of interest in these Eighth Amendment right cases, a lot of them were looking at treatises to the extent that they did not talk about things. For example, when they talked about cruel and unusual punishment, they were usually talking about methodology. They were not talking about proportionality. And proportionality was the majority of the Supreme Court jurisprudence at that time. And in Eighth Amendment cases, as in the last, the justices with conservative political ideological leanings tended to cite them more often than those with more traditionally liberal ideological leanings. The third I'll talk about this morning or this afternoon is freedom of religion. And of the 24 opinions that addressed religious rights, a little over half included citations to treatises, with historical treatises most commonly cited to support the need to separate church and state. Considering one of the driving forces behind the creation of the New World and the split from England was the desire of the original colonists to escape from the Church of England, it's unsurprising that many of these historical legal writings would find their way into these opinions. And we did find in this particular set that its justices who were of a more liberal leaning would cite to treatises more often than those who were more conservative. And the last area I'll talk about is the area of reproductive freedom. Of the 20 cases identified addressing reproductive and family rights, half cited to treatises in deciding the outcome. The legal theories underpinning these cases varied, but we thought it was important to put them together as their own separate category because they were frequently referred to as one of the most fundamental, underlying fundamental constitutionally unspecified rights to personal, reproductive, and interpersonal relationship freedom. Which the court repeatedly recognized as critical to the function of society and one of the basic civil rights of man, which is quoted repeatedly. In these reproductive freedom cases, the justices, again, with conservative political ideological leanings, tended to cite them more often. So this is where we are now. This is very much a work in progress. One thing we talked about extensively when we were talking about what is a treatise is what about treatises that are not of a legal nature, and to the fact that those also impact legal findings. For example, in the Eighth Amendment jurisprudence, there was a lot of discussion of medical treatises talking about the development of the juvenile brain. And when can we make people culpable for what they do? When have they reached that area of development? And again, some of those treatises they cited to were not that new. And we thought it might be interesting to see, perhaps instead of cutting off the definition of treatise at only legal treatises, maybe look at any treatise that was put out even by the medical profession, because certainly those were also reflected in the reproductive jurisprudence and in their ideas of medical development, development of the fetus, and women's health. A lot of what was cited to, especially in the most recent Dobbs opinion, was citing to quickening and to certain criteria that we just don't really talk about anymore, at least not in the common medical treatises. So thinking that perhaps another dimension to take this paper might be treatises from 1900 and earlier. How often are they cited for whatever reason to change civil rights in the current day and age? And really, is that the right way for the law to go? Are we making significant legal decisions based on what might be arguably outdated information? But again, it's something that we haven't done, something that we're thinking about. And the other aspect we were looking at for a possible future direction is, and something I had hoped would be more evident as we read through the case law, was whether justices were using these treatises in situations where they just couldn't find anything else to back up the point that wanted to be made, where there's no case law, where there's no anything else solid in the law, no statute, no other kind of history that they could point to. Our treatises filling in a hole in our jurisprudence in a way that maybe we didn't expect. One thing I can tell you overall, though, is from looking at the citation of treatises over time, as we mentioned in the paper, it's not new. We definitely saw a bit of an uptake in the civil rights era time period, but really throughout history, justices have been citing treatises in civil rights cases. So I mean, to the extent that it's been getting a lot of press lately, it has been getting a lot of press lately, but it's catching attention of the press, but it doesn't mean it's a new phenomenon. So, and again, we do appreciate your questions, your feedback. We would be most grateful for any direction you might have for us. Thank you.
Thank you, Jane and Wick. And our next author is John Moreland. And John is the Student Services Librarian at the Jerome Hall Law Library and an adjunct lecturer in law at the Indiana University Maurer School of Law. The title of his paper is To Train the Legal Mind.
Thank you, Nicholas. As I like to tell my students, it's show and tell day. In 1858, Georgia attorney Thomas Reed Roots Cobb published a legal treatise that changed the course of American history. An inquiry into the law of Negro slavery in the United States of America, to which is prefixed an historical sketch of slavery, or for brevity's sake, just the law of Negro slavery, was the first book-length comprehensive examination of the laws and court decisions related to the institution of slavery. Doctrinally, it became one of the most influential pro-slavery publications, as it was the only major defense of slavery written specifically for practitioners and students of the law. Yet, the treatise was more than just a practical guide for attorneys and judges. Cobb produced this work by design in order to counter what he saw as an invasion of Northern abolitionist literature into the antebellum South. Serving at the front lines of this bibliographical battle, Cobb's treatise provided Southern lawyers the training and education they needed to defend slavery on a rational and legal basis. Cobb's book was also intimately connected with his creation of a distinctively pro-slavery legal education. At a time in which legal treatises were essential to the education of aspiring and seasoned attorneys alike, the law of Negro slavery was intended to become central to the formation of pro-slavery legal advocates in Georgia and throughout the South. Through the production, dissemination, and reception of this treatise among lawyers, judges, and legislators, Cobb's goal was to instruct members of the bar, policymakers, and law students on what the law of slavery said, or perhaps more accurately, what he thought it ought to say. This pro-slavery education, as set forth in the law of Negro slavery, was designed to better train future legal minds and influence the arguments made by jurists in defense of the South's peculiar institution. Cobb not only hoped to inform and educate on the law of slavery, but he also hoped to defend and cement it into American law and legal education. In the end, he partially succeeded. In addition to citing and imposing 870 cases, Cobb's multidisciplinary treatise examined the institution of slavery over the course of human history, from ancient Egypt and medieval Europe to the antebellum South. He drew upon scripture, sociology, moral philosophy, and used spurious scientific evidence to support his argument that slavery was a necessary component for economic development and physiologically beneficial to both slave owners and slaves. Consistent with pro-slavery religious ideology of the day and his own deeply held Southern evangelical Protestant convictions, Cobb's treatise also argued slavery to be sanctioned by the Bible and in keeping with Christian principles. Long before he published his treatise on the law of slavery, Cobb was a well-known and accomplished attorney, not to mention his long family lineage, which included his cousin Thomas Willis Cobb, the namesake of Cobb County, Georgia. In addition to building a robust law practice in Athens, Georgia, 20-year-old Cobb became Assistant Secretary of the Georgia Senate in 1843. In 1849 to 1857, he was the reporter for the Georgia Supreme Court, where he compiled 15 volumes of the Georgia reports, wrote the Supreme Court Manual, and a general digested index to Georgia reports. In 1851, Cobb codified the laws of the state of Georgia, which marked the first comprehensive codification of law in the United States. A year after publishing his legal treatise, Cobb partnered with his father-in-law, Joseph H. Lumpkin, Chief Justice of the Georgia Supreme Court, in establishing the Lumpkin Law School at Franklin College, later to become the University of Georgia School of Law. On the eve of the American Civil War, Cobb became a delegate to the Georgia Secession Convention and took the lead in drafting the Confederate Constitution. After the firing on Fort Sumter in April 1861, Cobb raised and was put in command of a Confederate military unit. During the first 2 years of the war, Cobb led his troops through multiple engagements in defense of the institution of slavery. Despite, and perhaps because of, the passion with which he fought for his cause, he would not survive the war. On August 4th, 1857, a year prior to publishing his legal treatise and establishing the Lumpkin Law School, Cobb delivered a speech before the annual Alumni Society meeting at Franklin College. In his speech, Cobb identified three, quote, great and palpable educational wants for the state of Georgia. One, properly qualified teachers, home-born and home-bred, Southern textbooks, and a larger university with individual schools of advanced studies. For Cobb, the greatest of these of Georgia's three educational wants was the printed word. In order to get out from under the abolitionist thumb of Northern authors and publishers, there needed to be a dramatic increase in Southern textbooks. In 1858, using his background and reputation as one of the most respected attorneys in the state of Georgia, Cobb published his legal treatise, The Law of Negro Slavery. He subsequently became a faculty member at the Lumpkin Law School, where he committed the unforgivable sin of all college professors. He assigned his own book to his students. Within 2 years of his fiery speech on the educational wants of Georgia, Cobb made his own contributions to stamping out what he saw as a Northern anti-slavery invasion of the state's educational system. He had become a homeborn and homebred teacher. He had written a Southern textbook and turned Franklin College into a university with a quickly growing law school. In short, Cobb brought his own legal expertise to this bibliographical battle with abolitionists by writing a legal treatise and creating a pro-slavery legal education. Indeed, the power of the abolitionist movement dramatically increased in the 1840s and 50s. Abolitionist literary works such as Uncle Tom's Cabin were written to offer an emotional appeal to readers' humanity. While there were emerging Southern literary responses to these Northern abolitionists, often referred to as anti-Tom literature, Cobb believed in this context that one should not fight fire with fire. Instead, Instead of defending slavery on sentimentalist literary grounds, Cobb sought to fight this bibliographical battle on an academic, rational, and legal basis. As the moral temperature of the country began questioning slavery, Cobb's solution was to write a treatise in its defense. Cobb's legal treatise on the law of slavery was the first of its kind. In 1837, Jacob D. Wheeler had published a book titled A Practical Treatise on the Law of Slavery. However, this was not a treatise in the scientific or analytical sense, but was rather more of a case digest of judicial decisions related to slavery. Cobb's treatise analytically and explicitly argued for the justification of slavery in the American South. Moreover, by placing law in the book's title, Cobb was signaling to his readers the treatise's legal authority and thereby its primacy and superiority over the mere sentimentalism of abolitionist literature he was fighting against. Cobb set out to settle the slavery question by creating a pro-slavery education not based on persuasive novels, but rather on the mandatory controlling nature of law. Structurally speaking, one can view Cobb's treatise as being two works in one. The first part consists of a 228-page, 18-chapter section titled An Historical Sketch of Slavery from the earliest periods to the present day, preceded by a separate 317-page, 22-chapter section titled The Law of Negro Slavery. The first section, An Historical Sketch, is paginated using lower Roman numerals, while The Law of Negro Slavery is paginated with standard numbers. Additionally, both sections have a separate index located at the end of the book. Taken as a whole, Cobb actually devoted 292 pages of his legal treatise to historical, theological, and scientific arguments, while only 252 pages of the book offer some semblance of a legal analysis. This is illustrated by the fact that the first several pages of The Law of Negro Slavery, the actual treatise portion of the book, continues using non-legal arguments like those found in the previous historical section. For example, chapter 1 consists of a philosophical discussion on the natural history of slavery, and chapter 2 provides an in-depth examination of the Bible and slavery's justification from a theological standpoint. If one were to consider legal treatises as idealistically objective, comprehensive summaries of a particular legal topic, Cobb's treatise is difficult to be viewed as such through a 21st century lens. In reality, it is an unabashed racist promotion of white supremacy disguised as a piece of scholarly legal work. Far from being a nonpartisan tome of truth and legal objectivity, Cobb's treatise is a full-throated defense of slavery. In April 1858, having completed The Law of Negro Slavery, Cobb wrote to his brother Howell, quote, "My object is circulation and notice. Then if the book fails, it has no intrinsic merit." The doctrinal aspects of Cobb's treatise and its corresponding relationship of slave law to the antebellum South has been thoroughly examined by legal scholars. However, no one has attempted to view Cobb's treatise through the lens of book history, specifically in the way its legal ideas were transmitted. The production of Cobb's treatise was the primary building block in creating his vision of a pro-slavery legal education. The treatise's dissemination and reception followed suit in the founding of the Lumpkin Law School, and the book's subsequent distribution among students and the greater Southern legal community. To be sure, when Cobb spoke of the educational wants of Georgia before his fellow Franklin College alumni, he certainly believed that a pro-slavery legal education was very much wanting. His treatise was meant to fill that void. By March 1858, Cobb had submitted his manuscript to the T and J.W. Johnson and Company publishing firm in Philadelphia. In October, it went on sale at White's University Bookstore in Athens, Georgia. Now, at first glance, it may seem odd that Cobb would choose a northern publisher for his treatise in defense of slavery. However, it should be noted that no legal publishing firm was ever established in the South, and by the middle of the 19th century, T&J.W. Johnson Company had become one of the leading law book publishers in the entire country. Additionally, the economics of law book production at the time required more of a guaranteed number of sales prior to production, often through subscriptions, and treatises generally could be only expected to sell to lawyers. To his advantage, Cobb not only was a well-known attorney, he had a captive customer base with the Southern legal community that assured T&J.W. Johnson and Company a number of book sales. Compare this with the works of fiction or religious tracts, where the publisher had a more amorphous customer base and sales were not guaranteed. With this bibliographical understanding, it's likely that Cobb chose a Northern publisher by design. Once the book was printed, bound, and copied in Philadelphia, he was able to bring it back to Georgia, where it could be made available for purchase by his law students. In general, small-town booksellers such as White's University Bookstore solely operated as retail sellers and rarely as publishers, simply because they did not have the resources to do both. It was the large urban publishing houses that supplied these smaller booksellers with the stock they needed to make money. Many of the first persons to read Cobb's treatise were likely his own students. As stated before, after awarding himself a faculty position, Professor Cobb assigned his legal treatise as required reading. The Lumpkin Law students that bought their copy of Cobb's treatise at White's University Bookstore joined a long tradition among aspiring attorneys. Since the early days of the profession, books have been essential to lawyering. Whether lawyers learned their trade through apprenticeships or by attending law school, the dissemination of legal education came from the printed word. For individuals like Cobb, who learned the law via apprenticeships, or those who were given the opportunity to attend law school, treatises were central to a student's legal education. As American law developed in the early part of the 19th century, law schools needed more law books written by American jurists. Moreover, students who were trained at university law schools were taught to continue to use law books once they got out into practice. Also, as law schools began to grow in popularity, it can be assumed that students in apprenticeships also began to read more law books. In this context, then, Cobb's treatise, and by extension, the pro-slavery education that it expounded, reached both formal law students and law apprentices, and had the potential for the lasting impact in the future careers of Southern legal professionals. In addition to selling his treatise to law students at the Lumpkin Law School, Cobb also sent complimentary copies to various state governors, cabinet officers, and Supreme Court justices. Bibliographically, it would be extremely valuable to know the names and how many of these students, public officials, and judges obtained copies of Cobb's treatise. However, very few business records of antebellum law book sellers and publishers survive. Like most business records, they simply have been lost to time. Ephemera, such as catalogs, can still be found on occasion, but they too have not been widely preserved simply because they are ephemera. We can only assume that Cobb's purpose in sending copies to these policymakers was to educate them on what he saw as the one true body of law to be applied in the national contest between pro and anti-slavery forces. As one of our panelists today, Professor Hoeflich, has pointed out, quote, that the key to establishing the law as a prestigious profession lie in making lawyers learned, lies at the heart of why the history and production of law books is so crucial. Now, I think that we can all agree that creating a group of pro-slavery educated lawyers is far from prestigious, but the history of the production and distribution of Cobb's law book is no less crucial to the history of the treatise and its relation to American slavery. The law of Negro slavery provided the authorities that pro-slavery lawyers could cite in their pleadings to persuade judges and juries that slavery was consistent with the law. It provided the authorities and doctrines by which judges could decide in favor of the ruling Southern slaveocracy. It provided the materials for scientific legal education at the Lumpkin Law School, and it provided a means by which future Southern law professors and lawmakers could establish their reputations as experts and leaders in their profession and build a new pro-slavery American jurisprudence. Cobb successfully created a pro-slavery legal education through the production of his treatise and its dissemination to his law students in the wider Southern legal community. However, the impact was short-lived. Dwindling enrollment due to students enlisting in the Confederate Army at the beginning of the Civil War forced Lumpkin Law School to close its doors in June 1861. The law of Negro slavery, in large part, became moot with the passage of the 13th Amendment in 1865 and the resulting abolition of slavery. Yet, the historical record shows us that Cobb had plans to continue his bibliographical fight against Northern abolitionists with a pro-slavery legal education of the Southern bar. Cobb never got the chance, however, to write his volume 2 of his legal defense of slavery. Fortuitously, he died at the Battle of Fredericksburg in 1862. Struck in the thigh with artillery shrapnel, he was taken to a nearby field and slowly bled to death. What then should be the legacy of Thomas R.R. Cobb and his legal treatise? Perhaps for Cobb, his lasting effect is found in the Cobb House, one of the academic buildings at the University of Georgia that still bears his name. Perhaps also his legacy is captured at his home in Athens, Georgia, now a museum, that describes him as, quote, lawyer, author, educator, politician, military leader, slave owner, defender, and promoter of Southern nationalism. One could make the argument that the treatise's legacy is found in the current day bibliographical and educational battle being waged at both the national and state level. Several parallels can be drawn between Cobb's white-centric educational wants and today's fight for control of books in public libraries, classrooms, and even the inclusion of entire curriculums such as critical race theory. To be sure, the law of Negro slavery can certainly be viewed through the modern scholarly lenses as offensive and anachronistic. However, its importance as a legal treatise cannot be overstated. As a single title, Cobb's book helped change the course of American history as it provided the legal justification and rationalization for the institution of slavery. Its true legacy is that it needs to be recognized as evidence that the production and dissemination of information can be used for either justice and equality or injustice and oppression. And it is hoped that the purveyor of legal information will take the latter course. Thank you.
Thank you, John. And our final author is Simon Stern. Simon is the professor of law and English, director of the Center for Innovation Law and Policy, and chair in innovation law at the University of Toronto Faculty of Law. The title of his paper is The Treatise and the Human Figure.
Thanks to Nicholas and the other librarians, and thanks also to Wes Oliver, who sent me the CFP for this conference, which I otherwise would surely have missed. My argument is a simple one that relates to the fortuitous effects of timing. The paper considers two examples involving incarnations of the reasonable person, or more precisely, two instances of personified standards, which helped to account for the reasonable person as we now know it. I emphasize the point about personified standards because so few legal standards take the form of a human figure. Standards are almost invariably abstract in their formulation. Undue burden, probable cause, dangerousness, substantial similarity. These are typical of the way we normally express a legal standard. And when dwelling on examples of personified standards, jurists tend to exaggerate their number and variety. So, for example, in a decision from 2014, a British judge writes, "The Clapham omnibus has many passengers. The most venerable is the reasonable man who was born during the reign of Victoria, but remains in vigorous health. Amongst the other passengers are the right-thinking member of society, familiar from the law of defamation, the officious bystander, the reasonable parent, the reasonable landlord, and the fair-minded and informed observer, all of whom have had season tickets for many years." Notably, the many passengers reduced to 5 or 6 in total, hardly amounting to a crowded bus, and several are simply variants on the reasonable person. That is, they function just as it does, achieving the same result while specifying the context more precisely. The point is significant because people tend to engage with personifications in qualitatively different ways from abstractions. When a legal standard takes a human figure as its mode of expression, those tasked with applying the law may be inclined to identify themselves with the standard in a way they would not when contemplating and applying an abstraction. So in the case of the reasonable person, they're likely to start by associating themselves with this figure. I'm a reasonable person. And even to the extent that they understand that it doesn't end with that, the fact that it begins with their thinking that way, I think is significant because it would be most unlikely for a person to engage with an abstraction like undue burden or dangerousness that way. This may be the desired effect, but when we consider that this dynamic has not received much attention, it remains open to question whether judges have systematically adopted personifications when seeking to encounter such identification, and have systematically avoided them when seeking to discourage that tendency. So, on to my 2 examples. The first one comes from a 1703 fraud case, a case so simple as to seem almost like a parable for an age of capitalism. A man borrows 20 pounds. A fraudster appears, presenting himself as an agent of the lender, come to collect the debt. The chump pays up and discovers his error at leisure. The Queen's Bench declines to convict, holding that the deceit is not a crime unless it involves, quote, such a cheat as a person of an ordinary capacity can't discover. It would be another matter if the defendant had come with a false token such as false dice. These are crafty enough to deceive even a shrewd person. Here, the victim should be left to reflect on his own folly, says the court. This is an indictment to punish one man because another is a fool. Let it stay. That is, let the harm rest where it occurred. The case is covered by 3 different reporters, but the line about the person of an ordinary capacity appears only in the modern reports and might have been entirely forgotten if William Hawkins had not included it and reinterpreted it in the first volume of his treatise on Crown Law, published 3 years later in 1716. So Carlton Larson referred to Hawkins in his paper. The first volume appeared in 1716, the second volume in 1723. I'm just concerned here with the first volume. Hawkins writes, a false pretense of having a message to collect a debt is not punishable by a criminal prosecution because it is accompanied with no manner of artful contrivance, but wholly depends on a bare, naked lie, and it is said to be needless to provide severe laws for such mischiefs, against which common prudence and caution may be a sufficient security. It was Hawkins's version, and not the formulation in the modern reports, that would catch on. Common prudence and caution would be repeated in the case law and the treatises over the next century and a half until a different way of approaching the problem would catch on. And as will be evident, common prudence and caution are very much the characteristics that would be associated with a reasonable man in tort, as that figure developed across the 19th century. In fact, though I don't make this point in the draft, the reasonable man did not become the canonical form of the standard until the early 20th century. Throughout the 19th century, jurists spoke of the ordinarily cautious man, the man of ordinary prudence, and other similar variations. And so when these treatises and cases didn't cite Hawkins directly, they cited some of the decisions that cited Hawkins. So by the time the law of fraud had abandoned this approach, the language in Hawkins's formulation had had a long time to circulate and to resonate and to plant the seed of a thought that would grow in other legal domains. Hawkins had captured the person of an ordinary capacity and reformulated it at a fortuitous moment when it might simply have vanished. And so Paul Callister referred to Nimmer's treatise on copyright earlier. Here with Hawkins, we can see sort of a similar thing. He has his own way of formulating it. That's what catches on. And then later, when treatises refer to it, they'll cite, say, this case from the 1760s that cites Hawkins, so that just as Nimmer got his own treatise into the cases and then cited cases that cited him, one sees a similar effect here where the treatise canonizes a formulation that then is adopted by the courts. My second example comes almost exactly 200 years later. Scholars and judges who refer to the man on the Clapham Omnibus sometimes drop a note to the 1903 case from which it derives, the defamation case of McQuire against the Western Morning News, but few seem to have read it because one cannot read the case without wondering how it could possibly have sponsored the current use of this bus passenger as a synonym for the reasonable person in tort. McQuire involved an irate playwright who sued a journalist over a bad review. The jury had sided with McQuire and awarded him £100 damages. The appellate court reversed, explaining that to qualify as fair comment, the reviewer's criticisms must be relevant and must not disclose itself in must not disclose in itself actual malice. The question was, quote, not what the ordinary reasonable man, the man on the Clapham Omnibus, as Lord Bowen phrased it, would think a correct appreciation of the work. That is to say, it was irrelevant what the man from Clapham thought. Hardly a propitious start for a new legal personage, one might think. Again, the phrase might have been quickly forgotten. But within 5 years, George Spencer Bauer's treatise, A Code on the Law of Actionable Defamation, rescued the phrase from legal oblivion and equated it with tort's reasonable man. So this is a long quotation from the treatise. There are several departments of the law where the general understanding or the average opinion or conduct of mankind must be appealed to. The law in the field of negligence demands such care and caution as would characterize the prudens or diligence. In the law of defamation, where everything depends on the sense which the matter tends to convey, i.e., which it naturally conveys, it is impossible to avoid an appeal to an imaginary being who is supposed to represent ordinary or average humanity. This normal person is the man of the world, or as Lord Bowen on occasion terms him, the man on the Clapham Omnibus, though it is difficult to see why Clapham should have been selected as the seat and citadel of the normal. And I might just mention, this man on the Clapham Omnibus is nowhere found in Lord Bowen's writings, but was a journalistic usage of the previous 50 years to refer essentially to a white-collar government clerk working at the Treasury or a similar department. Bauer expropriates the legally irrelevant figure of the McQuire case and gives him a starring role. Blending the descriptive and the normative, he refashions this figure as, if not exactly a hero, then at least an icon. In this instance, Bauer's treatise was something of a way station on the path of this figure's legal development. Nearly 20 years later, in a series of journalistic character sketches by A.P. Herbert and Carlton Kemp Allen, this series of sketches would popularize the idea that the reasonable person standard could be viewed as an aggregate of the many actions this figure performed in a range of tort cases, all of which could be assigned to the man on the Clapham Omnibus. It was in the wake of these contributions that judges and law professors started to recite the phrase when speaking of reasonableness in tort. In time, the figure would acquire an international notoriety, giving rise to such variations as the traveler on the London Underground, the person on the Yonge Street subway, the man on the Shao Kei Wan tram, and the person on the Bondi bus. Both of my examples testify to the power of a treatise to circulate an image, a formula, a conception that may turn out to structure our thinking in unanticipated ways. I observed at the start that we have relatively few personified standards in law, and that judges do not seem to have given much conscious thought to the effects of personification. If you were to ask a judge, lawyer, or law professor whether it's just the same to speak of a reasonable person or reasonableness or reasonable steps, you'd likely be told they're all fungible and they all carry the same meaning. That answer would be consistent with the way this figure developed. Our adoption of a personified standard seems to have come about largely by accident and in no small part as the result of its chance adoption by treatise writers.
Thank you, Simon. So I'm going to be that moderator and ask some questions of the authors, and then I'll turn it over to attendees here in the room. And could one of my colleagues take the microphone when we turn to attendees and walk around with it? Sorry, just or Paul, you don't have anyone. Okay, I think Mike can do it. Okay, great. Okay. So my first question is to Jane and Wick, and I thought it was interesting because you sort of have this hesitation about empirical, but I almost think there's something like phenomenological about what you're doing or your project. But my question is, your paper suggests that conservative justices cite treatises more often than liberal justices do. In the course of your research, did you observe that there are sources that liberal justices cite more often than conservative justices? And do you mean to suggest that the treatise is, broadly speaking, a conservative genre of legal literature? Conversely, are, for instance, law reviews a liberal genre of legal literature in the judicial context? And I know conservative and liberal are such problematic kind of broad labels.
I can take the first stab at this. We often found the justices on either side of an issue citing the same treatise, but citing different chunks of the same treatise. So no, I can't really say that there were any particular treatises that were favored more by one side than the other. The point about law review articles is really quite interesting. And I think if we could have included any other kind of secondary source in our research and still stay true to the topic of the symposium, we would have swept those in too, because there were a lot of what I would think are, I don't know if controversial is the word, but sort of avant-garde conclusions that were reached based on law review articles. And I found it interesting that there would be so much reliance on that. But again, it's not something we can comment on for the sources of the paper. What was the second half of your question?
Oh, just whether legal treatises, broadly speaking, like the genre of the legal treatise, is it a conservative genre?
I would say no, not from what I saw. Absolutely not. I saw both sides. Wick, did you want to add anything?
Yeah, I mean, I'll say something about like the gun rights section, which is forthcoming. It was one of the more interesting ones because it was the sole civil rights section that we looked at where every case treatises were cited in every part of the opinion. And in many ways, they were kind of like, as sort of Jane sort of hinted at this point, dueling treatises where the justice would cite something in the opinion, in the majority opinion, and then the dissent would cite to a different section of the treatise or a different treatise saying a different thing. So in essence, trying to undermine the authority of the treatise by saying, here's another treatise that says a different thing, or here's the other section that says something different. So I think that speaks to the fact that it's, I don't want to say opportunistic, but I think that both sides use them to their advantage.
And John, in reading your paper and listening to your talk, my mind turned to the fact that John C. Calhoun, Yale College graduate, class of 1804, attended Tapping Reeves Law School in Litchfield, Connecticut. Reeve, from my understanding, was a proponent of gradual abolition and author of one of America's first treatises, The Law of Baron and Femme, later called Reeve's Domestic Relations, which subverted the institution of chattel slavery by suggesting that the rights of an enslaved person were the same as those of a servant, that is to say, an employee under the common law. When Cobb said, we want Southern textbooks, do you think he was reacting against treatises like Reeves rather than, or in addition to, popular abolitionist texts like Narrative Life of Frederick Douglass, 12 Years a Slave, Uncle Tom's Cabin?
Good question. Thank you. I think he was reacting against not so much, the literature, the anti-slavery literature I talked about. But in 1827, George Stroud published a legal treatise called A Sketch of the Laws Relating to Slavery. And it was a legal treatise, but it wasn't as comprehensive as Cobb. So Cobb looked at the slave laws in the North, the South, the slave laws in foreign countries. He looked at international law. He has half of it is this, historical sketch of slavery through time. So Stroud, it was not as comprehensive as Cobb, and actually Cobb even addressed Stroud in his preface. Says, I enter upon an untrodden field. Stroud's sketch of the law of slavery is and was intended only as an abolition pamphlet. So like right out the door, he just totally disregards Stroud as, an anti-slavery legal treatise, which I would argue that it was. It was a book-length treatise on at least analyzing the slave laws of the South. Even though he didn't really analyze the slave laws of the North or internationally. So, yeah.
And Simon, reading your paper and listening to your talk, I observed there's sort of on the one hand, there's the egalitarian and democratic rhetoric of the reasonable man standard. And on the other hand, there's the process through which it was formalized via the treatise, which would seem to be a rather elitist and hierarchical genre of legal literature. Is that a fundamental contradiction in your mind or not?
So that's a very good question. What I'd say is that while the standard was developing, at least through toward in the 19th and early 20th centuries, it was actually not clear whether they were thinking of it in egalitarian and democratic terms or not. The Clapham formulation in particular is striking because although it's in some strange way by the judge who introduces it into legal discourse, it's attributed by him to another judge. As I mentioned, it actually did have a particular journalistic use, which was freighted with normative meaning. And what I speculate, this is really just a guess because it's hard to tell. What I speculate is that this judge in 1903 was familiar with these journalistic uses, misunderstood them as referring to the average or typical person or the average or typical man, but was at some level nevertheless aware, because of the way that he'd encountered it in journalistic prose, that it described this white collar father living with a family in Clapham who didn't want to raise his family with the citified influences, etc. So I'm kind of inclined to think that even within its legal use, it already carried this sort of double meaning in which it referred to the typical while encapsulating a number of norms, which might therefore suggest that it was already freighted that way as it was developing.
And now we'll take questions from attendees in the room. Great.
So John, I've got a question for you and then I've got a comment. The question is, was Cobb accurate in the not pro-slavery, in the aspects of slave law that would have allowed things like manumission and things that would have actually allowed for freedom? Did he accurately report those things or did he skew those?
Oh, this entire book is skewed. Yeah, this is far from being objective in any legal sense. He did obviously take the cases and the statutes south of the Mason-Dixon and use them to his advantage. And then when he analyzed the cases and the statutes in the North, especially the cases, he said, well, this is what the Northern courts are deciding, and let me tell you why they're wrong. And then he took the decision and very much skewed what the court actually held to his advantage.
Because there were a lot of cases I remember from a long, long time ago when I was reading this stuff, from like even like the Deep South actually had some of the best laws on freeing slaves. It was the Upper South that had like the manumission laws, like if you were to, go into another state or whatever.
Yeah.
The Deep South, did he misrepresent the Southern laws as well that would have allowed for manumission?
Yeah, I believe that is correct. Yeah, and I can't remember. There were so many cases and statutes that he analyzed.
Of course, yeah.
But yes, that's very true.
So then the other thing is it's kind of a comment, and as someone who grew up in Virginia and obviously hates our past about this and hates all the monuments and that kind of thing, when you said his legacy is this building at the University of Georgia, there's a nice story I want to offer. I don't know if you know about this or not, but for anyone who's watched the University of Georgia football game, which is like now pretty much all of us because of the various national championships, their fight song. Their fight song is what we know as the Battle Hymn of the Republic. That's not the original set of lyrics to the Battle Hymn of the Republic. That the original lyrics to that come from Stephen Vincent Benet's poem John Brown's Body, that was set to music by the Massachusetts 54th. The all-black unit from Massachusetts that's profiled in the movie Glory. So, and I actually, when I was getting ready to make this comment, I Googled this, and it turns out that unwittingly, the University of Georgia adopted the lyric or the melody to John Brown's Body when they rewrote their fight song in 1915. So I like to think that unwittingly, the legacy at Georgia on at least something, the thing that they're the most proud of, their football team, is about the abolition of slavery. And I don't know that and actually the thing that I just read suggests they didn't have any idea that's what they were doing when they adopted that melody.
Historical irony.
Absolutely.
I would just mention Benet is a graduate of Yale College and wrote The Devil and Daniel Webster, one of the best short stories of all time.
Hi, I'm Ann Kleinfelter, and I have a question for Jane and Wick. I've been thinking hard about this ambitious project that you're doing, and a lot of what's being presented here, and I'm super curious about the scholarship that's coming out now about, and it has been for a while, about originalism and legislative intent, and these traditions of looking at documents like treatises as evidence of what? We're sort of talking about what cognitive authority these treatises have. And so it seems to me, since you invited a suggestion, that while you have so much here, you might even select one of the categories and go even deeper and categorize in whatever way you want to, or following some other scholars who are doing a lot of work of categorizing types of originalism and that sort of interpretive categories, and think about what you're finding and see, and maybe you develop your own, I don't know, but I think that would be super interesting since you've done all this work already about identifying a corpus.
I'll say, I think that speaks to part of what we were talking about when we were actually looking at what is a treatise also, because we started off thinking that we should be only looking at things that are really descriptive instead of normative. So basically, bodies of works that describe what the law is. So an argument that, again, I've looked at the case law, gathered up the statutes. This is how we're describing what the law actually is. But we ended up stretching it out to include some things that were a bit more normative because they kept on getting cited as historical evidence of, this is what people were debating at the time. So the Federalist was probably the prime example of something that we looked at. And we're kind of like, okay, so is this, can we look at this from you were kind of mentioning an originalist perspective where it's sort of like, okay, this is a debate. They're talking about exactly the Federalists themselves, and then the Federalist Papers are sort of debating each other, and then there's the anti-Federalist Papers as well. So should we be including that? And because it serves such a basis for what people refer to as, this is the historical evidence of what the founders, quote unquote, were thinking, this is what we should be arguing, and this is how we should this is why we need to alter precedent. This is why we need to set this precedent. So that was part, like that sort of concept was part of our initial discussion in terms of like what we were trying to do in terms of defining the treatise. But thank you for that suggestion, because the gun rights one might be the perfect one to do for that for.
I'll also add that there were a lot of resources that we really didn't know how to categorize. Like there were some remonstrances that kept showing up in this body of literature. And I think they were by Jefferson, and, you know, what was he remonstrating about, and started looking deeply into that. And we would end up sort of in analysis paralysis about where do we take this, because what you include and what you exclude changes the entire focus of what you end up doing. And the other thought I had later is that I would really love to do something that is replicable, you know, something that someone else could look at and maybe see from a different way based on the same criteria, which is why I was thinking maybe just a date cutoff as opposed to a type of resource cutoff might make sense.
Hi, my question's for John. I'm just wondering what the Cobb Treatise, what authoritative weight it had, if ever, if any. Was it used in courts? Did judges take it as an authority, or was it more a work of propaganda, or, as you said, an educational tool?
Good question. So between the time it was published in 1858 and at the end of the American Civil War, it was cited 7 times, all by Southern courts during the Civil War. And then after the war, it was cited a couple of times during Reconstruction. And then the most recent, it was cited, was 1965 by the US Supreme Court. And I think it was simply just used as kind of background information. But certainly it wasn't given any serious authoritative weight. Yeah.
Any other questions? Oh, Paul.
I'm sorry, I have so many questions. John, I was particularly struck with how our cognitive authority in the treatise can be corrupted, and found it akin to the work of Hans Frank, who was Hitler's defense attorney to later become director of the German Academy of Justice, charged with rewriting the law in a socialist, Nazi socialist framework, where the Führer would be a legal concept and expediency of execution of the state would be most efficient. As an attorney looking at some of that literature, I was chilled because there would be definitions of Jewish partnerships or corporations or entities that remind me of what I was working with when I did corporate and tax law. And Hans Frank eventually ended up being a short duration. He became the Oberleiter, or maybe that's not the right German word, but the governor of Poland, and was executed at Nuremberg. And a special Library of Congress mission after the war seized Nazi libraries and scattered the materials around a few libraries, including the University of Illinois, where I started my career. And I learned about the literature. And anyway, so the law often has been used for corrupt ends, but I wonder how long it can be sustained when it is used in a corrupt end. That's just my point. It wasn't a great question. It was the point. Sorry.
It's a great point. Thank you.
Any other questions? Okay, that concludes the third panel.
Good afternoon and welcome to our Pinnacle panel, panel 4 about transition. So I am going to introduce each of our set of panelists as they prepare to present. And we're going to start with Kent Olson. And prior to retiring in 2021, Kent Olson was the head of research services at the Arthur J. Morris Library at the University of Virginia School of Law. The title of his paper is Citation of Treatises and Law Reviews, Blue Book, and Reality. And he has some special presentation features for us.
Okay, have I shared yet? You are? Oh, okay. I'm off screen now. They can see you. Oh, anyway, I've already thanked Nicholas. The people I want to thank are our wonderful webinar viewers. I know you can't ask us questions, but if I could see a show of hands, how many of you have been with us since 9 o'clock this morning? Great.
I see a lot of hands.
Great. Oh, a lot of hands. Virtually everyone. Great. Thank you. Okay, it's our last panel. My paper, Citation of Treatises and Law Reviews, Blue Book and Reality, it's about citation, but maybe it's also about how treatises are used and how they're perceived in 2023.
Test. Okay. As a librarian, I tend to read the footnotes more than the text when I look at a law review. And I noticed something about treatise citations that they just didn't seem to be making sense. And it seemed like very few people were indeed looking at the books, authors or law review editors. So what I did was an empirical analysis over a 10-year period and looked at the citations to see if I could figure out whether anyone was actually looking at the print treatises. And to give away the answer, almost half of the citations that I found had some sort of error, either the names of the authors, the date of publication, something that convinced me that authors and editors were doing all of their work online. And my point here is not to shame law review editors into going back to another era, but to urge that the Blue Book, edited in part here in this building, is updated so that it accords with how legal scholarship is actually conducted in the 21st century. So, I have control of this. Let's take a quick look for starters at how the Blue Book mandates citation of treatises. Rule 15 of the Blue Book covers books, treatises, etc. And you'll see that the main example in the Blue Book is a textbook on organic chemistry. Wouldn't have been my first idea, but there it is. And this is the basic rule for citing a treatise. It doesn't give you a lot of help. There is a treatise does rear its little head. I apologize for this. It's very tiny, but the Federal Practice and Procedure Treatise does rear its head in the next section on authors and how to cite authors. The rule here says cite only the author associated with a particular volume. And then down the bottom half of this slide is a rule allowing people to cite an online database. But the rule in the Blue Book basically says you can add a site to an online database, but follow the rule for citing it in print and then go ahead and tack on an online database, basically. So it's not really all that helpful. There's not a lot of guidance on citing treatises as a distinct form of literature. I took a look through the Blue Book, through the whole Blue Book. The whole current edition has just 13 examples of how to cite a multi-volume legal treatise. On the other hand, the Blue Book has 33 examples of how to cite a student note or comment. So, it's not hard to tell where the focus of the Blue Book editors might be. So my research involved the two leading treatises on federal practice, Moore's Federal Practice and Wright and Miller, Federal Practice and Procedure. I looked at citations over a 10-year period. And I did my work in Westlaw, so I was able, using the citation form, to just retrieve the first citation to one of these treatises from each article. So there's only one citation per article, but I ended up, after getting rid of false drops and citations to treatises and other sources, with 408 articles that cited Moore's and 2,096 articles that cited Wright and Miller. I'd like today to focus on the Wright and Miller citations. There were a lot more of them, and they were a lot more helpful for what I wanted to look into. I looked primarily at two sticking points in citations. One was the names of the authors. One was the date of publication. If we look at authors in Wright and Miller, it gets a little tricky. It's known as Wright and Miller after its two primary original authors, but different volumes are written by different people. This is volume 3. The spine of volume 3 in print on the left is by Charles Allen Wright and Sarah Welling. On the right side of the screen, you see the same, one of the sections from this volume as it appears on Westlaw, attributed to Sarah Welling. Charles Allen Wright died in 2000 or 2001. At this point, his name is still kept kind of above the title as the main author, but the book has changed considerably since Charles Allen Wright's time. So my next slide here, 2,096 citations to Wright and Miller. Of these 2,096 citations, about 5.5% cited Westlaw or cited a date that they said the source was updated, which is Westlaw's term for the date. And those, I eliminated those from my analysis because, I guess I gave them a pass, that they didn't need to, they weren't pretending to look at the books. They weren't giving us a date, a publication date, according to the basic Rule 15, cite the book and the publication date. Of the other citations, the nearly 2,000 citations to print, more than 22% had the wrong authors. In other words, if they were citing this volume by Wright and Welling, they were citing either Wright and Miller or Charles Allen Wright et al. Or something that showed me that they were looking at the Westlaw database, but they weren't looking at the print. And more than 40% had the wrong date. A lot of them had maybe the date they looked at it online, the date Westlaw listed, or a date they got from some other source. But 40% could not nail the publication date of the volume that they allegedly used. Combined, the sources that had either the wrong author or the wrong date was 48%, or nearly half of all the citations. I also took a look at whether it made a big difference if Wright and Miller was available on the shelves of the library at the law school where the journal was published, and it made some difference. Not a lot. 63% had an error if the school didn't have a current edition of Wright and Miller, but 47% did have. 47% of the libraries of the schools where the library had a current copy available on the shelf still had an error. A couple of trends that I would just point out. Citation to an online source, citation to Westlaw, was close to non-existent at the beginning of the 2010s, 2012, 2013, not very few at all, and it's arisen in more recent years. So now about 10% of articles cite to Westlaw. Errors have also risen over the same time, about 40% at the beginning of the decade, rising to over 60% in the most recent years. Note that there's a COVID surge here. There's a home, there's a distance learning surge in 2020 from 60 to 65% or so. But even before COVID, by 2018, 2019, we're looking at well over 50%, close to 60% citations with some sort of error. Who cares? Why is this guy picking these nits on Wright and Miller citations? It doesn't affect how you can, doesn't affect whether you can find the source. It doesn't affect, if you have a citation to Federal Practice and Procedure, section 511, if you want to track that down, you can still find it. It doesn't really matter if there's an error or two in the citation. Well, there are a couple of things. First of all, treatises are getting harder and harder to find on the shelves of law school libraries. They're very expensive. Libraries are spending more on digital resources. There may be space constraints, and they're not used that much. So as libraries look for resources that they might cut, that's a good option. My next slide here shows academic law library holdings of Wright and Miller, as well as Moore's Federal Practice over time. Of 197 ABA accredited law schools, only 122 have a current set of Wright and Miller, about 62%. Moore's, only 77 libraries have a current set. That's under 40%. For an earlier draft, I also looked at Collier on bankruptcy as an example of a topical treatise, and that's only held in about 30% of the academic law libraries these days. And I would be willing to bet that other subject-focused treatises like that are doing even worse. This number has been dropping steadily. This is not a COVID distance learning issue. It's been dropping over the decade. Between 2011 and 2019, 41 libraries canceled their Wright subscriptions. 66 libraries canceled their Moore's subscriptions. So the option of print is getting more and more difficult to use, even if you wanted to follow the Blue Book rule. If you're at one of these law schools without Wright and Miller in the library, you would have to try to borrow or get a photocopy on interlibrary loan, which can be difficult. Certainly borrowing a copy of a major treatise like Federal Practice and Procedure, I'm not sure many libraries would lend that. The other thing is kind of a simpler reason. If half of law review editors are pretending to cite something that they're not looking at, then maybe something should change. So I came up with a proposed rule on citing treatises, a new subsection of the Blue Book 15.0.1 to fit nicely in there after books. And there's a couple of things here that I should focus on. The author is problematic. The authors that I found in citations came in all over the board. Not everybody included an author. I would include an author because treatise writing is not quite yet defunct, no matter what we've learned today. And it's still a scholarly pursuit. And I think the authors should get credit for their work. But as we saw in the slide of the book, Volume 3, and the Westlaw version of Volume 3, there are discrepancies. One is cited Wright and Welling, the other is simply cited Welling. I would cite it as it's found in the source you use. Blue Book, one cardinal rule of Blue Book is cite what you look at. So, even if it's different, it's different. I don't think that's to be helped. I would still include a volume number even if the volume number is not really necessary when you're using Westlaw. You can just type in FPP and a section number and go straight to a section. But the volume number is not quite yet anachronistic. There are people certainly who use the print source, so it helps them get to where they need to go. And it also, I think, gives some indication of the scope of a treatise. If you see volume 15 or 17, then you know that you're dealing with a fairly substantial work. The two things that are new and might be controversial here in my citation to a Westlaw treatise are, first of all, the lack of a date. In the 21st edition of the Blue Book, they took a baby step towards modernization by saying that a citation to the United States Code no longer needs a date. If it's a citation to the current code, you don't need to have a date. And I'm not sure any buildings collapsed or any horrors resulted. Somehow people, I think, were able to figure out, if you have an article in 2023 that is citing the United States Code, then that's going to be the United States Code as of about 2023. And treatises are, of course, not a primary source, but they're similar to codes in that they are updated regularly online. And if you track down a citation to a treatise online, you will get the current version. There is no archived version on Westlaw or on Lexis of a treatise. The old version is wiped out, goes off into the ether, and the only one that's available is the current version. With a treatise like Moore's Federal Practice, which is published in loose leaf format, that's doubly the case because there's also no archived version in print. So the date on a date in a citation isn't that useful because you can't go to that date. There's no archiving online. There's no, you might do something like a last visited such and such a date, but there also is no archiving. There's no Wayback Machine for materials in Westlaw or Lexis. Another possibility would be doing something like a perma, making a copy of a treatise section. But I know Paul's written about perma and copyright, and I can't imagine what the commercial publishers would think if their treatise materials were available out there in the, for everyone to see. So I thought of different options for dates, and I thought the date on the article really says what needs to be said. So there we have no date. Instead of having a date, though, I include a reference to the database source. I included that reference to Westlaw. One of the sad things about legal treatises is that they are not the least bit medium neutral. Westlaw has Thomson Reuters treatises, Lexis has Matthew Bender treatises, and very rarely do the twain meet. The major database systems have more or less the same cases, the same statutes, the same law review articles, but they definitely have each a distinctive and very separate body of treatises. This is a problem. This is a problem for open access. Amanda and others have written about, we need a new way of producing treatises so it's not locked up by these commercial enterprises, but it is. I mean, this is the current reality, so that's what I'm dealing with. It's not our ideal medium neutral world. One thing about having their own treatises online is that Westlaw will link to Westlaw treatises. Lexis will link in documents like cases and articles to Lexis treatises, and there's no link to what's on the other side of the fence. So, for example, a case on Westlaw, if it cites Moore's and Federal Practice and Procedure, there will be a link for Federal Practice and Procedure, but nothing at all telling you where Moore's is. Now, we know that Moore's is on Lexis, but I did a quick poll, a very unscientific poll of 40 students who were entering advanced legal research courses. So they were, eager, but unenlightened at that point in their lives. And I believe one of these 40 people, I asked them, where would you go if you were asked to do some work in a particular treatise? If a professor or a partner asked you to research Federal Practice and Procedure, how would you access that treatise? And one person would go to the library online catalog. 2 people would ask a reference librarian, and 37 people would go straight to Lexis or Westlaw. The problem is that of those people who would go straight to Lexis and Westlaw, none of them knew where a particular treatise was. Of the 40 people altogether, 20 said they had no idea which system had Wright and Miller or Moore's Federal Practice. Of the people that were bold enough to wager a guess, more people thought Wright and Miller was on Lexis, where it isn't, than on Westlaw, where it is. So if we are going to help researchers find material, I think we need to identify where the materials are. There's a problem. I mean, there are problems with this. If treatises are cited to online, if no libraries own treatises, they might become online-only resources. There is, as law journal editors keep us aware, there is a value in having a print publication, even if no one ever touches it. There's a sort of an imprimatur of, this is a valuable thing because here it is in print. That's why the law reviews, for the most part, won't go online only. There was an online only bankruptcy treatise that Bloomberg Law put out in 2014 to considerable fanfare, and to much smaller fanfare in 2021, they stopped updating it. So, there is this possibility that if treatises are online focused, that they might sort of wither in their cachet. I don't know about that. But anyway, this draft rule, I think helps to differentiate treatises from the mass of other books with which they're lumped now. I think it helps students, if we have a distinct rule for treatises, I think it helps students understand that these are particularly valuable resources, that they're accessible, they should be part of their arsenal of resources they use. Citing to online, I think, decreases reliance on the print treatises, which in more and more libraries are dangerously out of date. I would find citations to print treatises that would cite the version that was last updated in that particular library, even if it was 10 years or so out of date. So with apologies to Zephaniah Swift, to Joel Bishop, times change.
Thank you so much.
And you can go next.
Yes, thank you, Ken. So our next presenters are co-authors. We have Donna Neckshu, who is director of the Duquesne Center for Legal Information and the Allegheny County Law Library, and an associate professor of legal research at the Thomas R. Klein School of Law, Duquesne University. Also, Paul D. Collister, who's the director of the Leon E. Block Law Library and a professor of law at the University of Missouri, Kansas City School of Law. The title of their paper is The Persistent Treatise.
Hey Siri, set timer for 10 minutes. I need to give Dana time. I'm not Dana. We both agreed to have our hair done before we came to the conference today. And enough said as to who did better. Throughout my career, I have been concerned with the question, or an overarching theme, even though I've written about copyright and legal research and other things, but the overarching theme of how our information environment affects legal institutions, rule of law, legal education, etc. And this paper presented an opportunity to do that. Dana and I are working on a book together that covers some of these topics. And as I looked at treatises, one of the concerns I had was A.W.B. Simpson's critique that treatises were, and this was in 1981, would disappear because of legal realism, because we can't have treatises if we don't really believe there are principles or rules or systems that are in place. And two, because now researchers can do online, a technological issue. Now we can do online research of cases. So why do we need treatises? And so I thought about, how would we go about either finding evidence that was taking place, because there's still treatises around, or how would we determine that treatises were persisting? And persistence is a term often used in the information sciences to stress how a medium lasts over changes in time. So one of the things I wanted to point out was that we spent considerable time on a definition, if we're going to study treatises, of what they are. And we took Frederick Hicks, being loyal to our own profession, the definition on page 4, where we really start our work, as a beginning point. But at the same time, we felt, and you'll see in footnote 4, the need to further describe what a treatise is not, and what it is, and what it does, and the environment in which it operates. Part of that came through my efforts, as I was going to look at a lot of treatises, to figure out which items I would include and which I would discard. Now, I looked at over 2,500 items in the text and treatises on Lexis, and another 2,500 on Westlaw. And I had to make quick decisions, and probably some, so there's subjectivity heavily involved in what was a treatise and what was not. So I have a list of terms in Exhibit A or a list or description of rules of how I determined whether I would include something or not include something. So you can look at Exhibit A and see what was done. And Dana supported me in this. I also did something from my days as an undergraduate philosophy student, a heuristic that a professor imposed on us mercilessly that we had to do several times a week for a philosophy seminar. He was a expertise was in philosophy of language and believed in defining concepts. And he developed this heuristic that I always have found useful, and I still remember to this day. And so part of my definition, or our definition of treatise, came from that exercise, and we've included it as Exhibit C. It has no particular legal authority of any kind other than it's kind of a interesting heuristic and exercise to go through and to figure out what is a treatise, what would be the opposite of a treatise, what would be the counterfeit of a treatise. So all those things went into the definition. So some of you may take exception with that. You're welcome to critique it. I point out that we use a term called techne, and Dana will talk about this more, I'm sure, but we use it instead of technology because it was a broader philosophical concept that really referred to the skill and art, and not just the technology. That we have to, when we think about changes in technology and how they impact legal institutions, we also have to think about the institutions surrounding it, the social interactions, the mastery, the craft of creating a treatise, the environment in which they occurred, which has shifted from, as we've heard numerous times today, from law professors to primarily practicing attorneys or people that were attorneys. So techne is an important part of our piece and part of our definition. And treatises are part of a persistent techne and part of the cognitive authority of the profession. And that's the last concept, the cognitive authority, which I've borrowed from other sources. We've heard today, who is it? John, where are you? There you are. John quoted a cognitive authority, the same authorities I did. And I first learned about it from Bob Baring and thought it was absolutely brilliant because of my philosophical leanings. And so what do we trust? And I love this idea of cognitive authority in our profession may not be as simple as authoritative and persuasive. And in persuasive, we may have a scalable, not a hierarchical system, and that we need to take control of that as librarians and teach it and argue and teach our students the subtleties of that. I wanted to point out that Lexis has done something innovative. If you've seen our paper, one of the very first, I think the very first table, or it's actually an image, is of a screenshot from Lexis. And since spring of 2022, they have taken, I now have a footnote for it, it's not in your paper version. They have taken 170 different treatises and they now put them in the headnotes. So if you find a headnote on your case that's particularly relevant, you've got a link through right to the treatise. Why is that important? It says to me that efforts are being made to preserve the treatise, that it does have proponents behind it, to give it legs, to make it persistent. Going beyond that, getting to our actual, some of the empirical work, and I use that term loosely because I'm not in any way qualified, and I had to make a lot of subjective decisions. The way it worked was we wanted a significant body of work to maybe draw some generalizations. And we wanted to look at citations in all state and federal courts. We played around with different things and decided we really needed to do all state and federal. And we decided to go through the practice areas because it sounded too daunting to do all of them. So maybe the practice areas would help us limit them. They didn't really. They did some, but and so we went through the practice areas and down to the treatises and texts. And as I mentioned, I went through an enormous number and had to make relatively fast decisions. Even with the criteria I had for treatises, I had to run multiple searches for every treatise we picked to study, and there's 81. There were probably 4 or 5 that we didn't pick because they didn't have at least 70 citations. Why 70? It was just an arbitrary figure. My time is done. I will just close by saying this, that one of the things we discovered is when it comes to case law citation of treatises, there is an increase in the raw numbers of the 81 treatises. There's more instances of treatises that being cited more in a recent decade, the last 2 decades, than in earlier decades, the decades starting in 1960s, 1970s, when online searching was produced. However, if you look at it instead of just raw numbers, but you look at it in terms of a percentage of the cases that a court deals with on a particular topic, the same topic as the treatise, the number declines in courts and in briefs and in law reviews, except for, and we did all states and all Fed for the 81, except for the Supreme Court. And there we were able to just look at the top 10 because we didn't have time. And so we did this percentage study. And in the Supreme Court, surprisingly, we found not just in the top 10, but some others we looked at, that there was an increase, an uptick. And with that, I will turn it over to Dana. Do you want to do
Absolutely.
the chart?
Thank you so much.
Thank you.
So what do you get when a realist and a critical legal studies scholars get together? Today's presentation. So I'm very grateful to Paul because he's amazing. Please don't take him away from me. But the raw data he was able to look at and study the citations and the impact of quantitative data is phenomenal. The problem is I'm not as thorough as Paul. And for me, numbers are like, all right, but what do they mean? What is the meaning behind the numbers? And unlike Paul, who came up with a set of rules for defining treatises, I went to our friends at the Yale Law Library and I used Hicks. And Hicks' definition has something very interesting for my part of the speech. So Hicks talks about treatises from our perspective as technology. Technology for us is not the McLuhan, the Canadian take, deterministic, based on, sorry, no, I don't mean anything against Canada. I love Canada. It doesn't mean that technology is just the medium, although the medium, as Kent mentioned, has a huge impact on how we create information, how we disseminate information, and how we use information. So with Hicks, what is very interesting on page 152 of the first edition, which resides here in this magnificent library, and Nicholas, being the wonderful organizer he is, gave me a copy, says, Hicks says, a class, treatises as a class, treatises seek to set forth the law as it exists at a particular time. The closer they approach to this end, the sooner they become antiquated. And now I'm winking towards Justice Alito, wink, wink. So treatises become antiquated. they approach for while law at large develops slowly, it sometimes changes very rapidly in detail. So how do we manage to talk about treatises, even as a class, even as technology, as skill and authority, having an author, as Ken said? How do we use that? So that's why the work Paul did was daunting and amazing, because we're able to come up with something that we explain what treatises are. For me, even with the numbers, so we are happy, we're ready to, submit our proposal. When we went to the Supreme Court and we found out that in fact they are so heavily relying on treatises, we started thinking, what does that mean? Let's go and study from a qualitative perspective. Let's go and study the meaning of the words. So before I go to our, and I'm going to read from our work, I'm going to say thank you to a few of us presenting today, because indeed treatises are used to fill a hole, something lacking. Especially in Dobbs, Justice Alito refers to treatises as if something is lacking. So treatises are also, there's something special about them because they offer rational defense of a point of view. So at this point, at this moment, I'm going to be worried, because what we tried here, Paul and I, is to look at the rule of law from an objective, a neutral perspective. But if you tell me that you use treatises as a rational defense of a political point of view, I'm going to be very wary and concerned. And I'm going to say, I need to go further. What's behind that? And there were other mentions that are very nice, and we are going to add them to our paper. And our debt to Kent is going to be mentioned in the thank you note, correct?
Yeah.
So we are going to thank Kent. So the way we treated the use of treatises at the Supreme Court level was by looking at 3 sets of cases that overturned a precedent. So we looked at Plessy and Brown v. Board. I looked at the Plessy and Brown v. Board. So these are my mistakes if I made them. At Lawrence and Obergefell, and at Roe v. Wade and Dobbs. And what I discovered is that Plessy doesn't mention anything remotely related to treatises, no matter how you look at treatises. Brown v. Board, the same. You move to Lawrence and Obergefell, and you see our charts that secondary sources are being mentioned. You go to Roe v. Wade, and the word treatise per se is not mentioned, but secondary sources, which we can define as treatises according to Hicks and to our definition, are being mentioned. And we reach the level of Dobbs, and we are flooded, as many of you said, by the reliance on treatises. Now, as a learned person myself, I should have had a moment of eureka. Look at Justice Alito and I have something in common. I doubt that. But going further, I looked at how they were used. So how were these treatises mentioned, used by Justice Alito? And I have a wonderful quote here. So the quote, it's rather large on page 37. And Justice Alito relies on the great common law authorities, Bracton, Coke, Hale, and Blackstone, to evidence the common law tradition criminalizing post-quickening abortion. And I'm quoting, they all write that post-quickening abortion was a crime. My words, ergo, it is a crime. So they wrote, and it is evidencing. Perhaps the Dobbs quote below is the most telling for the treatise role in the current US Supreme Court jurisprudence. Quoting, We begin with a common law under which abortion was a crime, at least after quickening. Moving forward, the eminent common law authorities all describe abortion after quickening as criminal. Harry Bracton's 13th century treatise explained that if a person has struck a pregnant woman and so forth, that he commits homicide. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder. Moving forward, so I'm skipping. And writing near the time of the adoption of our Constitution, William Blackstone explained that abortion of a quick child was, by the ancient law, homicide or manslaughter. In Dobbs, in each instance, the persuasive authority of these early treatises is evident due to the qualifying adjectives such as eminent and the verbs describe and writing and explained. This use is within Hick's view of the role of treatises as summarizing the law, or what we describe as evidencing it. However, more intriguing is the Dobbs sentence following the rather impressive quote mentioned above. Quoting again, English cases dating all the way back to the 13th century corroborate, so the cases now corroborate the treatises' statements on abortion. Abortion is a crime. So until now, treatises explain, if you want, corroborate cases. Now we have cases corroborating treatises. Thank you for having a smile there because I'm getting so hot. I'm going to take my coat off. It's Justice Alito saying that the early treatises are authoritative beyond their persuasive role we all expect. Is the sentence mentioning primary official sources and cases a minor aberration, or is it telling of a new change in the US Supreme Court jurisprudence, where treatises are used to evidence tradition and as such minimize the disruptive effect of not following stare decisis, breaking with a cherished tradition of our common law system following stare decisis? The court in Dobbs does limit stare decisis in constitutional contexts. Quoting, we have long recognized, however, that stare decisis is not an inexorable command, and it is at its weakest when we interpret the Constitution. This is, I understand that Alito is trying to talk from the both ends of his mouth, but I don't think he is successful doing it, because you interpret the Constitution, it's the highest prerogative that the Supreme Court has to interpret it based on what? On precedent, or at least Justice Marshall said so in Marbury. Unless again, what's Marbury? It's just a case, it's not a treatise. So now moving away from Dobbs, unlike the use of treatises in Dobbs, so as you saw, I looked at 3 sets of cases. In Roe, treatises are used to evidence views and interpretation of the law rather than the law itself. The qualifiers in Justice Blackmun's opinion are more nuanced. The reasoning relies on the quoting predominant view following the great common law scholars. Coke's words are further qualified as taking a position which then Blackstone is shown to follow. Those treatise writers do not define what the law was, but in Blackmun's opinion, they opined about the law, interpreting it and leaving room for others to interpret it. Quoting from Blackmun, whether abortion of a quick fetus was a felony at common law or even a lesser crime is still disputed. Bracton, writing early in the 13th century, thought it homicide. But the later and predominant view following the great common law scholars has been that it was at most a lesser offense. And it continues. So our perspective, am I over? I have just one more thing, and I just made friends with Amanda. So you know how I work if you want to stay away from me. I had technology. So our point is, does Justice Alito use treatises as evidencing the law or as a way of interpreting the law? And what is the impact? Is this a change in how we perceive our rule of law. Because if we want to be neutral and objective, and I have to say that Paul does an excellent job in keeping me as neutral and as objective as I can be, I think Alito is bringing ideology and politics into play. And then it's fair game to say that we have to use Umberto Unger's definition of the rule of law. And I'm going to ask for more time to explain our marvelous work together. I'm done. Thank you.
Thank you both, Donna and Paul. Next, we're going to turn to Amanda Watson to bring us home. Amanda is the director of the Law Library and Assistant Professor of Law at the University of Houston Law Center. The title of her paper is Beyond Titles, Curating Relevant Law Library Collections.
Thank you, Anne. Is this okay? Yeah. Thank you, Donna.
Dana saving me as usual. Thank you so much, everyone. So I am going to right size this talk. If you haven't read my paper, I apologize for the dad joke and not do a very complete job. So let's talk first about completeness models. We've heard all day today about treatises and how small early law collections were, how few reporters we had, how few things were happening. And when we think about early law libraries in the United States, they were built on the model that if you didn't own it, you couldn't access it, right? So that's even been said multiple times today. If a volume was missing, right, you just couldn't have that area of law. So in 1876, we reinforced this by having a library report that stated out the number of volumes in different libraries. And then we sort of continued to do this, even though between 1870 and 1900, our population doubled and the amount of law went crazy. This is when our stacks were groaning. If we remember this morning, we're all, thinking about the groaning stacks. And the idea that a law library could be complete sort of became ridiculous, right? So even if we think of like the Library of Congress, which I often call like church for books, right? They're not going to be able to keep every single thing. That's just not really a thing anymore. But we continued to count in law libraries. The ABA required us to count. In 1921, they asked us to have an adequate law library. Then in 67, they wanted a minimum count. They continued to sort of move around and say, okay, let's quantify what that means, giving some indication that quality was important to them and not just number, but they kept counting until 2014. And that's when the ABA said, okay, we're not going to make you count anymore. But as all of us know, US News and World Report, which had happened back in the 90s, was still making us count titles, right? And so we were beholden to this idea of counting. But like Dana said just a few seconds ago, numbers, what's behind the number, right? A number by itself is not telling us very much. And so the idea that title and volume counts have been used as a proxy for quality is an idea that we should shelf, right? On a very groaning shelf and let it fall over. So I would like to offer this idea that libraries are not created equally, nor are we created on a scale. And what I mean by that is, though most of our faculty went to Harvard or Yale or Chicago, we are not all trying to be Harvard, Yale, or Chicago. And our collections should not look like the version we can afford to keep of those collections. Instead, they should be mission-based and reflect our own missions, right? And this is something that I call right sizing. So this morning, Professor Langbein said, I love the depth of the Yale Law Library collection. And I agree, depth is important, but depth and width are not the same thing. And in fact, the ABA would challenge us to have a deep collection and a range in collection. They intentionally choose that word range. And I think range means for some of us, that means a lot. And for some of us, that means not as much. So what do I mean when I say we right size? I want us to ground ourselves in assessment, which Anybody who reads my work knows that's basically all I talk about is assessment. And think about assessment not only in our selection, which we've all been doing for a very long time, carefully curating what we buy, but also carefully curating what we deselect, and really being as intentional about what we take off of our shelves. To go back to the idea that what people can access and use is what's important, not how many things we have. Right. So in this process of deselecting, then we can actually start to find things be more browsable, right? We can actually start to find things be more discoverable and accessible. Again, this morning, Professor Langbein said he thought publishers, he was talking about West, didn't use any kind of judgment, just publish it all. And I think we've become this way about keeping books. We don't tend to use our judgment. We just keep it all. And so our collections policies are truncated. We buy carefully, but we don't necessarily keep carefully. An easy example of this is you keep statutes. You have statute books on West, Lexis, Bloomberg, Free, but then I bet most of you also have shelves of selected statutes. Securities is a place that this happens, these soft bound annuals. It's not even commentary. It's just another replication of selected statutes. And the idea that that's meeting anybody's mission is pretty far gone, right? So let's focus on our mission, discovery and access, and that will help our focus. An idea that faculty often bring back to me is the idea of shelf serendipity. So everybody know what I'm talking about. So faculty will say, we've got to have these wide collections because in my brilliance, I walk in the room and I can just spot something and it really speaks to me. And I would like for us to pull back the curtain and say, that's ridiculous. A librarian created that shelf, a librarian bought that book, a librarian chose to keep it. There is no serendipity. There's hard work at play in that work. And by exerting our expertise, I think it also reveals our expertise to our colleagues, right? We're not just keepers of documents, we are curators of collections. So finally, I'll end and get us all to our happy hours and dinners by saying that assessment really is the key to this work. Assessment is not the same thing as collecting data. Assessment will look different for every institution, and it is just being in a cycle of continuously examining what you're doing and critically asking yourself if you're doing well. You will fail. Failure is a necessary and good part of assessment. If you're not failing, you're not doing anything, or you're at least not looking at what you're doing. So if we can kind of shake off this fear of having anything negative and instead be honest with ourselves and honest in our collections, then I think we'll do good work. I do want to say this, I think this is an alternative. I still think there are collections that strive towards a completeness model. I'm very thankful for them. We need them. I point out Iowa in this paper because they have a very clear mission statement where they talk about this idea of completeness. Thank you to those schools. And for the rest of us, let's enjoy right sizing. Thanks so much.
Thank you so much, Amanda. Thanks to all of our panelists. I as moderator, do have a question that I want to pose for the group, and then open it up for further discussion. So one of the things it seems to me that I've heard throughout the day is this theme of efficiency, that treatises were there to help us deal with this massive, incoherent body of law, to try to have something that would provide a meaningful, digestible, useful, usable, and relevant access to the law. And so I'm wondering, we're also hearing a lot about how the treatises have varied over time. Perhaps the demise is not so much what we're learning about, but as the change in the use, or maybe the change in authorship and just some changes in the treatise. But what I'm wondering how it is, and how they're cited as formats have changed. We're seeing a lot of, we're at the transition discussion here. What I'd like to ask you all is, how is it that law school libraries should promote discoverability and access to relevant treatises, because relevance seems to be, springing forward again, for even older materials? And how can law school libraries keep efficiency and that discoverability and access uppermost in our strategies? You want to start?
That has been, I'm glad you asked the question because it allows me to comment on something. Wright and Miller, federal practice and procedure, which Kent so beautifully studied. When I read his article, I realized I didn't get Wright and Miller in our study. And when I ran the numbers last night, I realized it's number one. It's the most, it'll be the top one of the top 10, which we did further studies on. And I asked myself, I felt bad, but then I asked myself, why did I not know about this? Well, part of it is because the vendors had, Westlaw doesn't have a civil procedure practice area. That's one. And because of my stupid rules, I had shied away from things that had the word practice in it, if I saw it at all, which I'm not sure you would see Wright and Miller anywhere else. I know there are other things like Goldstein on copyright. They're hidden. Even if you go into copyright on West, you won't find Goldstein on copyright, which after Nimmer is the most cited. So I think we are living in a time, especially as we go digital, because most of us just can't afford to keep these big sets. And the digital is decontextualized. You just see a link for a student that looks like anything else. That we have a real mission to play. One, advocating with vendors that they find ways to discover, like Lexis has done by putting treatises in headnotes. And I think we have a job with our students and faculty to do. Increasingly, it will be faculty to let them know about treatises. When I teach, I'll stop now, but when I teach advanced legal research, the students always come at the end and said, I had no idea how important treatises were. That's the statement I always get. I'm done, I'm sorry.
Thank you. Thank you for the question. I think these are wonderful times in terms of emphasizing the need for expertise, substantive expertise. And I was talking to Nicholas because, by the way, I'm the new director of the Boulder Conference. Please submit papers and you will have free drinks provided by Bloomberg Law. So expertise, that's how we are going to have, according to the mission statement, talking to our faculty members, like the wonderful Professor Wes Oliver, and he tells us what he needs for his work. I ask him what is an important treatise relevant to his work, and we try our best with the money we have to obtain at least one of the treatises that is necessary. I'm also trying to change the way we teach legal research and writing and ALR too, and trying to use the expertise we have and we develop. Like, for example, in copyright, we know also Paul has an amazing book on legal research, so he can do whatever he wants, but I'm teaching legal research writing and climate change law. And I hope that you can always come to me and tell you the most relevant treatise in climate change, Farber from Berkeley, or so forth. So, of course, Michael Gerard from Columbia too. We are going to have students learning about what is important from us when we teach legal research and writing according to whatever area of expertise we have and we own. So it's a lot about human expertise. And I love the question because we are going to remain relevant. So thank you.
Sure. So I think discoverability, if we make treatises more obvious, whether they're online or in print,
by cutting away some of the things that we're holding on to that are muddying the waters, and students are looking at them and thinking, these people don't know what they're talking about. This dusty stuff isn't any good. So why would we listen to them? And then the other thing, which is I'm sure controversial to say, is we disrupt the textbook market and really bring these materials into the eyes of students so that they can deeply understand things. And I've heard professors say, I don't want them to read the treatise. I want them to figure it out on their own, which I think is just sort of silly, and would love for us to use our influence to help bring treatises into case and material books.
Now I'm going to press you on this date thing. I'm terrified about these links to things that are not going to be there when you link to it, and then but we don't have it in print either. So I'm the only one. Am I the only one terrified that we're gonna? I mean, think about it. If treatises change over time, and we're like, anyway, sorry. But a good solution to just concede that and grow in the tone.
Treatises change over time. It's a problem. It's true, but having a date in a citation isn't going to help you. It's just going to help you. It's going to make you more frustrated, I guess.
All right.
I guess that's what I was thinking.
We have some questions.
Yeah, it's a great. I went in on the date. And the reason why I think with the code, you know when it changed. Wait, oh, sorry. I was sorry. I forgot there was another audience. I agree with Ann on the date, and the reason why is with the code we know when it changed. We can go back to earlier editions, and we know what happened. And the problem is if it's changed with the even with not pocket parts. I think a lot of us have had to search for like pages for loose leaves and to find out that Lexis and Westlaw just don't have them anymore. So, I mean, like you said, there's no record, but at least if we have a date, we know, and it's different in the past than now, we at least know that there's been a change. So
you would use the Westlaw's updated.
This is what I was going to put to you. You know how like the Westlaw codes and the Lexis codes have like they have a date like relevant. It's up to date up to this point, like a public law or something like that. Maybe you just have something like that. I'm sort of on the fence. I was going to say get rid of the author name too, because essentially a lot of treatises are brands now, essentially, like you've shown. But I think you pretty much convinced me that people are going to want. Like,
sorry, I'm not hearing you.
Oh, I'm sorry. I was on the fence about the author, about whether we should keep it or not, and I was kind of thinking, well, maybe we should get rid of it because they're just brands. But I think you made a convincing case that they they should be there because the people want.
Some of them definitely are just brands. I mean, some of them are, publishers, editorial staff, productions, but something like Federal Practice and Procedure is, those are law professors. And if we ever want law professors to write treatises again, then let's at least give them a site. Yeah. Yeah, the date is, I know it can be problematic. Maybe the Westlaw updated date is better. I just thought since you can't get the older version, and since since looking at all of these citations, so many people, a lot of citations didn't include a date. They just, they had a date that didn't make any sense, but you have the name of the treatise and the section number, and that's what you're going to use to find it. So, it requires, I guess, some intuition that the cover date of the journal, and I'm thinking specifically of law reviews as citing sources here. That's part of the issue. Is I'm thinking of the Blue Book for law reviews, but the Blue Book is used for other things as well. It sort of requires sort of an intuitive sense that if I'm looking at a journal article from 2018, then the sources are going to be as of 2018. And maybe that's a leap too far for most people.
Can I take organizer's privilege again to ask Amanda a question? Amanda, your comment about serendipity reminded me of a passage in one of Bering's articles where he says something along the lines of, we've sacrificed some of the greatest minds of our field to the LCC project. But my question is, let me describe what I think are 4 great law libraries: Yale, Harvard, Givens, the University of New Hampshire Franklin Pierce Law Library, Intellectual Property Law Library, the largest intellectual property collection in the Western Hemisphere, the Environmental Reading Room at the Vermont Law School, which is one of the great environmental law collections. And so is that what you're thinking about? Is there has to be collections like Yale and Harvard, but then other law schools that have commitments to specific areas will need to develop collections which reflect those specializations?
Absolutely, in part. So earlier today, a colleague, Sarah Sampson in Ohio, said, I was on this call talking to the different 9 libraries in Ohio, right? And we're all so different. So I think there will be those great schools like you talked about. And then there's this middle swath, right? I would add the Maritime Collection at Tulane to that. I would add University of Houston's Mexican Law Collection to that, right? And then there will be other schools who honestly just want to educate students and get them to pass the bar. And they are not going to be a part of that collegiality in the same way, but they're going to be borrowing from it and then like giving us money. And so contributing back and forth. And so that idea of sharing and having larger systems of sharing, both through formal and informal agreements, I think is pivotal to our future. How to organize it, I have no idea, but I think it's something that we need to do.
If you don't mind, I would like to just endorse the idea of collaboration and cooperatives. There is no other way for us at Duquesne to survive.
Oh, go ahead.
Can I ask a question from up here? It's not really a question. It's a comment for Paul and Donna and for Jane and Wick. I thought of this when Donna was talking about the treatises that Justice Alito was citing, and that they are all, they were to figure out what the law was as of 1868, or
even
earlier.
13th century.
Yeah, or earlier, and it would be helpful for what I'd be interested in your work is a distinction between treatises used for historical purposes and treatises if they actually use treatises to discuss what the law is now.
Yeah, I can speak to that just briefly, and that was one of the overarching things, one of the few things that we saw a trend toward, which was they weren't discussing the jurisprudence that was discussed in the treatise as to aspirationally what the law should be. There were some instances of that, but mostly it was we don't care about proportionality because Blackstone didn't say anything about proportionality, so the legislature can do what they want. Or, it was more, did it exist back then? And can we make an analogy now? But if we don't see anything analogous that existed back then it's all hands off. But we have looked at that, and thanks. we will look at that more.
Just to answer from our brief, superficial somehow look at the way treatises, they were just used to prove a point that should not be in the discussion, because around the Constitution, women didn't exist as subjects, correct? So I couldn't have a right because I didn't exist. So treatises were used to show what was a crime then, but there was no constitutional discussion. It's all very convoluted. It's almost like I'm not a midwife, like a breached delivery. It's so convoluted, but it goes to a historical evidence of the law at a time where we should not have a discussion about it. Because as Professor Hicks said, the law is for the future. I'm not talking about the law to discover how my grandparents passed their time, unless I'm doing a historical piece. But as a judge, I'm doing decision-making for the future. So it's very anachronistic, the use of treatises by the Roberts Court, and we haven't done an in-depth treatise of the way treaty of the way treatises are being used. Perhaps for our book we'll do more, but that's an excellent question, Kent. Thank you.
Paul?
I don't have anything to add. You said it all. That's why I have her.
Yeah, I don't want to. Yeah, I don't want to think about right sizing because our library is facing, I think, a big kind of crisis in terms of, because we have a space problem, which I think is going to force us to re-examine what's the right sizing for us. We're probably one of the last libraries to have to face that. So I want to just ask a simple question that I can wrap my head around for Kent. Now, I'm probably the biggest Blue Book hater that there is. And I and Julie Krishnaswamy published an article in the Minnesota Law Review about exposing deep corruption on the part of the Blue Book. But my question is simply, Kent, do you plan to let the Blue Book know about what you found and your suggestions? I know the Blue Book is, as a librarian, I know the Blue Book is very difficult to get to see reason on anything, but have you thought of sending it to them?
I haven't made any such plans. The corruption is on the part of Harvard specifically, I believe. Not the Blue Book, not the beloved Blue Book generally, but you're talking about Harvard keeping the money from the others.
I mean, that's what I mean.
Yeah, okay.
The evil Harvard.
It's a great idea. It's still still draft work, percolating its way along, but it's a great idea, but who are the, who publishes the Blue Book? Those, they're these little people that disappear every year. So,
Yeah,
so
I mean,
it's kind of hard to pin them down.
It's Harvard and Yale and Columbia and Pennsylvania, but
I know, but
Harvard
they change.
Gets 2 votes, or more than 2 votes. So they're the ones that I think are the real.
I propose that you two collaborate on this strategy.
Okay.
Do we have other questions or comments? To wrap up an amazing day.
Do you want to close up the panel? Just say.
I just want to thank our panelists very much and our hosts very much, and those who have joined us in person and from afar. We have a lot to think about. It's been terrific.
Thank you to those who joined us from home, and please feel free to contact me if you have any questions about this symposium.